Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Mistrial. Ridiculous that insanus. Ebony Parker. Pro said, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Happy Wednesday. Today is Wednesday, May 20th, 2026. And we're going to jump right into court because some interesting stuff happened in the past hour and a half. And the judge just took a break in this case to decide whether or not there's going to be a mistrial. Two of the jurors had questions. They came out. They were questioned by the judge. One of them wanted to know such things as she wanted like some clarity on whether someone had called 911, and she had some other questions of fact. And it was agreed between the attorneys that they were just going to tell the juror that she had to rely on her notes. Then a second juror came out and he indicated that he wanted to know when the judge had stricken something from the record and told them to disregard it, if they had questions in their notes about which part of it they should disregard, were they allowed to ask? And then would the judge tell them? And the way he kept saying we made it seem like he had been discussing this with other jurors. And as we know, you're not allowed to be discussing things with other jurors in the jury room because you're supposed to wait to deliberate until deliberations. And then they brought him out and asked him some more questions. And then they said something about his notebook. And he said, oh, well, I brought a notebook from home because I didn't know if you were going to give out notebooks for me to take notes. And I've had this notebook with me the whole time, but I didn't really write anything in it. And so there's now a question. Both sides have moved for a mistrial. The defense moved for a mistrial, saying they've already been discussing the case. They're not supposed to be discussing the case. And the prosecutor actually agreed. So while I was going to play that back to you, the judge just came back on the bench. So let's get into court and see what she's got to say. And then we will go back if we have to, depending on what she rules. If you are ahead, please do not spoil for those who didn't, because we were going to watch this just as a juror without listening to any of the outside the jury conversations. But because there may be a mistrial, we have to now jump into court to see what happens because we don't want to miss a thing, right? All right, we're going to have challenging issues again today with the sound. I'm going to tell you that right now. I'm going to do my best to boost and unboost and do all of the things I was doing yesterday so that we can try and hear a little bit better. They still can't seem to figure out how to mic up the judge and mic up the jury and mic up the witnesses, but we're going to do our best. And the judge has just come back from what she said was only going to be a 15-minute break. Turned out to be more like a half an hour, I'm going to say. Let's see if we can. We're going to definitely need to boost the judge. So let's see if we can get right into it. Here we go.
Okay. All right. We are ready to resume the case of Commonwealth.
Okay. She is boosted. She's booted. She's boosted. And this is my volume. Let me know how it is.
versus Parker. All parties are present in the courtroom, minus the jury. And
Okay, is that good? Are we equal? All right. I think we're okay. Here we go.
there was a mistrial motion made. The court has had an opportunity to consider it and research it. Anything else parties want to say before the court announces a ruling?
Nothing from the Commonwealth.
Just for purposes of the record, I just want to clarify the motion as it relates to juror number 38. She submitted a series of 3 questions, which again, we're arguing that helped, I believe, would aid the Commonwealth in planning out the rest of their case directly in response to her questions.
Thank you.
And that was his argument. His argument was like, okay, now the prosecution knows what the jury wants clarity on, who made the 911 call and some other questions of fact. And so now the prosecution, because the juror asked those questions outside the presence of the other jurors, the prosecution's going to know how to tailor the rest of their case. And that's not fair, Judge. And I think he's right. All right, let's see what happens.
And in response to the mistrial motion made regarding juror number 38's question, the court will deny that on the legal principle that jurors in this matter are actually the triers of fact. And under law, they can ask questions of the witnesses. Now, of course, our courts aren't set up to do that. We don't encourage it. We don't normally do that. But it is not prohibited. And all the evidence has not been presented in this case. And both sides can adjust accordingly based on those questions. But again, jurors are the trier of fact in this case, and they do have the ability to ask questions and can actually question witnesses.
That's true. They do that in Virginia. The witnesses can ask questions. However, that witness has already left the stand, as I recall. I think she asked the question about a particular witness, whether or not they called 911. And they're allowed to ask questions. They did do this outside the presence of the rest of the jurors. And so she said she had not been speaking to the other jurors about it. She just had the question for herself.
So that's the legal principle there. Regarding the motion to mistrial based upon juror number 33, asking questions of other jurors, which means discussions prior to the case being submitted to them for deliberation. The defense has moved for a mistrial. The Commonwealth has joined. The court is going to deny the motion for a mistrial, and the case will proceed. The court's rationale is as follows. The determination of whether a mistrial is warranted.
Okay, she went back and researched the law, and even though both sides agree there should be a mistrial based upon juror number 33, who said that they had been discussing things from behind the scenes about what was in their notes and what some of the witnesses had said and which part of the testimony the judge had stricken. Do you know what part of the testimony it was that we weren't supposed to consider? And the other people were saying, no, I'm not really sure. And it sounded like they were kind of comparing notes. The defense moved for a mistrial. Prosecutor agreed, said, I have to agree. And this judge is going to deny the mistrial. And here's her reasoning. She went back, she did a research. Maybe she called a couple of judge friends. And that's not what I thought was going to happen here. So here we go.
Is as follows. The court is going to deny the motion for a mistrial, and the case will proceed. The court's rationale is as follows. The determination of whether a mistrial is warranted depends on whether the juror misconduct probably resulted in prejudice to the moving party. The burden of establishing this probability of prejudice lies with the party seeking the mistrial. The standard is abuse of discretion, and to succeed on a motion for mistrial, the moving party must demonstrate a manifest probability that the misconduct was prejudicial. The allegations of juror misconduct arise, or if, the allegations of juror misconduct arise, the trial court may be required to investigate the matter to determine whether the prejudice occurred. In this case, the defense, which is the moving party, has not establish a manifest probability of prejudice. The court did investigate the juror misconduct. Again, Virginia courts have delineated between misconduct inside the jury room and outside of the jury room. In this case, this would have been not outside, such as unauthorized communications with third parties or introduction of extraneous evidence, but it was misconduct confined to inside the jury room, specifically premature discussions among jurors. And case law has indicated that that is less likely to result in a mistrial unless it demonstrably affects the fairness of the trial. And in this instance, juror number 33 had questions about procedure of the jurors, not questions of fact. And I also want to make that distinction here. In addition, Virginia.
I don't know if I agree with that. The jurors said we were trying to talk amongst ourselves to figure out what part of the testimony should be stricken. They didn't really get into the substantive issues of it. The judge did not ask, and I don't think the defense or the prosecution asked this specific juror what exactly they discussed with regard whether they discussed the testimony. We may have to go back and watch it again. But the judge in this situation has very wide latitude, and at the end of the day, it's up to the judge to determine whether or not what the jurors discussed or what the jury misconduct was and whether it was egregious enough and germane enough to prejudice the defense, because the defense did make the motion for the mistrial. The prosecution concurred. They agreed. They have to make a showing that it is so prejudicial that the defendant can't get a fair trial. And I don't know. The judge has wide latitude. Well, she's apparently researched it, and this is going to be her decision. And depending on which way this verdict goes, it wasn't just 2 jurors. He said there was 2 or 3, I believe. It doesn't matter how many. They're not supposed to discuss it at all. Oh, no, it was 2 jurors that asked questions. Yeah, you're correct. 2 jurors that came in and asked questions, but the juror who said that they were discussing the stricken testimony said he discussed it with, I think, 3 or 4 jurors. But that's all he volunteered. And so, depending on which way this verdict goes, I see an issue on appeal, but we'll keep going.
The statute does provide a mechanism for addressing juror misconduct, and that is 19.2-262.01. By the court, a legal decision. And a curative instruction can be given, and I will again bring them out and tell them that they are not to discuss the case, ask questions of each other about the case until it is submitted to them for deliberation. The case law that the court is relying on is Robertson versus Metropolitan Washington Airport Authority, Reiner versus Commonwealth, Caterpillar Tractor Company versus Holvey, and Bidet versus Commonwealth, in addition to the statute cited. All right, so with that being said, motion is denied and we're ready to move forward. Can we bring the jurors out?
Judge, I understand that the defense has an objection to the authentication of the video that the court has already considered, and that objection is going to require me to lay a foundation by showing her the video and asking her to authenticate it.
Okay, so we want to do that outside of the presence of the jury.
I think so, and we'll hear her both sides.
Mr. Rogers.
That is correct, Your Honor. Instead of bringing them out and then having to exclude them again, so we could lay the foundation and authenticate the video, I think it's for judicial economy, we should just go ahead and bring her out, follow her, authenticate the video, and then if the court believes that the authentication is proper, go ahead and present the evidence to the jury. I do have another concern, and that is at the beginning of the trial, the court ordered that all witnesses be sequestered back in the witness rooms. I think there's at least 3 rooms, and I think there's multiple witnesses in each room concerning that they maybe discussing the case, may have heard about the evidence that has been presented in the case and maybe discussing that. And so I'm concerned that the court's ruling on this question with witnesses may have been violated and is being violated.
Okay, and again, I believe there are over 20 witnesses in this case, and we don't have the physical space to give them their own separate rooms. But of course, they are sequestered, and it's on the attorneys to identify them and to instruct their subpoena witnesses as to the rules. Do you have a basis for believing that they may have discussed the case?
No, I'm just believing that's a probability, of course.
Probability just because they're sitting in the same room.
And they're
Okay, full of questions. Barbara is telling me to please keep the volume boosted because going back and forth is a bit maddening. Does anybody agree with Barbara that it's maddening for me to boost and unboost the volume depending on the mic'd up situation of the judge versus the attorneys? You want the whole thing boosted? Nope, or what? You appreciate me going back and forth. It depends if you have earbuds. It depends on if you don't have earbuds. Some people say your volume, your problem. But the problem is the attorneys are much louder than the judge. And if we keep the attorneys at a certain volume, we can't hear the judge. We went through this yesterday. I'm sorry if you're being, if I'm making you mad, but if I am, then I will just suggest to you that you can go survive over on Law and Crime or Court TV and deal with their sound. Okay, thank you.
talking, but of course I'm not in there. I don't know what they're speaking about.
All right. Without more specific information, that the court is going to deny your motion, but feel free to voir dire them regarding that when they take the stand. Okay. And Commonwealth's witness that we're going to pre-clear the testimony for evidence.
Yes, Your Honor. Nina FARRISH, Dr. FARRISH.
Okay. Bring out Nina FARRISH, please.
Okay, so we are on real time now. This is the first witness of the day. This is the criminal trial of Dr. Ebony Parker. Many of you watched the civil trial and you may be confused thinking this is a replay. This is not a replay. This is the criminal trial. There are extensive show notes that I took a long time to draft underneath the video. If you're not familiar with the case, they are all there.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Watch your step. There's a stair, and the chair and microphone are adjustable. And Ms. Ferris, we're going to take up some of your testimony outside of the question for the jury to deal with any objections and evidentiary issues. And upon the ruling, we might bring the jurors out, and then redo it. So I just want to explain to you procedurally what's happening right now. Okay.
We are also lucky enough to have closed captions today on Law and Crime. So if you can watch your screen, you will get the closed captions. They're not always correct, but it is what it is.
If the attorneys have any questions, we'll start with the combo. Yes, Mr. Roberts?
Before the video, I would like to coordinate her during the video prior to her actually speaking.
Okay, and I don't know what order Mr. Jenkins is going in. Do you want to start with the questions, Mr. Roberts?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
Okay, yes, please proceed.
Good morning. Could you please tell us your name and how you're employed?
Nina FARRISH, Human Resources Director with Newport News Public Schools.
Were you employed in that same capacity in January of 2023?
Yes.
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Richneck Elementary School that occurred on January 6, 2023?
Yes.
As part of your investigation, did you have occasion to interview numerous people?
Yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom,
Okay.
recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes.
And what was, prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
Assistant principal.
Okay. And do you see Dr. Parker in the room right now?
Yes.
Could you please just point her out for the judge?
Okay.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes.
All right. And was that was that interview conducted in person on Zoom or some other way?
Via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes.
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think does.
Good morning, how are you? Great. So regarding any video that was produced, did you keep, or were you the sole custodian of that Zoom video?
Yes.
Okay, and where was that video maintained?
On my computer.
Okay. Did anybody else have access to your computer, or was it just you?
Just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys.
When you say the attorneys, what attorneys?
The ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins at Commonwealth?
No, I'm trying to remember the name of the law firm because as I recall,
so the civil attorneys?
Mr. Jenkins was not the original attorneys.
The civil attorneys?
Correct.
Okay.
Okay, Law and Crime has also been doing a really great job with chyrons. And so they have the witness's name at the bottom and her position. This is Nina FARRISH of Human Resources. And so I'm not going to do scrolling banners today. If you need to know who's testifying, Law and Crime puts it up, but they usually put it up on a little bit of a delay. So there you go.
So have you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes.
When did you review that video?
I reviewed the copy that I still have, and I reviewed it to refresh my memory.
Okay, I want to make sure that you understand my question.
Okay.
The copy of the video that the Commonwealth has, have you reviewed that?
I'm not sure how to answer that question because if I didn't give it to the Commonwealth, I don't know which video then you're referencing.
That's right. So you did not personally give the Commonwealth attorney a copy of the video, and you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into the possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Okay. Can I have a moment, Your Honor?
Yes, sir.
For those of you who are asking, the child's mother was charged not only in state court, but also in federal court. She was charged in federal court for lying on her gun licensure application. Apparently, she said that she did not disclose that she used marijuana, I think, at some point in her life. And so she did receive a 21-month sentence in federal court for that. She pled guilty. She also pled guilty to some child endangerment charges with regard to her son being able to access the weapon. She pled guilty. The guidelines said she should have received 6 months, but she received 2 years. Those sentences were served concurrently. I don't have any receipts on it, but many of you have said that she was just released recently. And I do have some video to show you when we have a break about the mom. So the mom has been charged. She did her time. This is now they're charging the assistant principal for a failure to act on child endangerment charges. They're alleging that she knew that this 6-year-old first grader had a gun and did nothing. So far, I'm not seeing a lot of evidence of that. She's facing up to 40 years, up to 5 years for each of the 8 bullets that the child brought to school that day. And many people have many different opinions on whether or not this school administrator should have been charged. It's a very interesting case to me because I really don't know where I fall on this yet. Very conflicting. All right. The attorney and his co-counsel are currently discussing something. Yeah, she lied on the firearm application.
Okay,
And the child was being raised by his great grandfather. So she is when she pled guilty, she was 26 years old. That means she had her son when she was about 20. Her great grandfather doesn't seem very old. He's been raising the child, as far as I know.
and this recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it stored on Zoom's the Zoom app, or how is it actually how is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
I would call it the original because I've never, except when subpoenaed,
Okay.
made a copy.
Okay. And again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you.
Where'd the Commonwealth get it from?
I'll tell you what, I'm going to let Mr. Chief step in.
Good morning, Ms. Farrish. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
Well, I pressed record, but it was the Zoom platform that's recording.
Okay, so you did not actually record it with your own device or anything like that?
Yeah.
And so the actual video was something that you downloaded from Zoom or was provided to you later via Zoom, correct?
Repeat that question.
You said
This is very strange. This is co-counsel for the defense who's now getting up and asking questions. This is rarely done and it's rarely allowed. Usually it's one attorney per witness, but maybe the Commonwealth of Virginia has some weird rule that I don't know about. If you practice in Virginia, let me know. But he seems to know where the microphone is, this attorney.
I believe your testimony is that Zoom recorded it. You pressed record on the Zoom platform.
Correct.
And Zoom recorded it.
Yes.
And then you were able to, I'm assuming, download it in some way, or how did you get it onto your computer?
I have the Zoom app, so then I just reopen the recording
Mm-hmm.
and it can play for me.
Okay. Thank you.
Okay, one moment, Dr. Parrish, any further questions while here before we?
Just arguments at this particular point.
Okay, your arguments are towards the video?
Your Honor, she testified that she cannot verify the accuracy of the video that Commonwealth has. She hasn't viewed it. She's testified that she cannot verify that the whatever video the Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video. It can be run through
We know.
intelligence and alter it. She testified that she can't. She's not in a position to be able to verify that.
Do I have permission to play the video?
Yes. And Ms. Rogers, did you want to say something?
Your Honor, what I don't want to happen is that she's already testified that she cannot verify a video that's in possession of the Commonwealth is accurate. So what I don't want to happen is for her to see the video and just sign off on it without actually having to examine it ahead of time to determine its accuracy.
How did the Commonwealth attorney, how did the prosecutor not prep this witness by having her watch the video? Am I in the Twilight Zone again? I think I might be. The Commonwealth did not obtain the video, this Zoom video of, she did an independent investigation about this incident. She's human resources. She interviewed some other teachers, maybe some administrators about what happened that day on Zoom. And she says she did not give this video to the Commonwealth. She gave it to the civil attorneys. So where did the Commonwealth get this video from? If she can't authenticate it, it's a problem. If he didn't prep her with the video, it's a problem. But again, we may be in the land of the law, so I don't know if Chaka is warranted yet, but we'll see.
Judge, if I may.
You may.
The two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that.
JT
it's
is
just
the
longer
child.
and contains what I believe to be pretty irrelevant.
JT is the 6-year-old child shooter. They're not using his name. They're trying not to. They did blur it out his first name once or twice.
But I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
All right, and the 3 clips, are you able to give me a duration of each clip?
Because they are in one file,
And if you can't, that's fine. I just didn't know if you can.
the total duration of the 3 is, let me make sure before I say.
Thank you, Cupcakes for Justice, who gifted 5 memberships to the 5 lucky winners. Welcome. Thank you.
16
minutes and 36 seconds is the total duration.
Okay, thank you, Mr. Jenkins. Yes, Mr. Rogers?
Commonwealth has already admitted that the video has been altered. So with that admission, she can't vindicate it. There's been, Commonwealth would say minor alterations. But Your Honor, I'm not comfortable with just presenting clips. She needs to authenticate the whole video, and if part of it comes in, I think all of it's coming.
Okay. Do you have any authority for that position, Mr. Rogers? Because I'm unaware of the authority that if she is able to say that this is an accurate, fair and accurate representation of the interview she conducted, what authority indicates that it can't be redacted to the relevant parts and that you cannot mute sensitive information such as the names of minors involved? What authority do you have for that that makes it indefensible?
No, I don't have any authority regarding the muting or the name of a minor, but I'll just cite Baez versus Commonwealth. And I've got a copy of it before.
Okay. And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. It doesn't.
Okay, but I'm saying, you're saying if they get parts, I want the whole one. How do you wish to do that?
Your Honor, I just, I'm going to object to just a part of it because of the reports of context. If some of it comes in, I think that jury's entitled to it.
And Commonwealth, they're not objecting to that. So what I'm asking you is, how do you want that? And well, let me back up. Mr. Jenkins, how long is the entire interview?
Oh, I will have to look at that.
That's when I asked Mr. Rogers, are you asking him to play the entire interview?
Yes, ma'am, essentially.
Okay, that's what I want to know. How long is the interview?
Thank you, Sarah Be Creative, for your super sticker.
The whole video is 28 minutes and 58 seconds, I show. Let's see if that's right.
Okay, that's nice. Okay, all right. So we'll play the whole video for the jury should it meet the other notification things. Anything else, Mr. Rogers? Okay, so Mr. Jenkins, what are you prepared to play now for the witness?
Well, I can play the whole video if that's what it's going to take to authenticate it. If defense counsel would agree to let me show her a freeze frame and verify, we can do it that way.
Freeze frame?
Robert?
So I'm gonna ask that she be shown the entire video, but then when it comes down to the presentation of the evidence, then I would suggest that the Commonwealth can show clips at that point. But I want the jury to have the whole video. I want the whole video reading the evidence.
I think I understand that the defense is wanting to admit the entire video into evidence on a disc so that the jury could see the whole unedited, unredacted video and only play for the jury the clips, the 3 clips with the redactions in place. And if that is what the defense is suggesting, I do agree to do that. I think that's fine.
If the court feels that it has some problem.
Okay, all right, so, okay, we agree to proceed in that manner, except she doesn't need to watch the entire thing. Ms. Farrish, she's going to show you portions of the video and ask you questions about it. But in terms of the entire video, if at any point you say that that's not accurate, please let us know.
Your Honor.
Yes, Mr. Dixon.
Just before we start, I would note that Mr. Commonwealth has indicated that all of the 3 clips have been melded into one file, so they've been joined together, which I think obviously jump would mean that it jumps from clip to clip without the context in between. So I do believe that there may be some issues with playing just those 3 clips, especially if they're in one melded video that's combined into one file. I don't think that would be fair to Dr. Parker, because it would leave out. I'm assuming that he's jumping. Having seen this video, the splice one, it jumps. He's saying that he's joined 3 clips together into one file that plays continuously.
Okay, well, let me hear from Mr. Jenkins.
Yeah.
Judge, the 3 clips that I'm playing are melded together, so to speak, as defense counsel says. But I am happy to tell the jury, and I'm sure Your Honor may as well, that I am showing clips and that they will have in evidence the full unedited, unredacted video. And the jury can know that up front, and I see no problem with that.
Okay, and to the 3 clips, because they're spliced. In between the splicing, is it obvious on the video that this is a splice and we're going to jump forward in time and hear another portion and then we're going to jump forward in time?
It makes a small jitter or jump, it is all, but it doesn't, fade to black and come back up.
Okay, so there's some kind of visual signal that something is happening.
Admittedly, you have to be kind of watching closely because it just jitters, the people move oddly, and that's when the new clip starts.
Understood. Okay, so what is the defense motion? Because Mr. Rogers said it's okay to play it, but as long as they get the entire video for deliberations, Mr. Teague is saying play the entire video. We're talking about 12 extra minutes.
Yes, sir. I think that that's an alteration that goes beyond meeting people's names and clicking, making slices that are obvious to the jury. I just don't think that should be played.
Given that, Judge, here, I am offering that into evidence. That is what I'm offering, the clips. And the counsel is free to offer whatever they'd like. They have a copy of the video.
me just clarify something. Just because you exchange something with the defense, which you are required to do under the rules of evidence, and the prosecutors have certain duties that rise to a whole other level with regard to automatic discovery and disclosure, just because you disclose something or exchange something with the defense does not make it admissible at trial. Those are two different things. And this prosecutor seems to think that just because he turned it over makes it admissible. Should this have been a motion in limine? Maybe. Should there have been a motion to suppress prior to the trial? Maybe. I don't think the defense is being difficult. I think that the prosecutor, despite the fact that he can't authenticate it and that this witness can't even say that it's the same video that she had, because she did not give it to the prosecution. They did not get it from her. Where did they get it from? The civil attorney? We don't know if the civil attorney chopped it up to show it to the jury in the civil case. If you were not aware of what happened in the civil case, the jury came back with a $10 million verdict against Dr. Parker, the same defendant who is sitting here. The case against the school district was thrown out, I believe, because the judge decided that she was entitled to workers' comp. And if you're entitled to workers' comp, you can't sue your employer. That doesn't make it admissible. Don't get confused. Sally Port, the sequel, is what it sounds like, right?
We don't agree to admitting a spliced, altered video into evidence. We just don't.
Remember what happened with the altered video in the Karen Reed case? It was inverted, and Yuri Buchanan got up there and lied to authenticate it. He said, yes, this is a fair and accurate representation of the way the car in the Sally Port looked on a certain day, and it certainly wasn't. It was flipped, it was inverted, it was mirrored. And the defense is not going to just agree.
Give me the authority that indicates that that's not admissible. I'm not aware of it.
I tend to think that he does not have a copy of the full video, that the only one he has is spliced. That's what it sounds like to me. How do we know if the clips are in chronological order? Right.
Okay, and Mr. Rogers, what case law have you handed up?
No, this is Commonwealth, Supreme Court of Virginia, December 19th of 2024. And so I will begin, but the rule begins at, you'll see, designated paragraph 1819. That's probably like 6 pages back.
Sir?
It says, beginning with that paragraph, it says, photograph or video which is verified by the testimony of the witness as fairly representing what the witness has observed is admissible in evidence, and it need not be proved by the individual who made it. And then I'm just going to go on down. It says, if a silent witness or a witness that speaks for itself, video or photograph evidence is admissible when given an adequate foundation showing the accuracy of the process producing. Obviously, this splice video.
If this prosecutor does not stop flipping his papers directly into the microphone, he's going to kill my ears. He said they were willing to enter the full thing. However, it sounded like what I heard him say is the full thing has these like skips in it. So I don't know if they took the clips and they edited them all back together. I don't know if they've got a full uninterrupted video of these interviews that they did in their internal investigation. It's very unclear.
It's not something that she's going to be able to verify the accuracy. And so, going down to paragraph 2223, focusing the authentication clause on one street moment is two more to bear on the genuineness of the video as a whole. And then going down to paragraph 24, it says, for witnesses to affirm that a video is accurate So in terms of video,
Dude.
The other things what transpired based on the witnesses' observation. So Commonwealth has submitted this video in its form as it's in the obviously the Commonwealth is going to be presenting a video that points more to Dr. Parker's field than innocence. So in their form, it's highly prejudicial to Dr. Parker. We don't believe that just those steps should be presented as Commonwealth has a certain video prepared. Obviously, Ms. FARRISH had not seen the clips in the form, and so she can't verify that the process of how even these clips were produced.
Judge, would you like me to respond?
No, sir. So the court is going to allow the Commonwealth to play the 16-minute clips of what the relevant portions are to the Commonwealth in their perspective. Again, the evidentiary rules are about reliability. Is the thing what it purports to be as proclaimed by the proponent? Are the legal principles involved? And is it a fair and accurate representation? Once those are satisfied, it comes in. I note the defense's exception. Mr. Rogers also brought in the word prejudicial. I don't think he's laid an adequate basis for why this is prejudicial. So you may proceed with your attempt to authenticate this, and then we can get moving with the jury trial.
I was thinking the same thing. Diaco Dan Law says, I wonder if the judge is now rethinking her decision on the mistrial, right? 100%. She's like, yeah, I should have granted the mistrial, so I don't have to deal with this. She's also giving us, well, from what I was watching behind the scenes, that we weren't going to watch together, but it seems like now we have to. Things said outside the jury. She's giving everyone a lesson in evidentiary rules because she keeps reading the rules into the record. Let's keep going.
Okay, Your Honor, given the court's ruling, the video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the three different clips.
Yes, sir.
Your Honor, before we go, so there was discussion about if the video was admitted, presenting the complete unredacted copy to the jury. Was that
Is that still a defense request? And the Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. Yes, sir, you may proceed.
Thank you, Judge.
So Dr. Parker, thank you so much for joining me today.
Okay, this sounds like she's interviewing Dr. Parker on the Zoom video. Is the jury in the room? I've lost track. I don't think so. I don't think they're in the room. I think this was a proffer. When I get confused, then we're all really confused. I'm going to boost, I guess, a little bit the interview. Hopefully they'll show us the screen at Law and Crime.
I'm here to first ask if you are giving permission for me to record this session to discuss the incident that occurred in Richneck on Friday.
Yes.
Okay. So as part.
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Okay. Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview.
Mr. Rogers?
Because she watched 2 seconds of it. You can say that she's authenticated the video because he played 2 seconds of it. Okay. Okay. Dude, you should have prepped her by showing her this video during your prep session. Maybe last night. I don't know. Do you not work past 5? Come on. This audio is the worst.
She's only seen my client's face. She's verified that's violent. He's just going to ask it for purposes of identification. There's no way she can verify that this, what's on this clip, the 16-minute clip, is accurate. She has to see it.
Ms. Jenkins, if you just jump to 2 other sections, if you're able to, and play about 10 seconds and ask the same questions.
Okay, I can.
Oh,
sorry.
sorry. I'm seeing at the bottom of this screen a date and time stamp, and those are military hours. So those will move as you move your cursor?
Yes,
Okay.
Your Honor. So I can make a record of those.
Hey, Karen, I don't know if you're new here. I think you are because it's the first comment you've ever made on this channel, but racist comments are not tolerated here. I'm going to delete that comment and ask that you guide your actions accordingly. Appreciate you.
Okay, and I didn't know if that's on video or if you have another cursor mark on your laptop that's showing the different timestamps.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video. But what I believe is on here is in the date and time it was recorded.
Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
And he left. But those are the only two. Okay. So help me understand.
And Dr. Farrish, does this still seem to be your interview with Dr. Parker?
Yes.
Okay. I'll jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her.
They're trying to backdoor in statements of Dr. Parker by saying this was part of the internal investigation, but this witness can't authenticate this recording, and so could be another appellate issue. But this is Dr. Parker's interview. She's the defendant here. Dr. Parker's interview with this witness doing the internal investigation of the shooting incident. Okay, at least there's captions, but I boosted this part of the video. But he keeps jumping ahead now because he only wants to play certain statements that the defendant made, similar to the Karen Reed trial, where they took portions of her interviews that she gave to Dateline, Nightline, 2020, whoever, Boston 10, Boston 25, and played those for the jury and interspersed them throughout the trial. The entire video is going to go back with the jury. He only wants to play clips. So here, listen up if you can.
So I said, okay, she called back.
26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday. Okay, all right. So just to be clear.
And Dr. Farrish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
All right. Judge, with that, I think we've laid a sufficient foundation for authentication purposes for this video.
Yes, sir. Anything additional from the defense?
No, just to try to stress the whole point of authentication is to verify accuracy. Your Honor, it's going to be the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this record to the Commonwealth. She gave it to other attorneys. We don't know what kind of manipulation occurred in the possession of those other attorneys, or any IT professionals, any other person between the chain from Ferris, the other attorneys, and Master Commonwealth. Just showing her those very few seconds that she's not verifying the accuracy. She's verifying that essentially that's her talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that video.
Okay, so again, the defense will continue to note their objection for the record. The court, again, is going to allow this video to be played to the jury for the rulings it's previously made. But again, the defense exception is noted.
Judge, may I please request to make a quick record related to that? Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter. Yes, ma'am. All right, thank you. Yes, Mr. Jenkins.
There could be portions of this interview that have been cut out, that were cut out because it was used in the civil trial. And there are things that are, as you know, because I've told you a million times, As you know, the rules of evidence in civil court are much broader and more generous, and many more things are allowed to come in civil court just because they're relevant that would not be allowed to come in criminal court. And so the plaintiff's attorneys, I submit to you, may have spliced up this video in a way that benefited the plaintiff. The plaintiff was Abby Zwerner. She's the teacher who was shot. That was a totally different case. And so if they did splice up this Zoom interview of the human resources officer against the good doctor who's on trial here, Dr. Ebony Parker, this could be highly prejudicial. This witness hasn't even watched the video. There could be many other things that Dr. Parker said that are not going to be contained within the video. Do you see the problem here? And yet the jury's going to get to bring the whole thing backstage with them when they deliberate. And there may be portions of it that were helpful to the defense that have been cut out. And that is the problem that I am seeing here. Okay. This could be overturned on appeal if there's a conviction. I don't like this ruling. I don't like the fact that he hasn't even showed it to the witness. She might have said, oh, but wait a second. I asked her this whole other line of questioning and it's not in here. I did do my own outside research, and I found out by watching the interviews with the mom that after he smashed Ms. Werner's cell phone on the Wednesday, I think it was a Wednesday, after he smashed the cell phone, the 6-year-old student, JT, he was suspended the next day. And then it was the day after his suspension that he came back to school that he brought the gun and did the shooting. All right, back to the judge.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. It is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
Sheriff, you kindly bring the jury out, and you ask all parties to stand while the jury comes out. If you're able.
Your Honor, I'm going to step out and thank you.
Okay, we're waiting for the jury now. The jury's coming back in.
Okay, all attorneys are back in place, and we will bring the jury out. Thank you, Sheriff.
You can tell because when they stand up, that's when the jury comes in. Oh, wait a second. And look, she's got a bedazzled collar on her judge robe. Or I think the collar's underneath the robe, but it's bedazzled, and I'm here for it. I love it. I think every judge should have a little zhuzh in her outfit. The judge, Lisa Lott, in the Edric Foss case, which was in Georgia, didn't even wear a robe. She didn't even wear a robe.
Happy Wednesday to everyone. Thank you for the time. This morning. I know you've been there for about 2 hours. We were working on some motions to hopefully keep a swift pace through the day. As usual, we'll try to break around 1 and try to conclude around 5 for evidence for the day. And if you need any breaks, let me know. Now, I haven't asked the parties, the juror box as a whole, but we had that cautionary instruction not to research this case outside of what's presented to you in the courtroom, not to discuss it with others, and if somebody approaches you, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction. Again, amongst yourselves, please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. So you can talk about the weather, talk about family, but just don't talk about the case or questions amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in the Commonwealth will start their direct examination. Mr. Jenkins.
But this is the first time the jury's been in the room all morning. We're only a little bit behind, but how far behind are we? Only about 15 minutes. So the jury didn't even come into the room. Oh, and this feed is also a half an hour behind, I think, according to the media rules. But it's almost noon here on the East Coast. So here we go. This is the human resources officer who did the post-shooting investigative interviews with Dr. Parker and others.
You're on. Good morning again.
Good morning.
Would you please tell us your name and how you're employed?
Nina FARRISH, a Human Resources Director for Newport News Public Schools.
And Dr. Parrish, how long have you been in that role?
For 5 years.
Okay, I just want to test to see if you can hear the witness, because going back and forth on the boost button is a little rough. Can you hear the witness? Are we equal in sound between me, the attorney, and the witness is a little bit low, but you can still hear her? Let me know.
And so were you in that role on January 6, 2023, and in the month of January 2023?
Yes.
Do you know someone named Dr. Ebony Parker?
Yes.
And was she employed by the school system?
Yes.
How so?
As an assistant principal.
Okay. And is she in the courtroom right now?
Yes.
Could you please point her out?
Yes.
And Judge, I'd ask the record reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Richneck Elementary on January 6, 2023?
Yes.
And after that incident, were you called upon to investigate it?
Yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Richneck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes.
Did you conduct an interview with Dr. Ebony Parker?
Yes.
And technically, how was the interview done?
Via Zoom recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes.
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken. May I publish to the jury?
You may, and for the jury, defense has objected, and of course allowed that the video will be played. I don't think it requires their name.
Okay, this I will boost because I can tell you right now, I can't really hear it. This is the video of the interview.
I don't think it requires their name, but do either of the attorneys want the courtroom to be dimmed?
Not necessarily.
Okay, you may proceed.
So Dr. Parker, thank you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Richneck on Friday. Yes. Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer the questions honestly. Also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So, Dr. Parker, let's start with Friday. Were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that students reported that the student had a weapon in his backpack.
Do you remember? Go ahead.
So, Ms. Kodak, we're allowed to use names, right?
Yes, ma'am, please.
Okay, so Ms. Kodak was the one who informed.
Okay, this is super important. This is the whole case right here. Much of it. This may be, if the defendant doesn't testify, this is going to be the only time the jury hears from her. And this was during the HR interview, post-incident interview. She said that she was told that other students reported that he had a gun. Listen to that again. Were you given any knowledge prior to the incident, prior to the actual shooting, that the student had a weapon? Hear that again.
The actual shooting that the student were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that students reported that the student had a weapon in his backpack.
Do you remember? Go ahead.
So, Ms. Kodak, we're allowed to use names, right?
Yes, ma'am, please.
Okay, so Ms. Kodak was the one who informed me of this. And she said that she had already asked the student, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside to recess. So I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter growth assessment, printing off tickets and such. So I didn't go into the classroom with her when she came.
Okay, this is so important. We're going to play it twice. This is 3 days after the shooting. The shooting was January 6th, 2023. This was January 9th, 2023. And it seems like everyone was so focused on state testing. I think state testing may be the bane of many teachers' existence. You can tell me if you're a teacher in the chat. We have a lot of them. She was so focused on the state testing. She was going to wait until recess to look in the backpack then? Hold on a second.
Recess. So I said, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside to recess. So I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter growth assessment, printing off tickets and such. So I didn't go into the classroom with her. When she came back, she says, there's nothing, I didn't see anything in his backpack. And I said, okay. And she says, but, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So, I don't know if she went outside or not, but there was a comment that said, well, we watched him closely. Assuming she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of
So Ms. Kovac, who we watched testify yesterday, told her students reported that he may have a weapon in his backpack. They're going to recess. Ms. Kovac checks the backpack and comes back and reports to her there was no weapon in the backpack. And so she thinks that that's been done. And then she says, well, what about in the pockets? And I guess, well, this is a statement by a party defendant. So it's not hearsay because it's a statement by a party defendant. Good question though. Call me Murdoch. And is it foreseeable that a 6-year-old might have a gun in his pocket? I don't know. You'd have to ask the teachers. And that's going to be a question for the jury.
That conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you, the students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between them, but I know from the time that she said it to the time that they went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at one. That was at
Miss Foster's the principal, so she did not report it to the principal.
the meeting was at 1, and I didn't make it into that meeting, but because I was in the midst of testing, I don't leave my office when we're in testing to maintain, the testing tickets and the security of that. And so I had not spoken with Ms. Foster.
Okay.
Miss Foster's the
So
principal.
can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So, after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask, should we check his backpack? Do we check his backpack? Mr.
So she's essentially saying that she gave permission for Ms. Kovac to search the backpack. Remember in opening and in other parts of this trial, we've heard that the only people who are allowed to search are the principal, the assistant principal, who's the defendant, and the security officer or the school resource officer or whatever they're calling that person in this trial. But we also learned that there was not one in the building at this time because they share a school resource officer with another school. And so she's saying that she told Ms. Kovac she could go and search the backpack.
Rawls, after that situation was settled, came back into my office and he said, "Hey, did you hear what they said about?" I said, "Yeah, I heard." I said, "But we checked his backpack." And again, I'm still using we, but it was Miss Kovac. I said, "His backpack was checked. We didn't see anything." And he says, "Oh, okay. Did you check the person?" And I said, "Ooh, no, we didn't." And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and then she can, we'll let her go through the rest of his things and check it. He nodded his head and he left. But those were the only two.
Okay. So.
And again, this is a slam dunk civil case, and it was a slam dunk civil case. Was she negligent in not then, leaving the state testing for a couple of minutes to go check and see if this kid had anything in his pocket, the 6-year-old? 100%. That's why they got a $10 million verdict against her in civil court. She was negligent. She owed a duty to the students to keep them safe. She breached that duty by failing to go and search his person. The breach of that duty was the cause of the shooting, and the cause of the shooting caused damages to Abby Zwerner. That's a slam dunk civil case. Duty, breach, causation, damages. That's negligence in a nutshell. But does it rise to the level of criminal charges? This is a different burden. In his opening, the prosecutor said in this case, the victim was not Abby Zwerner. The victims were the other children in the classroom who could have potentially been shot. This is a very different case. 100% she was negligent. 100%. $10 million negligent. But does it rise to the level of 40 years in prison? That's what we're here to determine. And I don't know the answer to that. Thank God it's up to a jury, because I wouldn't want to decide this case, because we just heard her outright say she was going to wait for the mom to get there. And so the mom could search his stuff and his person. Okay, let's keep going.
Help me understand, what is your understanding of what should have taken place from the first notification that you received about the student from Ms. Kovac possibly having a weapon?
What we did, in previous times before, we had 2 other students who also were reported to have a weapon. And we, asked the student, if you have something that say, no, we do have someone else come in with us to look in their backpack. But we never searched a student. So because we didn't, Ms. Clark didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day, and we have a conversation every day. So I was waiting for mom to come in.
So in the past protocols of what you've done, and correct me if I'm wrong, you've brought the student into your office, and you, along with who else?
So the first time it was Mr. Rawls, and then the second time it was an incident of a parent had already called the police because the report was given to her from her son, so she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Ms. Zwerner on that Friday come to you and express concern about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Zwerner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, oh, okay. And then she left. So I told Ms. Kovac, because they were going to go down as the kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Ms. Zwerner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't say that to me.
And she's crying during this interview, and it looks to me like they're genuine tears. This is 3 days after the shooting, and she probably wishes that she did things differently. But she said that Abby Zwerner came in, and we heard Abby Zwerner testify yesterday. She said that he was being defiant that day, that he gave a challenging look to somebody in the cafeteria. I think there was at lunch, I think there was a school resource officer there, and then they left. That he was staring down the security officer, or I forget what exactly the position was that they referred to this person as, and that he looked defiant, and that she said to the assistant principal that he was in a violent mood. But the assistant principal says that she said he was being defiant, and if he hits me, I don't know what I'm going to do. And then she's saying she did give the option that if you feel that it's necessary, we can call the mom and have her come in early because he was on some sort of a special plan. I'm not really sure what it was, but I think the mother did have to come into the school every day and sit with him at some point in the classroom. I don't think they've testified about that yet in this trial, but she seems genuine to me. I think this particular video may be a good one for the jury to see, especially if she doesn't testify, because it humanizes her. She's crying. She probably wishes she did things differently. Hindsight is always 20/20. And she seems like a nice woman. I don't know her personally, but she seems like a nice woman. And sometimes horrible things happen to nice people. And we all make mistakes. And in hindsight is always 20/20. Does this woman deserve 40 years in prison? Because this child got a weapon from his house that was legally owned by his mother, who is 6 years old. His mother has served her time. That's another thing that I want to know. Is the jury going to find out that the mom pled guilty and has spent almost 4 years in jail on federal charges and state charges? Or are they going to think to themselves, listen, somebody's got to pay for this. Somebody's got to pay. Somebody's got to go to jail. So we might as well put her in jail because she's the one who's sitting in front of us right now. She's the one in the defendant's chair. Is the jury going to hear that the mom did face ramifications? I hope so. And so do you think she deserves prison at all? As teachers in the chat, I know there are a lot of you as schools administrators in the chat, you do the best you can do every single day. And every single day, unfortunately, school administrators and teachers are faced with not always life and death situations, but they're put in some really dangerous situations. We read something yesterday about this particular Newport News, Virginia school district where the children are assaulting teachers on the regular. And this is outrageous, and the students should not have to, and the teachers and the administrators should not have to deal with any of this nonsense, any of it. But does it rise to the level of putting this assistant principal in prison? I don't know. I'm starting to have a problem with this. I think I'm starting to lean toward one side, especially now that I've heard her speak and I've seen her emotion. All right. So I'm going to take this back a little bit so you can see her kind of break down. And this may be good for the jury to see. You can please let me know what you think. I'm open to all theories on this case and all of your opinions because I really, really just don't know.
Never came to me and said anything about her feeling that the student had a weapon or that she felt unsafe. She didn't say that to me.
Okay, all right, take your time. Had Ms. Zwerner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
No, so has been on a modified schedule since the beginning of the year. His acting out was he's extremely defiant, and he does the exact opposite of what he's asked to do.
Now she's talking about the particular student. They've blurted out, they've muted his name, which is good. They've been referring to him by the initials JT. And now she is talking about the student. So let's take it back. Teaching is hard. Being a school administrator is hard. I'll tell you what, I wouldn't want that job. It's hard.
Out was he's extremely defiant. His acting out was he's extremely defiant, and he does the exact opposite of what he's asked to do. And it was making it difficult for her to do instruction in the classroom. So we sat down and we made a modified schedule. We had things in place. So somebody was getting the bus. He was going to Miss McBurnett's room to do a social story. He was then transitioned to Miss Kovac for a 15, 20-minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office, and he said no. Ms. Zwerner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated the meeting that afternoon with Ms. We told, hey, you don't know the damage that it is to the teacher's phone. We'll let you know. She understood that she was prepared to pay for it and everything.
The mother.
So, in hindsight, that evening, I spoke with Ms. Foster and she said, I really think I'm gonna call mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Zwerner have a report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do. Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Miss West. And what Miss West reported to Miss Newton was that he was like pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that was what was reported Wednesday, that's where I think that came from.
Okay. Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. Prior to Friday, had anyone, Ms. Zwerner or anyone reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So staff stating that administration knew, what is your response?
Your Honor, could we pause the video?
Yes, we can pause. Yes, sir.
Can I have just a moment to talk with counsel, then I think I have an objection.
I just want to rewind 1 second to hear what they were talking about. Hold on.
Knew. What is your response? Stating that, so staff stating that administration knew, what is your response?
Your Honor, could we pause the video?
Yes, we can pause.
Staff saying that administration knew. What's your response to that?
Counsel, then I think I have an objection.
A brief moment.
She's only going to give him a brief moment to discuss with co-counsel.
That are being part of, there's a lot of, there's a lot of, I'll say hearsay statements that are being propounded by Ms. Ferris, things that other people may have said. And so I understand the video is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Ferris, I would submit to the court that I believe those are hearsay. Any statements that she is alleging was made or declared by another party, I would submit this hearsay, and I would ask the court to instruct the jury not to consider statements of Ms. FARRISH or what somebody else may have said, but only consider my client's responses to those questions.
Judge, I would ask that we continue playing the video for now and make a decision about whether there needs to be some sort of curative instruction after that.
So I will, again, continue to play the video, but I will grant defense motion that will be a curative instruction. So we'll prepare that when it's time for instructions. Whose testimony they can consider from this video and the hearsay. All right, you may speak, Mr. James.
The jury is already confused because of what they came in and said this morning about they don't know which portions of testimony they're supposed to be striking. And the judge said, well, you're just going to have to rely on your memory. This trial's kind of a mess so far, in my opinion.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
Yes, sir.
Administration.
No, don't spoil it.
What is your response to that?
I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Zwerner, was asking for. Like, just I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Zwerner were reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear.
Don't spoil it. Somebody put in the chat that there were special reasons why they were treating this specific student a certain way. I don't want the chat to know about it unless it comes into the trial. We were trying to watch this trial in a very different way and only watch the testimony and only what the jurors were seeing. That turned out differently today when the jury wasn't in the room for the first 2 hours. But I only want me and everyone else here to be considering what the jury is actually seeing. So if you did watch the civil trial, you're going to know a lot more about this case than the jurors in this case, criminal case, are. So we're going to try and keep it to that for now. And maybe after the trial's over, we can talk about all that stuff. He doesn't follow directions. He won't sit in his seat. He's being defiant. I mean, back in the day, elementary school in the 70s, there wasn't even an ADD diagnosis for that. It was just a typical 6-year-old, right? Or 5-year-old. So we're not learning any more than that as of this point. He may have had more serious issues, but we don't know. They're not telling us.
Ms. Kovac, check the bag. What is Ms. Kovac's title?
She's our reading specialist.
So help me understand why Ms. Kovac why did you direct Ms. Kovac to check the bag?
So in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay. Did you talk to your resource officer that day?
She was not there.
Okay.
The resource officer, the actual, I didn't call, I didn't call. And our security officer, Ms. Lee, she leaves every day at 2:00.
She leaves at 2, so Ms. Lee was.
I mean, I'm sorry, not 2 o'clock, 12 o'clock. And she comes back after McIntosh's dismissal for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay.
There it is. So the school resource officer was not present during that time. She went to another school and then she comes back. So during the specific time that this happened, there was no school resource officer in the building. It's all about the state testing. Jeff, you seem to have a lot of very strong opinions on this case. He says she didn't want to leave the office because she was lazy. Also, state testing. Teachers in the chat, are you allowed to leave the room during state testing? I don't know. I'm asking you guys.
All right.
Dr. FARRISH, was what you just watched a fair and accurate depiction of some clips of a longer interview that you did with Dr. Parker?
Yes.
Judge, at this time, I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker that contains the clips that have just been shown to the jury. I would move to enter that as Commonwealth's 2.
I so introduced over defense's previous objections, which were made, considering being marked as Commonwealth 2.
And Judge, at some point I will need to take a moment to get the full and complete video saved to a drive, and at that time I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor.
Oh, for the love of the traveling Mary, sir, please move your stuff away from the mic. All of the teachers in the chat are saying absolutely not. You're never allowed to leave the room during state testing. And people are saying she didn't look up from her desk at Abby Zwerner when she came in. That has not come into this trial yet. The prosecutor did say that in his opening, but it hasn't come out yet in this trial. You may have remembered that from the civil trial if you watch that. Soap says, even if we assume her lazy and even incompetent, is that criminal? Should that be criminally charged? Remember the $10 million verdict in the civil case against her. Here we go.
Dr. FARRISH, do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes.
And you do that for the school district?
Yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes.
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year?
Yes.
Do you have that document with you today on the stand?
I did.
Would you mind pulling it out? And did you bring that with you today?
Yes.
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Okay.
Yes, what's the objection?
Dr. Foundation, Your Honor. Ms. Ferris is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not made that the proper foundation has not been made.
The court has already ruled on that. It is
We ruled on hearsay, we didn't rule on foundation.
Okay. Well, she has testified that On hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is in fact an authentic record of the Newport News Public Schools. She brought it with her here today herself, and that it was in effect on the time in question. So that's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Yes, Your Honor. So thank you, Dr. Farrish. This is page 28, a paragraph that begins, principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Richneck Elementary Multi-Hazard Crisis and Emergency Management?
Let's listen to that again, because I was dealing with something else on my phone involving family. So wait, so any staff could have searched a student? Let's take it back and listen to that school policy again, because I have other questions too. If there was school testing that day, couldn't they have made arrangements to make sure there was a school resource officer in the building at all times, being that the teachers were not allowed to leave their classrooms, and or if the assistant principal was overseeing the state testing, she was not allowed to leave. Why didn't they make arrangements to make sure there was another school resource officer in the building at that time? This is leading to more questions. I have more questions now than I had before. Here we go. They're allowing this in, the policies and procedures. They had an argument about this morning as well.
Security officers, under the direction of a...
So thank you, Dr. Farrish. This is page 28, a paragraph that begins, principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you.
I mean, it didn't really say any staff. I think it was personnel, like the personnel that they had specifically stated, which was administrative principals, assistant principals. But it seems like, based on the interview that we watched, Dr. Parker gave Ms. Kovac the authority to search his backpack.
Now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
do you have with you, or have you brought with you to court here today, the Richneck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay, please give me just a moment. I'd like to direct your attention to page 18.
Yeah, I'm going to request some idea on this, on the, her foundation of knowledge regarding this particular document.
Okay,
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room, because admissibility is not a factor for them.
Mr. David,
Yes, sir.
and what's the basis for this again?
I don't think the proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not gonna allow this one here at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Farrish, let's back up. Is the multi-hazard crisis plan for 2022-2023 required by law to be created by the schools?
That is my understanding.
Okay, and are the plans records of the schools?
Yes.
Official records?
Yes.
Okay. And is what you've brought here today an official record of the school that was in effect at Richneck on 2022-2023 school year?
Yes.
That,
Foundation established, you may proceed. Objection is overruled.
so I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes.
18. And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
Yes.
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
Okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
I'm sorry, I need to pull that up.
10 seconds.
I'll provide it, Judge.
Thank you. All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression or has attempted to carry out threats in the past. Is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Parrish. I'm going to direct our attention to this one.
Okay. Okay. This is the crisis management plan for the district. Okay. The objection to this morning, we're just going to talk a little bit about what happened outside the jury because I think this is an important distinction. The objection by the defense was it's going to confuse the jury if you allow this crisis management plan in because the defendant failing to abide by the crisis management plan is not a crime. And so if the jury hears the crisis management plan and they start thinking about all the ways that this administrator, the defendant, may or may not have adhered to the crisis management plan enacted by the district, they may confuse that with criminal liability. And I think that's a good point because there are a lot of people out there. The average juror is not like one of you in the chat who watches trials all the time, and you can make the distinction between a criminal act and this policy. And so is the admission of this policy more prejudicial to the defendant than probative of whether or not the defendant committed the crime of child endangerment? Something for you to toss around there in the chat because I see you guys having a lot of discussions about this. Thank you, Court 62755. Being here for 7 months, allegedly 5. Thanks for your 5. Says my husband's a school resource officer. He said that teacher or aide didn't need to search the bag, just immediately take the bag to the principal's office would have been avoided. No, because what had happened was the bag was searched by Miss Kovac and it wasn't in the bag. It was in the child's coat or pocket. It was on the person of the child. But yes, I could see how in a regular situation, if it was in the backpack, that could have been avoided. Problem was, that was when they were at recess and he already had it on him, apparently. Linda Loves Trial says, I watched the civil suit. I see how after watching that, but who knows if the same evidence will be let in? No, 100% no. Lori, covered the civil suit, right? I think that was all the way back in November of 2025, correct? Freeze frame. I think in song lyrics. So thank you for that, Veery Cat. As a side note, because we go on side notes here and side hustles and whatever, I saw a video this morning of David Byrne burning down the house. I don't know if it was last night on the Stephen Colbert show with a bunch of his musicians. They do like this interpretive dance and drum sort of thing that I totally love. And they're wearing like Blue Man Group suits, like blue like onesies, like gas station attendants used to wear back in the day. And Stephen Colbert at the end put on one of those suits and came out and was dancing with the band. It was great. It was wild. Look for it. If you're interested in it, I'll link the video in the show notes below. I can't play it because of the music, but did anybody see that? Burning down the house with David Byrne on Stephen Colbert. I love it. I love it because I love the Talking Heads and it was awesome. Check it out. Okay, next on top. Thank you so much for your super sticker. You're always an amazing contributor to the channel. I appreciate you so much. The Stay Hot podcast says, thanks for replying to my email. I appreciate you covering the case. This case interests me, a public educator in Kentucky. Thank you for tuning in from Kentucky and for your 5. And Overruled Sit Down says, I'm sorry, but it seems like there was a lot of people that failed this school. Right. And when I say slippery slope, I'm like, somebody said, what does that mean, slippery slope? Or what are you talking about? This person has to be responsible. Well, okay, then you should charge everyone else in the chain of command. Right? Well, why didn't Miss Kovac call 911? She should have done something too. She's the one who actually searched the backpack. She's the one who was texting with Ms. Zwerner about what the kids were doing outside and how they, went behind the rock wall and didn't come out. Are we going to charge Miss Kovac too? Are we going to go so far as to charge Miss Zwerner and to say that she should have done something? Or is everyone going to say, it's not my problem, I'm not allowed to do something, you got to charge the assistant principal? Like, where does it end? I think the Crumbleys were the first parents in our United States of America who were charged with the school shooting of their son. And following that, now there's the great case in Georgia, Colt Gray. Did that even go to trial yet? I don't know. I have too many cases in my head. And so it does become a slippery slope. This mother, in this case, for the 6-year-old, has served her time, and she has been punished. And that's a great point. Mr. Junior Wedge says, this case reminded me of an event 30 years distant. A high school teen, Amber Zajac, was raped and killed by Kevin Painter August 7th, 1995. He was arrested 5 months later while at work. I knew her and worked with him. Thank you very much. I don't know how this case reminded you of that case, but thank you for your 10 for telling me about it. I appreciate you so much. Karen DePasquale gifted 5 memberships to all of you who were gifted memberships. Welcome. I think you're going to like it here. So my question that I had just mentioned before I went off on my tangent was, do you think that the introduction of that school policy is going to confuse the jury? All right. A lot of split decisions on this. Colt Gray's father was convicted. Okay. So, but has Colt Gray, I know you're in Georgia Law Mama 4. I love you so much. Did Colt Gray have his trial? Wait, is Colt Gray the dad? Who's the son? Was the son also tried? Can't keep up. So Colt Gray's father was convicted. So the father was convicted. I don't know if the son was ever tried yet. I think the father was tried. The dad, Colin, went to trial and he was found guilty. Colin, the son, hasn't gone to trial yet. Okay. Thank you. Thank you, Dizzy OD. So now look what we're doing now. We're having the parents of the child being prosecuted and going to trial before the actual shooter in some cases. Wild. How old is Colt Gray? This kid is 6. Apparently there was no ramifications for the child. I think that the child maybe went to a state hospital for some evaluation, but they were not charging this child in this case because they said he didn't understand the legal system. He's too young. He's 15 now. Okay. All right. He's 15 now. They haven't tried him yet. You're talking about Colt Gray in Georgia. We saw Carly Gregg, 14 years old, tried as an adult in Mississippi and convicted of shooting her mother, killing her mother, shooting her stepfather. He survived, and she is serving life without ever having the possibility of parole in Mississippi. The appellate arguments are going to be next week on Carly Gregg. We will cover that. All right. Just things to think about as we do. And now back to the prosecutor.
One more section of that. Thank you, Dr. Farrish. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading Weapons Threat?
Yes.
I'm just going to ask you to read only that section that falls under the heading Weapons Threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon. Evacuate the area. Evaluate the perpetrator, evaluate the perpetrator. Isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Ferris. That's all the questions that I have for you. Please answer any questions from Defense Counsel.
This will now be cross, and I'm sure he'll need a boost. We've only seen the back of the defendant's head throughout this trial. The camera is in such a position, the pool camera, that it has not captured the defendant's face at all, and it never captures the attorneys hardly from the front. It's a weird positioning of the camera, but that's all we got.
You may.
We have a sigh emoji for that.
Still morning. Good morning again. All right, a lot to unpack. So just to go over again, you are the HR director for Newport News Public Schools, and you conducted an independent investigation of this whole incident. Is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that?
Objection. This goes beyond the scope of the direct exam, and is also asking about the investigation and other things that I didn't go into.
It was elicited on direct. That's one of the first things that she testified to, is that was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I was trying to figure out where the scope of objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, Ron.
And what part was your scope of objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
Dude, you opened the door on this. This is your witness. You're having her testify about her Zoom interviews and her investigation. I'm sorry, but he opened the door. Wait a second. Thought I paused it, but I just muted it. Hold on.
The findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all, Your Honor.
All right, okay, but if you plan to get there, I think he's going to object.
Well, we'll see what happens as we go along.
All right, you may proceed.
Okay, so you did conduct a complete investigation of this from the beginning of the incident to the end. Is that correct?
Correct.
Okay, and as a part of your investigation, did you do the videos that may have been taken, produced on Newport News School System's surveillance cameras?
Yes.
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
Not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Richneck Elementary School?
You want me to describe? You're not asking me how many.
I'm asking you how many. How many different positions, sir? Is it?
I don't recall how many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Richneck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways
Yes.
Objection, Judge. We're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
Response?
I don't think I'm required to show anything. She's testifying, she's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response?
Your Honor, she's testifying as to what she observed. So, she looked at videos, she's testifying as to what she observed on these videos. So I'm not asking to introduce these videos, I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on those videos?
She is probably, I'm going to ask her to summarize what she saw in these videos, yes.
How is that admissible?
How is it admissible is something that she observed. I mean, she can testify as to what she observed.
Okay, so that goes back to his objection. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if the video is not admissible, how can she testify as to what she saw on the video? How would that also be, by analogy, admissible?
Your Honor, obviously we have already submitted video into evidence.
Well, one video. Are you talking about that video or a different video?
No, I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events that they record. If I had the videos, I can, I guess I can ask the court to take a recess so I can show her several videos that the Commonwealth just released.
Okay, 2 questions, or I guess 1 rule. Yes, she cannot testify to what she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming in through the Commonwealth's case in chief.
I understand. Is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay. So again, my ruling is that she cannot testify as to what she observed on the video. I sustain Commonwealth's objection. Next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object it, and the court can rule.
Yes, sir. And again, to the attorneys, I know that there's been a lot of objections, and there were a lot of objections yesterday, and squirrels all over. And sometimes I might be grumpy, but I'm not grumpy at the attorneys, and they are doing their job, so don't hold that against them.
Squirrels?
That's a cautionary instruction in the beginning. It is their duty to object, to make sure the rules are followed, and we analyze the rules of evidence. Okay, you may proceed, Mr. Rogers.
Okay, other than Dr. Parker, were you able to determine the conduct of any other employees that were at Richneck Elementary on January 6th?
Okay, and don't answer. So your question was, she able to observe, determine?
Observe the conduct, behavior of other parties, other staff members at Richneck Elementary School.
Okay, and in reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
Authentication that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not produced. It's the same objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. If the court believes that she should not be able to testify as to what she observed by video, then I'm prohibited.
So I sustain the objection because it's the same thing we just discussed.
Right.
Again, if it can't come in through the front door, it cannot come in through the back door. Next question.
First cowgirl. Apparently they don't do sidebars here. I don't think we've seen a sidebar yet, have we? They've done some stuff outside the presence of the jury, but.
Go to the, let me first talk about you being a custodian of records. Have you testified as a custodian of records for Newport News Public Schools previously?
Yes,
Okay. And so you're the custodian of this document, is that correct?
correct.
Okay. All right. If you'll turn to page 17.
For those of you asking, why doesn't he just put it on in his case or introduce the video during his case? He doesn't have to put on a case, right? Law Mama 4? I don't understand why he can't introduce the video now with this witness if he wants to. He's not required to put on a case, but he is required to do a thorough cross-examination of these witnesses. I don't know. I'm in the upside down again.
Of this document?
Yes, sir.
Okay, it's tops, I guess about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive students in the classroom. Could you read that first paragraph, please?
Under the disruptive students,
Yes, ma'am.
the code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provision.
Does she sound like a robot voice or is it just me? I thought he meant he doesn't have the video queued up, but it is surveillance video in the case that has been turned over to him in discovery. That's what I got from that. That he doesn't have it queued up right now, but he's got it somewhere. She sounds like a robot voice.
Provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents should be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay. So would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection, that's improper opinion testimony. She's not been qualified as an expert to answer that.
Response.
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is,
right,
but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes.
Okay. Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge, this is getting into the findings of her investigation now,
Okay.
which is the province of the jury to decide.
No.
And your response.
Your Honor, I'll submit that to you. I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I ask her to determine if something actually occurred or did not occur. That's not a finding.
Okay. So again, legal conclusions are a problem for the jury, but how is the finding of this school investigation not come, well, how is that not relevant and admissible?
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Farrish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it, and over the Commonwealth's objection, the court's rationale is the Commonwealth has introduced the school handbook, the policies, procedures, and the crisis management. And there's been a lot of evidence and questions towards was that followed on that day. So that's a proper subject for cross-examination. And what the school found in all the school policies can come into evidence. We can have a curative instruction later if parties want that the school findings are not legal findings and legal conclusions for this case. And that is for the fact Congress, and that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So if that's the court's basis, I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. So Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
Correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Zwerner. So I meant Zwerner. Could you answer the question in regards to Mrs. Zwerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive, she could have removed him from the classroom. Is that correct?
Correct.
Okay. If Ms. West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right. So regarding the multi-hazard crisis and emergency management plan, this is a plan for each individual school. Is that correct?
Correct.
Okay. And are you who's responsible for producing this document, if you know?
That would come under our safety security department.
Okay. Prior to this incident happening, were you familiar with this document?
I know that the schools have them, if you're asking if I'm familiar with this particular one prior to that incident, no.
Okay. And so you have become familiar with this document since this incident has occurred. Is that correct?
Correct. And when you say familiar, again, the custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
Through the entire document, no.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay.
Girl, you are HR, and you're telling the world that the only time you ever read this policy was in preparation for the civil trial of Zwerner versus Ebony Parker. I don't know. Is it just me, or should HR be fully familiar with the policies and procedures of the school? What? Oh, man.
Would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes.
Okay, so this document would also apply to the teachers in the classroom. Is that correct?
Correct.
It would have applied to Ms. Kovac as a reading specialist. Is that correct?
Correct.
Mr. Rawls in his position. Is that correct?
Yes.
All right. And so based on these two documents, was there anything in these two documents that prevented Ms. Zwerner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No.
Okay. Is there anything in these two documents that prevented any of those four individuals, Zwerner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
No.
So I'm going to actually go to the page 60 in the multi-hazard crisis and emergency management plan, which the Commonwealth directed you to.
Speak up for me, Mr. Ross.
Okay. Did you hear what I said so far?
I heard you say you were going to go to page 60.
That's correct. Okay. And even when he directed you specifically to a weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Wait, say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, judge calls for an opinion.
Response?
Your Honor, this is the policies and procedures of the school. She's here as an agent of Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can ask you what does the manual say, but your question was whether or not it was applied or followed in the circumstance. So I'm going to sustain the objection.
Okay. So I'm going to ask it in a different way, if I may. Ms. Zwerner, Ms. Kovac, Ms. West, and Mr. Rawls, was it their responsibility to follow these procedures?
Objection, same objection. He's asking for an opinion of whether they should have followed certain procedures.
All right, well,
of them or few of them.
Response?
I can rephrase it to make it more clear, I guess. Are they obligated to follow these procedures? And I let him say this objection.
Okay, do you object to that phrasing?
It's been asked and answered, but I don't object.
Oh, you may proceed. With that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those four individuals, if they believe that there was a weapon, they should have.
Objection, judge. This isn't the question that the court. He proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about that.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
State your question.
Was it their responsibilities when presented
Was
with?
it whose responsibility?
Ms. Zwerner.
That's the same question, yes, that I sustain objection to. Next question.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Little room to scooch while they converse among themselves, the defense team.
Ms. Ferris, Dr. Ferris, are you Are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
Okay. Ronna, I'm going to relinquish this witness to my colleague.
To your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Thank you, Your Honor.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have any authority that says they cannot. Understood.
That's interesting. I said that earlier. I said it's unusual for a defense team to tag team on the same witness. Usually, well, I believe Judge Cannoni made the rule that one attorney per witness. Whoever's directing the witness has to be the only one objecting. They can't be tag teaming like this, but this judge doesn't seem to have a problem with it, even despite the objection from the prosecutor.
And I think you got something, Mr. T.
Oh, thank you.
I mean, it's definitely helpful.
Good morning again, Miss Farrish. Are you
Oh, he knows where the mic is, so I got on boosted now.
Dr. or Miss Farrish?
Doctor.
Dr. Farrish. You were shown a video of about 16 minutes earlier during your testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting at certain sections.
Okay. So are you aware that the entire video is 28 minutes or 28 or 29 minutes?
Based upon the timeline I saw.
Okay. And you were shown about 16 or 17 minutes, correct?
Yes, as I recall.
And is it your understanding that the video clip that you were shown contains 3 different clips joined together?
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets, it's the whole video.
Okay. So I'm gonna pull up the video, the actual video, the whole video.
Judge, I'm going to object to this. I don't know what the relevance of this is.
Okay. And I'll give him a moment to respond to relevance.
I'm going to ask the council not put that up on the screen until we've addressed
That's fine.
Okay.
This prosecutor sounds like he's scolding a child as he puts his finger up and he goes, I'm going to ask that he not put that up on the screen until we're allowed to talk about it. I don't know. He sounds, I don't know. He sounds a little patronizing the way he speaks to everyone in court. Am I overreacting? Could be. I've only seen the back of his head, so I really don't know. I can't see his facial expressions, but if you ever wag your finger at me, I'm not going to be happy about it. Listen to that again, just for funsies. This is not a trial. We've had a lot of laughs. We usually try and laugh a little bit or we're going to cry, but try and say something funny. And if you need a break, go watch the David Byrne video from Stephen Colbert playing Burning Down the House. I think it was just posted today. So I don't know if it happened last night or whenever, but it's a really good watch. If you like music, if you like the Talking Heads, if you like David Byrne, I loved it. And so a couple of you have jumped off to watch it. I'll allow it. Just come back when you're done.
I'm going to ask the council not put that up on the screen until we've addressed.
That's fine.
Okay, he's objecting to relevance. What is defense response?
It's relevant. The witness has testified that she does not believe that the video has been cut up and, certain parts edited out.
Say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Okay, and what are you purporting to introduce and under what legal admissibility rule?
So best evidence rule, the Commonwealth has spliced the video, and he's cut out and skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Okay, and we agreed that the jury would get the whole video for deliberations. So your objection, and what you're gonna play is a part of this whole video?
Yes.
Okay, and so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and that the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has, which they can certainly introduce evidence in their case, but this is still the Commonwealth's case.
So
They don't have to put on a case. What am I missing here? Are there any Virginia attorneys in here? I'm sorry. They don't have to put on a case. You've already introduced this entire video into evidence. The jury can bring it back. But if he wants to play another portion of that video while this witness is on the stand, doesn't he have the right to put on a defense and do that? I mean, what? I don't understand. If I'm confused, we're all confused. But what's to lose? You can call this song the United States Blues. Yes, the false prosecutors, Larry, were much worse than this guy. Agreed. You know who is even worse than they were the evil stepsisters in the Ashley Benefield trial in Florida. Do you remember them? Did you watch that trial with me? They were whack.
the legal principle here, when we start with my ruling, I'm going to allow it in over the Commonwealth's objection. The basis being, if the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth, the opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not legally sustainable principle, does not comply with case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's the court's basis. You may proceed, Mr. G.
Thank you, Your Honor.
What's in this video that the Commonwealth thinks is really, really bad for their case? The rule of completeness. Thank you, Danny Conley. Sometimes I just can't find the words. It's like, part of my early onset self-diagnosed ADHD. What's in this video that you don't want us to see or the jury to see, despite the fact that you've entered the whole entire thing into evidence? How many trials have we watched recently where the defense did not put on a case at all? They don't have to. They can sit back and do nothing and rest after the prosecution's case. Brian Walsh is one. Edric Faust is another. We've watched many, many cases where the defense did not put on a case at all, and that's their right to do that. So why is it that this attorney is not allowed to play portions of the video that's already been introduced into evidence by the prosecution and question the witness on it? It's wild. I know, I'm twitching already over here, Law Mama 4. Okay, here we go.
And Dr.
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Understood.
Okay,
So-
the whole name, not initials.
Correct. The
Okay,
whole
but
name.
how are we dealing with that, Mr. G?
Oh, so they didn't redact the entire video that they wanted in evidence, only the portions that they wanted to play in court. See? Yeah, I see.
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid
We're
it.
talking about, again, audio and press coverage to the world.
I understand.
So
Yeah.
you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay. You may
But just to be safe, I'll just try to elicit the testimony from her directly, and then if I need to, I'll play the portions that I need to.
playing video or not?
It would just depend on her answers.
Okay, you might. Okay.
Okay.
But understand we have that
I
cautionary
understand.
instruction. We are not releasing the names of any minors. Okay, you may proceed.
Thank you, Your Honor. Dr. Farrish, during the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to 2 other students that were acting out?
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I want to just refer back to my notes.
Ms. Foster, reminder is the principal. Welcome, Tina. Chris West is getting a migraine. Thanks for your 5, Chris. Sorry about your migraine. Okay, why did the video just freeze? Looks like a law and crime problem.
Correct. Not just in her office, of the school doing the testing, correct?
Objection. It's an opinion about something that she did not observe.
I'll rephrase the question, Your Honor. From Dr. Parker's testimony to you regarding the events of the day, she mentioned that there were 2 other student issues that she dealt with in the school, correct?
Objection. That was the most recent question. It's been asked and answered.
I want to narrow down and go down the path of asking about these 2 other.
Okay, repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Farrish, of what was going on regarding her conversations with Mr. Kovac and Ms. Zwerner, she also mentioned that there were 2 other student issues that she dealt with regarding misbehavior, correct?
Okay, hold on, that's the question. What's the objection, Mr. Jenkins?
This is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, so you can ask it one more time. You can ask it, so go ahead, so overrule.
Okay. Do you need me to repeat the question, Dr. Farrish?
Yes, she responded to other issues.
Okay.
Students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Correct.
Okay.
Or a student who was an eloper.
An eloper.
Something that happened.
Right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
Correct.
Okay. Dr. Farrish, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection, Judge. Hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter entirely.
And her foundation for having that knowledge or information, so sustained.
Okay.
So it seems there are other lawsuits against the district. I don't know by whom, because Abby Zwerner got her jury verdict. The district was thrown out of that case, or let out of that case, I should say, because of workers' compensation. You can't sue your employer for an on-the-job injury. You're entitled to workers' comp. So I guess there's other lawsuits out there. I mean, you can't unring the bell. The jury's heard it. They seem smart based on their questions this morning.
You interviewed Dr. Parker within 2 or 3 days of the shooting, correct?
Correct.
And she gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct? You also told her to keep the conversation confidential, correct?
Correct.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
A basis for your objection?
Judge, we're gonna need to address this at sidebar.
Sidebar.
I'm asking her what she advised Dr. Parker during this interview.
I'm going to sustain the objection. Next question.
Okay.
She should have had a lawyer. She should have had a lawyer, but I will point out this is probably the first time in the history of anywhere, I think, in the United States that a school administrator has ever been criminally charged for a student school shooting. And maybe the jury will start thinking about that now. Oh, that's right. They didn't even tell her she should have had a lawyer. She probably should have had a lawyer. No, she's not even going to do the sidebar. She's like, no.
According to your interview with Dr. Parker directed Ms. Kovac to search JT's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember, the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay. So is it your understanding that Dr. Parker had been told that there was no gun in the backpack and also that he had been closely watched during recess?
Objection, can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
Sustained. Can you rephrase, clarify what you're referring to?
Okay. Well, I've already asked the questions. I'll move on. Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
Okay.
There's something in the background noise. I'm not sure where it's coming from. I don't know if it's somebody's cell phone or, but if we could try to take care of that, it's very distracting.
Yes, I keep hearing it and it's distracting.
Okay, well, Sheriff, be on top of that.
Okay.
And I'm hearing it too, but yeah, we'll work on it. All right, thank you. And again, it's 12:23. We're gonna keep going. Again, we'll try to go till 1 for lunch. But do any of the jurors need a break? Okay, they indicate they're good. Okay, proceed with your cross.
Thank you. Dr. Parker also testified or said to you during the investigation that Ms. Zwerner never stated that the student had a weapon, right? And may I ask what you're reading?
It's a transcript of the video.
Okay.
He's reading a transcript of the video on the stand. I'm sorry, what? Who gave that to her? This is a mishigas, this case. What a mishigas this is. It's a mess.
Do you have any independent recollection of
I
what?
don't remember her saying Zwerner said the student didn't have a weapon. I asked her, did Ms. Zwerner ever say she had concerns about the student and the student being a threat to her or her feeling unsafe?
Okay. Do you recall when the video was played here in the courtroom?
That's what I was trying to remember if Ms. Werner said that. I remember Ms. Kovac saying she did not see anything in the backpack.
Do you recall the video today where Dr. Parker was speaking to you in an interview, and she stated that Ms. Werner never came to her and said that the student had a weapon?
Then, yes.
Okay. And everything that Ms. Werner related to Dr. Parker was about behavior of the student, correct?
Correct.
It also looks like everyone is frozen.
She also mentioned that they had, prior to this incident, that they had 2 incidents at the school where there was a potential weapon possessed by a student, correct?
You're referring to 2 other times?
Prior to January 6, 2023.
Correct.
Okay. And she also mentioned to you that they've never searched the student without the parents' consent, right?
That they've never searched students.
Okay.
They've never searched students. I teach you lots of things.
And she was also managing state testing that day.
Correct.
Okay. Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
Right. In fact,
That was important. He's asking about her findings. The prosecutor didn't jump up and object like I thought he would. Did you conclude that this was unforeseeable, that it was unforeseeable that a 6-year-old would bring a firearm to school? And she said, yes. Listen.
foreseeable. Did you conclude that this was?
Oops, sorry. The boosting unboosting got me there. I don't want to blow out your ears, but let's hear the top of that question.
Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
No.
Right. In fact, you came to the opposite conclusion, correct?
That is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
At any point, did you say something to go different? Oh, okay.
And just ask for a moment to refer to her notes.
Okay.
It's not foreseeable. Interesting, because the civil jury found her liable to the tune of $10 million, even though the school district's own investigation said that this was not a foreseeable event.
I do not recall making that specific statement.
She reviewing. Why does she have paper?
Okay, but you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. He can ask her what she believes today, now, but not what she said out of court.
I thought you said from the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within this proceeding. Yeah.
She says that she can.
Her testimony in any other court proceeding is allowable for purposes of impeachment. Okay? So if she said something differently in the civil trial than she said today, he could use that to impeach her. But he's just asking, did you testify under oath another time that this was highly unforeseeable, that there's no way in hell that anyone ever would have predicted that this kid who was 6 years old would have brought a gun? I guess the prosecutor knows that's really damaging to his case. I want to hear that again. From the top, a 5, 6, 7, 8.
Does that make it in court, or am I missing something here?
It's out of court.
Got to go back to the question of the witness. Hold on. Before he jumps up, that's where I know where to come on.
I do not recall making that specific statement.
Okay, but you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. He can ask her what she believes today, now, but not what she said out of court.
I thought you said during the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within this proceeding. Yeah.
She says that she cannot recall, she could not at that time recall making a statement, and I believe I was asking her about the actual report itself that she created.
Okay, well then rephrase, because that's not the question as I understood it.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, no for answer. So, assuming she says yes, which I don't know what her answer is going to be, are you going to ask her to then give that statement?
I just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
And your position, Mr. James?
He's feeding her the statement and just asking her to say, didn't you say at the civil trial? He's going to give her the statement and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly. To the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood, and your response to that,
Your Honor.
What exception applies?
I can ask her about her statement. This goes to the foreseeable. You know what? I will try to question Your Honor. She's already answered that she has determined that it was not foreseeable. So I'll withdraw the question. Okay. No further questions.
And you redirect.
Yes, sir.
Oh, he's going to have some redirect.
Dr. Farrish, much has been made about your investigation. Do you have, as part of your investigation, did you complete a Richneck investigation report?
Yes.
And do you have that report with you right now?
Yes.
May I approach, Your Honor?
You ain't?
Yes, documents.
Sure. I believe you have a copy.
Law Mama 4 said this judge is really new. FYI, she took the bench less than a year ago. I could tell the way she keeps pulling out the statutes and reading them into the record. Judges that have been doing it for 20, 30 years, they know the statutes by heart. And they can just rule on objections without pulling out the law. But it's hard. Being a judge is hard. Gotta know and remember a lot of stuff.
Judge, I provided to the defense counsel a copy of the plan. Do I need to wait?
What you're presenting to the witness.
Of course.
To make sure that it is the same. Okay?
He's a little impatient, this prosecutor. He's grating on me too, Jen.
Thank you.
Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy?
I mean, yeah, the defense attorney may have one. He may not have an organized trial binder a la Babalesi. You know what I'm saying? You shouldn't have to look for it. You need to show it to him before you show it to the witness. We've been there. We know the rules. This trial's supposed to end by Friday. They have 26 witnesses. I don't know how it's going to end by Friday at this pace.
Copy of your.
Yes.
All right. So is that a fair and accurate copy of your complete full report of your investigation?
Yes.
All right, Judge, I move to admit that as Commonwealth's 3. I think.
Your Honor, I'm going to object. This is the investigation, confidential Richneck investigation report that contains hearsay from other parties. It's not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about, cherry pick little pieces that they want to talk about. And I'm seeking to admit the whole document so the jury can see it for themselves.
No, that report could have, I meant to pause when I only muted. That report could have other testimony from other people that she spoke to that have nothing to do with the guilt or innocence of this defendant. Reports are hearsay. I mean, we've seen them come in recently in such cases as Zedrick Faust about, DNA reports. The testimony is supposed to be the evidence, not the report. She's really regretting not granting them a mistrial now, eh? All right.
So the jury can see it for themselves.
Your Honor, we are on cross-examination allowed to ask about anything we want to ask about. As long as it's scope of the direct examination. This is a report that contains hearsay statements from other parties, just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video. Giving them a full report complete with hearsay is beyond the pale. It's not useful.
Okay, let me see the document.
Of course, may I approach the, the deputy has it. Yes, of course.
Now that we know the judge has only been on the bench for less than a year, do you think that the prosecutor is getting frustrated with her and kind of being condescending to her to try and get her to rule in his favor? I don't know. Like, I know better than you do, Judge. Obviously, this should be admitted. I don't think it should be. It is hearsay. The report is hearsay. He didn't even want her to be able to testify about the report at all.
Your Honor, I would add that Dr. Ferris has not been qualified as an expert.
Messy trial. Messy trial. Why say my name? It says prosecution's taking advantage of the judge being new to the bench and being a bossy, entitled bully. Miss K says yes, and it's working. I mean, this is like a stream of consciousness for me. I just tell you what I'm thinking. Doesn't mean I'm always right. I just, spitballing, brainstorming.
The court will allow a redacted version in, so I will sustain the defense objections as to some of this are not admissible based on the rules of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in. The middle does not. I will.
That's not a good ruling for that's not a good ruling for the prosecution, because I would bet you anything that page 8 is the conclusion, and the conclusion says there's no way in hell that this event could have been foreseeable by any school teacher or staff or administrator, and the cover sheet's coming in and the last page is coming in. And right now, that's not good for the prosecution, in my opinion. Let me know what you think. I don't think he's going to want that. He's going to be like, yeah, I take it back. No backsies, dude. No backsies.
And does the Commonwealth want the portion of the to be marked Commonwealth rejected?
Yes, please, Judge. Thank you.
Okay. Thank you. We're not amazing. Commonwealth, this we're at 3. Commonwealth 3.
It's only the third exhibit.
Rejected 1. Rejected Commonwealth 1. Okay, you may proceed with your reading. Direct.
Judge, may I retrieve Commonwealth 3 from the court to bring to the witness?
Yes, and I'm going to ask. Let's say, well, yeah, I do.
This is a good comment here. Comer K says, I think you are all overreacting about the prosecutor. It's just his personality. I mean, we're watching this from home, right? Jurors have impressions of attorneys too. And it's not always about, sadly to say, it is not always about, especially in civil litigation, which is what my 30 years of experience is in. It's not always about the facts. It's not always about the law. Sometimes it's about who the jury likes better or who they think is more credible. Not just witnesses, but attorneys too. And if they don't like his personality and it's turning them off, it may work against him. I think that's the reason for the conversation. But I see what you're saying, Kay.
Dr. Parrish, for the purposes of these questions, I'll just ask you to refer to Commonwealth 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the 2 that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Your Honor, again, I'm going to object to hearsay. Those are statements coming from other people.
You asked for the finding to be in evidence, findings in evidence. So noted your objection, overruled.
Please continue.
The book bag was searched independently by Ms. Kovac.
This report should not be entered into evidence because she just said several students. I'm going to read that again. Several employees were told. I don't think we've heard several yet. We've heard Ms. Kovac. We haven't heard from the others. And so this is going to make it look like more people knew about this than we've heard in evidence right now. Oh, this is a mess. Let's hear her read it again.
And establish if there were investigation was conducted. Yes.
Could you please?
All right, this is conclusion of the report that they're now allowing her to read into evidence.
Read it.
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon.
Several employees were told that the student had a weapon. Several employees, not several students. Several employees were told that the student had a weapon. The only one we've heard of so far is Ms. Kovac, that the 2 girls came to Ms. Kovac, right? Have we heard of any other employees yet in the trial who have testified they were told the child had a weapon?
All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
All witnesses told Dr. Parker. The only witness we know who told Dr. Parker was Kovac, right?
Your Honor, again.
We're gonna watch Miss West's testimony. She testified yesterday afternoon. I watched it yesterday. I don't remember that she said that, but we're gonna go back and watch it.
I'm going to object to hearsay. Those are statements coming from other people.
You asked for the finding to be in evidence, the findings in evidence. So noted your objection, overruled.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Mr. Werner, Ms. Kovac, Mr. Rawles, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause: failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll retrieve Commonwealth 3 after you and return it to the court.
Thank you.
Now, Dr. Farrish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes.
All right, and that document is an authentic manual that provides all the policies that were in place at Richneck in the 2022-2023 school year?
The Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district?
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth 4. I'll have to retrieve it from the witness.
Okay, you may approach.
Is there no objection to this?
Could I have a moment, please?
Yes, sir. You can still retrieve it, Mr. Jenkins.
I would say it would tend to confuse the jury because violation of the policy and procedures manual is not necessarily a criminal act, right?
Oh, all right, so this is marked Commonwealth 4. All right, so this
The court's already ruled that it come in, so.
oh, all right, so this is marked
He's not objecting because he said the court has already ruled that it could come in, so.
Commonwealth 4.
May I approach the witness, Judge?
You may.
Dr. Farrish, could you take a look at what I just handed you and identify it?
Yes, this is the Newport News Public Schools, Richneck Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of the same document that you have that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in in whole, unredacted, as Commonwealth 5. May I proceed?
You may.
Just want to continue.
Yes, continuing objection, which was previously ruled on and for the record was made contemporaneously.
And I have no further questions for the witness, Your Honor.
Thank you. Any recross?
Yes, sir.
Okay, briefly.
This case says pin it on Miss Parker Day. Forget the other 6. They failed to notify the principal. Interesting take. She does. She has a great voice for an automated phone system, Robin. I agree.
Briefly, Dr. Farrish. Again, the portion of the report that was just entered into evidence, your investigative findings. You were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving up any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
Good. He'll clear it up.
You also mentioned in your root cause section of your report a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct?
Correct.
And according to your report, all of the, I'll just name them specifically, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker, your finding is that none of them responded adequately, correct?
Objection, Judge, I think that misstates the evidence.
To respond to adequately, I do think it's a mistake. Can you rephrase?
Okay, all right. In your root cause section, you write, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims, and Dr. Parker?
Yes.
Okay. No further questions, John.
I have a follow-up, Judge.
Yes, sir.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically?
That was the one.
We took it away from you. Can I please retrieve Commonwealth's form? 5, the Rights and Responsibilities Handbook. And I can give you a page site. I'll direct your attention in Commonwealth 5 to page 28, the paragraph that begins principals and school security officers.
Mm-hmm. Principals and school security officers under the direction of a school administrator may search students and student property.
All right. So given the root cause analysis that involves the failure to search, who was authorized by the district's rights and responsibilities to search?
The school under the direction of the school administrator.
Okay. And are teachers that work in a school considered school administrators?
I thought she's not an expert, dude. You can't use it as a shield and a sword. You can't say she's not an expert and now ask her to interpret the school policy, which is what you've been objecting about and blathering about the whole entire time.
Are teachers that work in a school considered school administrators?
No,
Are reading specialists that work at a school considered school administrators?
no.
All right, thank you. I don't have any further questions, please.
Okay, so this, so that paragraph, it starts out principals and school officers. And then it, comma, under the direction of a school administrator.
Objection. I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
Are you reading the same thing the witness has?
Yes, ma'am.
Okay, then go ahead. You may proceed. Overruled.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes a principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of a school administrator.
Principals? Okay, so if I take out, it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that seems to indicate there needs to be some authority above the principal. Do you disagree with that?
Same, Mr. Jenkins, the same. Next question, Mr. Rogers.
That's all I have.
Okay. The status for this witness. May she be excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to.
Mr. Rogers?
Yes, Your Honor, we agree.
Okay, all right, so Dr. Fair, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room. You can go about your day, be available by phone if we need to call you back for your testimony.
Yes.
Okay, and you'll be informed when you receive question ends and you will release from the witness obligation. Okay, thank you, ma'am, and why accept that you stepped in.
Thank you.
All right. Can we do another witness in about 10, or start with another witness about for 10 minutes or so? I want to use up our time.
Before we call another witness, I would need to step out, so.
Okay, okay, yes, Mr. Jenkins.
If we're going to need to take a break here, it doesn't make sense to call another. The break will take 5 minutes, and then we'll only have 5 minutes of a witness.
Okay,
One
so
time, so.
it is 12:51. We will start our recess for lunch. For the attorneys, are there any motions, objections that we need to take up before we resume evidence? Meaning, I'll tell the jurors to report back at the jurors at one time, and I'll tell you all a different time if we need to work out issues.
There's nothing from the Commonwealth.
I think we're good.
Okay, so I'm gonna keep a tight schedule. Jurors report back at 2, attorneys report back at 2.
Okay. The live feed is on a half an hour delay, which means that they won't be back in court or we won't get the live feed to us until 2:30 East Coast time, and it is now 2:17. So we have a little time to chit chat before court comes back. And then, praise be, we will be on real time. Look at that. It's a good thing we started late because there was so much shenanigans. So it looks like maybe we have 13 minutes. This is a messy one, huh? It's a messy trial. We'll go back to court as soon as they come back from lunch, as soon as they allow us in. Mr. J, correcting an earlier comment. Thanks for your 10. Says the connection was a misassociation between the victim's name and the name of a different killer near the same time period. Sean Novak, my recall is a train wreck. So here we are. Thank you for your 10 for explaining. Mass Mom says, for me, it's hard to place blame on just one person in these types of cases. It seems like there was a lot of missed opportunities here from all sides. I wonder if the jury is seeing that too. I wonder. Sewing is asked this question earlier. I thought it was good, so I started so that you guys in the chat can talk about it. Look what happened to the police that did not go into the school while children were being attacked. Is this any different than what happened then? Well, those were school resource officers and other officers. I think you're talking about Uvalde, but there have been so many cases like that. But I do believe the officer in Uvalde was acquitted. So if anybody in the chat would like to address Sewing B33 with your thoughts on that and how this case differs, please let him or her know. And also followed up with a comment. Sewing B33 said, hopefully people use this case as a kind of guideline and act swiftly and not wait for testing to be over or a parent to come and take care of the matter. Hindsight is always 20/20. Negligence is negligence. Does it rise to the level of a criminal act? That's the question here. Andrea with an eye said, I can't say what I would do as a juror, but as a mom, I'm sickened at the idea of any grown adult not immediately dropping everything to ensure safety. Thank you, Andrea, for your 5. Amber said, we all need to keep in mind that if this student had an IEP or 504 plan, there may be clear instructions on what can and cannot be done to this child. Thank you for that. Welcome, Tina Serafina, for becoming a member. I think you're going to like it here. Denise says, Denise loves Ollie, and she says, I'm unsure of many aspects. However, 2 things stand out. The administrator not knowing all duties, and the child had previously been indicated as having issues. Thank you for your 20, Denise. Kelly says, I'm waiting for a reason for the objection being he's opening his mouth and words are coming out, Your Honor, followed by a foot stamp and stuck out bottom lip. Thanks for being here for 15 months. Risa says, why are they arguing in front of the jury? I don't know when you put this comment in, which is about a half an hour ago, and this judge does not do sidebars, it seems. Here's your answer. We've also learned that she's only been on the bench for, I think, less than a year. Tom said, you're asking people who never wanted or thought they'd be in a violent crisis and have no personal protection getting for teachers near minimum wage to react 100% right? Interesting point. Chris West says we should have a counter for objections. I don't do that, but Zoe's in the chat. She sometimes does that. She's our resident statistician. I wanted to show you some footage I had of the JT's mom. And so let me pull that up for you real quick. She spoke to the media early on in this case before she pled guilty to the charges against her. This is the shooter's mom. Let me just go through. Oh, please. All right, well, we're going to look at the charges that she was facing and what happened. Let me just see. That was 2 years ago, November 15th, 2023. And then there was another news clip from, I'll play them in order. December 2023. All right, so the first one that we need to look at is November 2023. Those were the federal charges. And this is with regard to the little boy's mom. This is 13 News Now reporting on what happened with Miss Taylor, the mother of the shooter, the 6-year-old JT. There you go.
News, the mother of the Richneck school shooter will spend nearly 2 years in federal prison. The ruling came down just moments ago.
Deja Taylor pleaded guilty to lying on her gun permit paperwork about using marijuana at the same time that she bought her handgun. Ann Sprocco sat in court today for the sentencing hearing. That included the first ever testimony from Abby Zwerner, the teacher shot in January. So, Ann, tell us what you learned today.
Well, Dan, Janet, the sentencing hearing just wrapped up minutes ago. Judge Mark Davis sentenced Deja Taylor to 21 months in prison. This is the same sentence recommended by the prosecutors handling the case. Deja Taylor broke down in tears when the judge handed down his decision this afternoon.
Here's the mom right here, 26 years old. She got 21 months federal time for lying on her firearms application. She pled guilty. There was no trial.
David said, quote, "This case cries out for a sentence of imprisonment." During the hearing, the teacher, Abby Zwerner, shot by Taylor's son last January, testified. With a deep scar still present on her hand, Zwerner read a letter to the court stating how she still has nightmares about the day her student pointed a handgun at her and shot her in her own classroom. She said, quote, "I love children, but now I'm scared to be involved with them." Taylor's attorney read a letter she wrote to the judge telling the court she is remorseful of all of her actions involved in this situation. But Judge Davis heavily weighed the fact that Taylor had multiple probation violations after failing 8 drug tests for marijuana. This is what Taylor's attorney had to say about the emotions in the courtroom.
She feels deeply remorseful about what has happened, and she's going to prison. She's 26 years old, and that has a big impact on someone with her background and her age. But I think when she gets out, she's going to turn her life around.
And Taylor was taken directly into custody following the hearing. Judge Davis said Taylor will have a 2 years of supervised probation following her release. Reporting live in Newport News, I'm Ann Sparacco for 13 News Now.
And thanks. Prosecutors did not want to comment on this case today. Zwerner and her family also did not comment on the judge's decision tonight.
Okay, so those were the federal charges. Just hang on one second while I get the state charges for you. That was for lying on the firearm application. The state charges for the mom were child endangerment charges. Let's take a look at those and what happened there. This was 1 month after the federal charges.
And breaking tonight, the mother of the Richneck Elementary School shooter will spend 2 years in state prison. Today, a judge called Deja Taylor's actions egregious after she was found guilty of felony child neglect.
Emily Harrison was there when the judge handed down the sentence. She is live now. And Emily, this decision goes well beyond the sentencing guidelines.
That's exactly going to be the case. A Newport News judge sentenced Deja Taylor to a total of 5 years, 2 of which she will spend in state prison. And the other 3 years are suspended at this time. The judge told the courtroom he could not follow the sentencing guidelines of 0 to 6 months because, quote, "these guidelines do not take all the facts and history of this case into account." Deja Taylor stood stone still as the judge handed down the sentence. The judge said he could not follow the sentencing guidelines of 0 to 6 months because, quote, "this is significantly more serious than lying on a form. Child neglect is the most serious crime, the most serious charge." Taylor's attorney, James Ellenson, says he is disappointed with the decision.
We think it was excessive. I think there are guidelines for a reason. And I think the guidelines were adequate in this case. And I just respectfully disagree with Judge Papil.
Right now, Taylor is serving 21 months for 2 federal charges because she lied on her gun registration and will now serve this 2-year prison sentence consecutively to it. When handing down the sentence, the judge also questioned Taylor's remorse. He pointed to public statements Taylor has made about her son's frustration with his teacher, Abby Zwerner, and Taylor's, quote, "misleading statements about where she kept the gun in her home." Ellenson says an appeal is possible, as he says Taylor's statements should not have been a factor.
There's a couple of things from a legal perspective. I don't know that he could even take that into account because that was not evidence that was presented in court today. So I think the judge is looking outside of what evidence had been introduced in court.
Teacher Abby Zwerner did not have a comment walking out of Newport News Circuit Court following the sentencing, but she read a victim impact statement on the stand. She told the judge, quote, "this never would have happened to me if not for the defendant's actions or lack thereof." Now, while Taylor is going to be serving her time in prison, there is still a protective order between her and her son. She is still able to have supervised visits with her son, but she cannot have any criminal or offensive behavior in front of him. And it is entirely up to the discretion of the child's guardian, which is going to be Calvin Taylor, who is
Interesting that she was still allowed to have visitation with her son, unlike Kelsey Fitzsimmons, right? Interesting. Let's see that again. She's going to tell us who the guardian is.
Her and her son. She is still able to have supervised visits with her son, but she cannot have any criminal or offensive behavior in front of him. And it is entirely up to the discretion of the child's guardian, which is going to be Calvin Taylor, who is Deja Taylor's grandfather. In Newport News, I'm Emily Harrison, 13 News Now.
Okay, Emily, thanks. And following Taylor's release from prison, she will have 2 years probation. She'll be required to undergo a psychological evaluation, counseling to overcome drug addiction, and she'll have to take parenting classes.
Oops. Is that JT's dad? No, it's his great grandfather. It's a great grandfather that he's in the custody of, or was in the custody of. There's been some rumblings in the chat that she's been released. I don't have any receipts on that, so I'm just not sure. But concurrently would mean that both sentences were served at the same time, meaning the 24 months in federal, I believe 24 months is 24 months. I don't think there's any chance of early release. And so the 21 months would be served at the same time as the 24 months. And so I would imagine that she's been released, but I cannot confirm because I do not have any receipts on that. And so let's go to you in the chat and take your pulse on this. Where's the father? I don't know. Somebody else, somebody else in the chat surmising there must be abuse in the house. No, there's no indication of that. I would not say that there must be. Sometimes good parents have children who do very bad things. The Google says she was released May 13th. Can you send me, virtual juror, the article on that so I have a receipt on that? AI is often wrong, as you know. So there's that. Some earlier comments. Zoe said, the issue for me is why wasn't the kid removed from the classroom and was required to be monitored one-on-one or in the office or other secure location until the mom arrived? That's what they were going to do. Diaco Dan Law says, Melanie, you were correct. The mother was supposed to be with the child at all times during school. In that day, they talked to follow that protocol was set out. Well, remember the child we learned, I think, was suspended the day after the smashing of the phone incident. Hey, it's Ariel said if she was expected to act as a school resource officer, they should have provided a school resource officer when she was not able to. Nathan said the child never made a threat. It was just a suspicion that was reported to admin. Zoe, clarifying what's happening with the Colt Gray hearing or trial. Colt Gray next status hearing May 28th was 14 on the day of the incident in 2024, charged as an adult. Gray has cycled through multiple attorneys. Latoya Williams is the current public defender as of late 2025. Latoya Williams was also representing Sarah Grace Patrick, but I thought Latoya Williams was going to take a private job. So I don't know, Zoe, if she's still the attorney or if she's in private practice now. Thank you for that. Lori says, my master's degree in education is from Columbia University in New York City and geared toward public education. We did not have one class in how to address disciplinary situations. Make it make sense. I can't, girl. I can't. Law Mama 4 said, the video we just watched, I agree, but then he said he wanted to ask her about another video that he doesn't have. I thought he was referring to the surveillance video of the scene that has been talked about at the trial. In fact, some of it was played that was blurred out of Miss Kovac doing the bear hug on the young boy, on the JT. I thought he was referring to other surveillance video, but I could be wrong. Lori says, Melanie, one time when we need a laugh, I'll share my story about meeting Bob Weir with my high school field hockey team 30 years ago and how cool and funny he was. I've met him a couple of times. One of the times that I met him was in when I was in college. That's a long, funny story too. I'll tell you about that sometime. In Salt Lake City, he was playing with another band. We were invited to come backstage, and then we were like hand selected to come to the after party. But since it was in Salt Lake City, they had very strict liquor laws at the time, and there was no booze at the after party. It was wild. It's a story for another day, just like yours, but fun story. Poe Ethnic Justice Podcast word I learned today. Mishigas, also spelled Mishigas, right, is a Yiddish word that means craziness, foolishness, or senseless behavior, from the Hebrew word mishuga, meaning crazy. That is true. It is Yiddish. Sometimes I pull out my Yiddish. I live on Long Island. We all know it here. La Mama said the judge is new. Less than a year ago, she took the bench and lost and stuck in Detroit. Says this morning, I was a she's guilty boy. Now I'm the opposite. I don't know. I don't know where I'm going on this at this time. Petty Patty said, I think the school district is using Miss Parker as a scapegoat to try and avoid pending lawsuits. Interesting. Goodmans are here. Thank you, Goodmans. This trial is a mess of gosh. Thanks for being here for 20 months. I'm going to run and fill up my iced coffee. I'm going to leave Law and Crime on live. So if they come back, you'll get it before I do, but I'll be watching off screen. So just let's put this. The court is on lunch. They're supposed to be back already. Hold on. But they're not. Oh, please. All right, I'm going to leave it up. I'm just going to put the banner on that court is on break until I'm what should be 2:30. So I will be right back. Go fill up your drinks if you need to. Because the media has been told that they needed to broadcast on a 30-minute delay. All right, I'll be right back. Go fill up your drinks.
Resuming on day 3 after the lunch recess. Anything to take up before we bring the jurors out?
Nothing from the Commonwealth.
We're good.
Okay, Chair, please bring out the jurors.
Please rise to the jury. Jurors in the box.
All right, thank you so much. You all may have to take your seats. Jurors in the box. And jurors, are there any issues to report to the court? Okay, nothing has been said. All right, next witness, Mr. Jenkins.
Commonwealth calls Mark Garcia.
Good afternoon. Come stand in front of Madam Clerk, please.
Again, do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay, sir, take your witness stand, please. Watch your step. Okay, you can adjust the microphone and please answer questions the attorneys may have.
I'm back. I was listening on my phone while I was getting my drink refilled, and it sounded to me like the court audio is better. So right now it is not boosted. Let me know if they've fixed it for you too, or if that was just me off camera.
Good afternoon, sir.
Afternoon.
Would you please tell us your name?
Mark Lincoln Garcia Sr.
All right, sir. And I know that I mentioned this to you earlier, but just as a reminder, we're not saying the names of any children at all today. You're welcome to use initials or refer to them, you know, like my son, for example, but no names. I want to, do you have a son?
Yes.
And what is his initials?
MJ.
All right. Did MJ attend Richneck Elementary School?
Yes.
Was MJ in attendance at Richneck on January 6, 2023?
Yes.
How old was he then?
7.
On January 6 of 2023, did you go to Richneck Elementary School? Well, first of all, let me ask you this question. Did you take MJ to school?
Yes.
So was that in your car? Did you personally drop him off?
Yes, I drop him off every day.
Okay. And on that day, did you go back to Richneck Elementary School sooner than you normally would?
Yes.
When you arrived there, I want you to describe what you saw occurring without telling me what anyone was saying.
Okay. Well, getting there was a task because once you get to Jefferson, going down Richneck, it was kind of like cordoned off by the cops and a lot of people trying to go there. So we had to go to the adjacent road, which is Monroe. And we had to come down Monroe, and we got to Monroe and we had to stop because there's a lot of cars. So I parked my car in somebody's house and he said we could park there, and I got out my car, and I parked my car and I went down the road, and there's a church that's on the right hand side, and that's where everything was cordoned off by the cops, and that's where all of the confusion was going on because nobody knew what was going on.
So did you go to that church area where people were gathering
We
with
were
the
in the
police?
middle of the street.
Okay. And did you immediately see MJ there?
No.
Okay. From the time you arrive, and I know I'm asking you to estimate, but can you give us an estimate? Are you able to give us an estimate of how long it was from the time you arrived at Richneck to the time you saw your son?
Response.
This is the connection, Judge, that we have been talking about in this case between the shooting and the ensuing trauma to the children. And that came from a delayed reunification. And that came from, as we will hear in a moment, that came from the continued chaos leading to these children in a panic and a state of trauma.
Your Honor, I'm going to continue to object. Even his response to this is a narrative testimony.
Yeah, it is. Speaking objection much?
Why we're here, and I guess I'm missing that. If you can expand on that, if not, it's sustained.
The nexus for why we're here. Let me look at the statute and read from the statute.
No, you don't read from the statute in front of the jury. No. The jury's in the room, right?
18.2, 371.1. Any person responsible for the care of a child under 18 whose willful act or omission in that care was so gross, wanton, and culpable to show a reckless disregard for human life is guilty of a Class 6 felony. As to how
A delayed reunification.
the shooting, Judge, the shooting occurred, and everything that has happened to these children is a follow-on from the shooting that establishes it is gross, wanton, and culpable behavior of Dr. Parker. It was the willful omission that caused these children to be separated from their parents in a state of chaos.
I sustain the objection. Next question, please.
Mr. Gar-
I know that I was downstairs when we started, but is the jury in the room? Does anybody know? I may need to turn my volume down. The jury's in the room. Okay, we are officially now in land of the lost territory. So Chaka goes up in the right-hand corner at this time. He just read the statute to the jury. And so now you know what the statute says. Let's hear that again. Because this is part of, I guess, what she's charged with. There you go.
18.2, 371.1. Look at the statute and read from the statute. (18.2, 371.1). Any person responsible for the care of a child under 18 whose willful...
Somebody says, shouldn't the jury know what the law is? Yeah, but it's not his job to tell them the law. It's the judge's. At the end of the case, when she instructs the jury on the law.
Act or omission in that person response. 18.2, 371.1. Any person responsible for the care of a child under 18 whose willful act or omission in that care was so gross, wanton, and culpable to show a reckless disregard for human life is guilty of a Class 6 felony. As to how
A delayed reunification.
the shooting, Judge, the shooting occurred, and everything that has happened to these children is a follow-on from the shooting that establishes it is gross, wanton, and culpable behavior of Dr. Parker. It was the willful omission that caused these children to be separated from their parents in a state of chaos.
I sustain the objection. Next question, please.
Mr. Garcia, after you were reunited with your son, describe his demeanor, how he looked to you.
He can describe that out loud. Overruled. You may answer the question, sir. You need him to repeat it?
Okay. My son was confused. He was very scared and very shocked that all of this took place in his school, which he loved.
All right. And are there any ways that you've noticed as a parent that your son is different was different after the shooting versus before the shooting?
Yes.
Describe what you noticed.
And objection to relevance.
Okay, I didn't hear, okay, leading and relevance. He can describe what he observed when he sees his son. Go ahead, overruled.
So my son, he's in therapy. He has to go to therapy now. He's still scared of the dark areas in which they have to be pushed in their safe room. He's not comfortable in certain situations like he used to be, like being talkative and things of that nature.
Objection, Your Honor. If I can just have a question.
Yes, sir.
Even regarding the statute, the things the Commonwealth has to prove, this is the things that he's testifying to is not a material fact that has to be proven or established to prove that Dr. Parker is guilty of this crime. He's testifying as to things that occurred afterwards, but nothing regarding Dr. Parker's conduct or lack of conduct. So it's not relevant.
It's not relevant.
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is as far as I'm going with this.
Okay. The proper venue for this is in civil court. Okay. And maybe this parent does have a civil action pending. Maybe he will file a civil action after this. But as the prosecutor told us in his opening, his theory here is that the children in the classroom are the victims here, not Abby Zwerner, the teacher who was shot. This is a very odd theory of a case. The child endangerment, the charging is weird. The fact that he's saying that the children in the classroom are the victims here. And so now he's sort of trying to put out there some evidence that the children in the classroom suffered injury or damages as a result of Dr. Parker's failure to act. Remember, this is a failure to act. It's not what she did, it's what she did not do. And so now he's trying to put this witness up who had a child who was in the classroom, I guess. Have they even established that the child was in the classroom when the shooting happened? For this father to now testify about the problems that his son is having because of the delayed reunification. This is so all over the place that it's like, it's wild. It's child endangerment, right? Is the actual charge here. And is this more prejudicial than probative? Because he's got to show damages. He's got to show that a child or more than one children, 8 of them, because there's 8 counts here, that 8 children were damaged somehow, injured in some way by Dr. Parker's failure to act. And this is his college try, I guess. Is he going to call 8 parents in? Is he going to choose 8 random parents? to come in and say that their child has nightmares now because of the delayed reunification or because of what they saw in the classroom, that they have nightmare. It's just, it's wild, right? There's 20 in the classroom. They're charging her with 8 because there were 8 bullets that the child brought to school. Do you think that this is a stretch? Yeah, Jenna's like, this is like financial crimes and Murdoch, except for this is the crime. This is the crime. It's not like these are extraneous things. This is the crime. They have to show that children were endangered and that they suffered some sort of an injury. And this is what they're trying to do. The best place for this is in civil court. There's there's a $10 million verdict against Ebony Parker that she's got to, at some point, maybe in her lifetime, pay Abby Zwerner. Abby's the one who got shot. Now they're trying to show, oh, the children in the classroom were the real victims in this criminal case. They're not charging her criminally for what happened to Abby Zwerner, the teacher. And it's very confusing. Chaka even looks confused. That's from the episode where Chaka was possessed from the 1970s TV show Land of the Lost. But here we are. And she seems like she's going to allow it. So let's see how many other parents he parades up there. Here we go. We're going to take it back a little bit so you can hear what the testimony was again. And this is what he's saying. My child has nightmares. He's not that talkative anymore. He's different now than he was before the shooting. He doesn't like to go to school anymore. And all of those things are horrible and tragic. Horrible and tragic. But there was an intervening act of a 6-year-old who got a hold of a gun out of his mother's purse, which was a legal weapon. The mother has served her time. And I'm getting to the point of, what are we doing here? What are we doing here? If we're going to start prosecuting everybody in the chain, then we should prosecute everybody in the chain, right? Nobody's ever going to want to be a teacher or a school administrator or work in a school if everyone can be criminally charged when there's an intervening act that is not foreseeable. We're all confused. All right, here he's going to tell us my heart breaks for his son. No child should ever have to go through this. But you got a woman sitting in the defendant's chair who's facing up to 40 years, up to 5 years on each child endangerment charge. So, I mean, I'm just telling you the facts, because I don't know what the right answer is, but the jury is the finder of fact here. Thank God we're not. I can't believe a mistrial wasn't granted this morning, because this is getting crazy. It's cray. All right, let's hear Mr. Garcia tell us about his son in the room when the shooting happened.
That your son is different
in his school, in which he loved.
All right. And are there any ways that you've noticed as a parent that your son is different was different after the shooting versus before the shooting?
Yes.
Describe what you noticed.
And objection to relevance.
Okay, I didn't hear, okay, leading and relevance. He can describe what he observed when he sees his son. Go ahead. Overrule.
So my son, he's in therapy. He has to go to therapy now. He's still scared of the dark areas in which they have to be pushed in their safe room. He's not comfortable in certain situations like he used to be, like being talkative and things of that nature.
Objection, Your Honor. If I can just still flesh this out.
Yes, sir.
Even regarding the statute, the things the Commonwealth has to prove, this is the things that he's testifying to is not a material fact that has to be proven or established to prove that Dr. Parker is guilty of this crime. He's testifying as to things that occurred afterwards, but nothing regarding Dr. Parker's conduct or lack of conduct. So it's not relevant.
Response?
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is this is as far as I'm going with this. But the fact that the child is different after than before is relevant to whether the choices Dr. Parker made were gross, or the omissions were gross, wanton, and culpable, because this is the after effect to the children.
But you're not showing causation. How are you going to prove causation? Okay, I'm sorry. How are you going to prove causation? A lot of kids are afraid of the dark. A lot of kids that age wind up in therapy. You're not going to be able to prove causation. Again, this is not a civil trial. You're going to need doctors to come in and testify about the therapy sessions with these children, and that the reason for these changes and these nightmares and these whatever it is that the father is saying has the injuries to his child, that it was caused by this specific thing and these specific omissions of the teacher. This is such a slip of the administrator, such a slippery slope. You can't just parade the parents up there one by one and say, oh, my child has nightmares now. You need a causal connection by a medical provider to say that. I don't know what's happening here. We have Twilight Zone emojis. I'll allow it if you want to use them. I don't know.
It can end here, but again, I'll let you finish, Mr. Rogers. But as to where we are now, I'm going to overrule defense objection. You can ask that one question. The gentleman may answer that question, but then we're going to stop. Yes, Mr. Rogers.
Yes, Your Honor, I might agree with Mr. Jenkins that the Commonwealth had to prove some type of serious injury, but that's not what is charged. Felony abuse and neglect, but it's not based on any injury. It's based on my conduct and not any impact on these children.
Anything additional?
Not from me, Judge.
Okay. Do you need the attorney to repeat his question?
Yes, please.
Okay. How was your child different after the shooting versus before?
Yes.
Describe how he was different after.
Would you like me to describe before?
If
you
you
have to answer the question that he asked.
Okay.
Yeah.
So after, again, my son, he doesn't like sleeping in the dark because of being in that safe room for however long they were in that safe room, being confined to an area, having, I don't know how much light it was, but he's scared of the dark, having added more light and going to therapy.
Okay. And were any of those things present prior to the shooting?
No.
All right, thank you. I don't have any further questions for you.
He's afraid of the dark because he was in a safe room, not because of the shooting. Do you see the difference?
Good afternoon, Mr. Garcia. I just have a few questions. Are you familiar with any relationship that your son had with Dr. Parker?
No.
Okay. Your son was a second grade student at Richneck, correct?
Correct.
So he was not in Ms. Zwerner's classroom, correct? Okay. You mentioned something about a safe room. Isn't it true that your son was in the gym?
No.
Your son was not in the gym when you picked him up?
No.
Okay. Where was he?
I don't know.
Oh, you don't know?
No, we were told by the police.
Oh, well, I'm not asking you to tell me what somebody told you.
Okay.
So you don't know?
No.
Okay. You filed a civil lawsuit arising from the events on January 6, 2023, correct?
Sure.
Okay. And it's filed.
Okay, so he does have a civil lawsuit pending. There's the answer to your questions. to our questions.
That's on January 6, 2023, correct?
Correct.
Okay. And it's filed here in this courthouse, correct?
Not sure.
You're not sure?
No, I got it. You have
What-
to talk to my attorney.
I'm sorry?
You have to talk to my attorney on that.
Okay. You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not gonna talk about that on camera. Let it straight.
Judge, I am going to make a limited objection here in that any civil suits relate to the children. And I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording.
Why?
While he discusses his child. And I support that request and ask the court to do that.
No, he filed a civil suit, so he's got a financial interest in convicting this defendant. That is the point. They're not going to be specifically talking about the child or anything having to do with the child. But if if he filed a civil lawsuit, it goes to bias because he's got a financial interest in having this woman convicted. And if she's convicted, it makes his civil case more of a slam dunk on damages. Come on, prosecutor. Don't hide that from the world. Let's see if she shuts off the cameras.
Well, Your Honor, he just asked a series of questions about the child on a camera. I'm asking about a civil case, asking him whether he filed a civil case. It has nothing to do with the child himself.
So the objection is overruled. Cross-examination, the questioner is allowed to examine the witness's interest in a case. And for the witness, we are not using names, we are using initials as we previously did. So that is the protection to minors in this case. All right, you may proceed, Mr. T.
Mr. Garcia, you are seeking money damages from Dr. Ebony Parker in that civil case, correct?
Yes.
And a criminal conviction of Dr. Parker would assist in your civil case against her, wouldn't it?
I believe so.
Okay. So you have a financial interest in the outcome of this criminal trial?
Financial. What do you mean?
Well, you just stated that you believe that a criminal conviction of Dr. Parker would assist you in your civil case where you're suing for money, correct?
Yes.
Okay. So you would agree you have a financial interest in the outcome of the criminal trial, correct?
Possibly, yes.
Okay. When did the school first contact you about the shooting?
January 16th.
16th?
Yes.
Okay, so 10 days after the shooting occurred. Okay. And how did you get that notification?
I was called by the city, the Newport News Public Schools, I forgot the name of the downtown director of people, but I know her name, but she called me at 6 o'clock on the 16th.
Okay.
Okay, so his child was not in the room. He was not in the classroom of the shooting. He was not in Abby Zwerner's class. He was just put into lockdown because that's what they're supposed to do. Very sadly, our children have been trained on shooter lockdown drills since kindergarten. And I have some children who are over 30 of my own. He didn't see the shooting. He wasn't in Abby Zwerner's classroom, but he's filing a civil lawsuit because he was in lockdown and now he's afraid of the dark. Okay. I don't want to belittle or demean any child's fears because, I have sympathy, but now we're really stretching it.
And do you consider that failure to notify you for 10 days a failure?
Absolutely.
And do you believe that failure is on the part of Newport News Public Schools?
I believe it's on the part of the school system as well as Newport News Public Schools.
Thank you. No further questions.
Any redirect?
Yes, Your Honor.
You've indicated on cross-examination that your son, NJ, was not in Miss Werner's classroom. What was his homeroom?
His homeroom was Mrs. McAulif's class.
And did he have occasion to interact with other students from other classes?
Yeah, in the same hallway.
Now, in the immediate aftermath of this, when you picked him up, did he tell you anything about contact he had had with another student?
Objection, relevance and hearsay.
Okay, and I was going to ask you, are you asking me to give the statement or just to?
I am going to attempt to establish possibly an excited utterance.
Okay, all right, so there's an objection.
Yes.
What's your response?
What is the legal basis for the objection? I missed it.
If you could repeat, Mr. T.
Relevance and hearsay.
Okay, so it would be hearsay unless the court finds that the excited utterance exception applies. I'll need to lay a foundation for that.
So if you could lay a foundation and to the witness, sir, when we ask you to pause, and we can make sure that the evidence is appropriate under the rules of evidence. You may proceed.
In the immediate aftermath of the event, right when you see your son, does your son speak to you about the event?
Yes.
Does your son tell you about a child he interacted with?
Stop.
Yes.
Okay.
He's leading.
And do you know who, just a yes or no question, do you know who that child is?
No.
Okay.
Well, it's foundational, but
when your son tells
he's
you
not saying when. He's not saying when this happened. Didn't he just say he wasn't notified until 10 days later? He went to school to pick him up same day. He's not giving us a time frame. I mean, I'm twitching again, Law Mama 4. I'm twitching.
And do you know who, just a yes or no question, do you know who that child is?
No.
Okay. When your son is telling you this, can you describe for us, without saying what he said, can you describe his demeanor, how he appeared and how he was acting and how he sounded?
He was scared, shaky, and nervous.
Okay. Did he relate to you something that had just happened earlier that day?
Correct.
Judge, I think that is sufficient foundation as to hearsay under the excited utterance.
Yes, sir. Anything from the defense?
Yes, Your Honor. He has, Mr. Commonwealth has not established any foundation regarding excited utterances. We don't know how long before, and if we're talking about the shooting that had occurred at 2 p.m. and the father didn't pick up his child until sometime later in the afternoon, presumably hours later, then I don't see how it qualifies as an excited utterance.
May I respond to that, Judge?
Yes, sir.
The excited utterance exception is extended when the declarant is a child, because courts have recognized in Virginia the nature of being a child and brain development means that the heightened experience of an emergency extends quite some time. There are cases that I will have to look up if the court would like that involve many hours long when the child is young. The younger the child and the more traumatized they are acting, the longer the extension of the excited utterance is.
I am going to sustain the objection. The legal basis would be as such. Reading Rule 2:803, excited utterance. So an excited utterance is defined as a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with firsthand knowledge at the time under circumstances negating deliberation. Again, my pauses are to show the clauses and breakups and how to decipher that. It has not been established that the declarant, which would be the witness's son, had firsthand knowledge at a time, as he was not in the affected classrooms, and there's been no evidence other than that being a student at school since it happened.
That's true.
as to how he would have gained firsthand knowledge through an appropriate way. So I'm going to sustain the objection.
I'm going to request to voir dire the witness so that I can establish exactly that.
The child wasn't in the room, sir.
And just go out of the presence of the jury.
Yes, Your Honor.
All right. Ladies and gentlemen.
The child wasn't in the room.
To the jury room and we'll bring it out. Thank you.
Please rise the jury.
They're sending the jury out now. And he's going to try like hell to get it in.
See, into the witness, you're still under oath. We're going to have some additional questions for you. But one more will work for the door. You may proceed.
In that moment where you were just describing his demeanor, tell us what MJ told you.
My son sits on the last seat because they don't have any doors in their classroom. So his seat, he could hear the pop. When he heard the pop, the teacher, they heard over the walkie-talkie that someone got shot. And they got everybody scrambled into the outside of their classroom, which was in the direct line of supposedly their safe zone, which is outside of their classrooms.
Okay, let me ask you this question. Did MJ say all of that to you in that moment?
Yes.
Okay.
In what moment?
And so if I understand your testimony correctly, is it that he heard the gunshot and he was in a classroom that had no door?
Yes.
Okay.
He heard a pop, I believe.
A pop.
Yes.
Isn't that a fire hazard to have no door in a classroom? I am. Okay. Okay.
And then he had to evacuate with the school, basically.
He had to evacuate his classroom in the danger zone.
Okay.
Say that you're saying in or and?
In the danger zone because his class has no door, so the zone of where they have to go out is out.
Oh, his attorney explained to him the zone of danger rule in civil court. Raise your hand if you know about the zone of danger. In order to collect in a civil case, you need to be within the zone of danger. Certain situations. He's throwing out his lingo. See how he's putting in zone of danger? You're picking up what he's laying down? But what was the excited utterance? All he told us was that he heard over the walkie-talkie that. What did his child say to him? Where's the excited utterance here? Am I missing something? Let's hear it again.
Basically.
He had to evacuate his classroom in the danger zone.
Okay.
Say that you're saying in or and?
In the danger zone because his class has no door, so the zone of where they have to go out is outside of their classroom in that same hallway.
Okay, and he used the word danger zone.
My son?
Yes.
No.
Okay, I think he's asking you, what did the child say? I mean, the verbatim statement.
He was in his the safe room. He went to the safe room.
Okay.
Okay, and Mr. Rogers, you were saying something, you want to say something?
I was going to address his characterization of danger zone. I think the court has done that.
Judge, I'm not going to seek to admit
Good.
the statement. We need to bring the jury back up.
Good.
Thank you, Mr. Garcia.
You wrong.
Yeah, I know you all just stood, you can keep your seats this time. It's not funny, and I gave you a break, it was just a few minutes ago. You can bring them out, but everybody doesn't have to stand.
You wrong, Mr. Prosecutor. There was no excited utterance. There was nothing.
Very much. And normally they stand, I told them that they just stood, they didn't have to, so it's no disrespect to you all, it was just my command. You may finish with your questions if you have any more.
Yes, Your Honor. Mr. Garcia, had you personally ever been inside Richneck Elementary School?
Yes.
Had you personally ever gone to your son's classroom? And did your son's classroom have a door?
No.
All right, thank you. I don't have anything further.
Cross-examination?
I think we're fine.
judge has no questions? Okay, all right. And the status for this witness?
I would ask that he be released unless there's an objection to that.
He can be released.
Okay, so sir, what that means is you're released.
That would have been recrossed, but
You may stay in the courtroom.
we're all confused.
Go about your business, and thank you, sir.
Thank you so much.
And next witness,
Commonwealth will call Susan White.
Susan White.
Susan White.
Thank you.
Bet this is another parent. There was a cross. The cross was, didn't you file a civil lawsuit against the school? That was redirect. That would have been recross, right? I might be losing my mind, but I don't think so. Not yet.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Your Honor, if I may.
Yes, sir.
I know the court has already ruled on Mrs. White's.
And come on, and hold on one second. Come on in the witness stand and watch your step. And yes, you can move the chair and microphone. Yes, Mr.
The court's already ruled on Mrs. White's ability to be able to testify today. So doing my objection to any testimony she will give regarding how it's not relevant to what happened on January 6th regarding my client's conduct in the actual mission that occurred on that day. She can't testify to that because she didn't observe it. So I don't believe that she has anything of relevance to offer the fact finding here to decide if my client's conduct is appropriate.
So noted. Thank you. You may proceed, Mr. Shin.
Good afternoon. Tell us your name.
Susan White.
Ms. White, how are you employed?
Right now I'm retired.
And on January 6th of 2023, how are you employed?
I was retired by then too.
Okay. And were you at Richneck Elementary School?
Yes, I was.
Why?
I was there for 34 years.
Okay.
And my last year was the year before
Right.
that happened.
And so I want to take you back to the year before that, which was that your final year before retirement?
It was.
Okay.
No, I'm sorry. I don't believe her answer was responsive to the question. There may have been a misunderstanding as to what was asked. So it definitely wasn't.
Okay, you can clear that up on cross-examination. You may proceed, Mr. Jenkins.
So during the course of your last year of teaching at Richneck, did you know a student who we're referring to as JT?
Yes, I did.
Okay, and as a reminder, we're not speaking the names of any students at all, only using initials. Whose class was JT in?
My class.
And what grade was that?
Kindergarten.
During the course of your time with JT, was there ever a discipline incident that you did report directly to Dr. Parker?
Yes.
I want you to start at the beginning of that incident that you eventually reported. So
I was confused too about why she was testifying if she quit working or retired the year before. She was his kindergarten teacher. She's going to show that they're going to try and show that he had a longstanding history of behavioral problems, maybe of violent incidents, and that he should have been watched more closely. That's what they're trying to do here.
what was going on that day that began that?
He had gone up. This was during post-COVID, so we had to be careful with distances and with masks. And he'd gone up to the front of another child's desk with his chair and put his face over about 3 inches from the other child's face. And so I had to think, what am I going to do about this? Because just telling him no, or you need to get back to your seat or whatever, those weren't working with him. So I slid the chair slowly so that if he wanted to get up, he could get up. And if he didn't want to, he could stay seated. I was going to bring it to his desk. But then he pulled the legs away and dropped them. And so I brought it up a little bit further just so I could be right in front of the class. and I sat there and I kept on teaching. Because
Okay.
I was still talking with the students.
Let me pause you for a moment so we can kind of visualize the scene. So when he is in the face of another student, how is he? Is he sitting, standing, or doing something else?
All right, I'm going to tell you why I object to this whole line of questioning, okay? This would go back to, if it was in the fall, the shooting happened January 6, 2023. If we go back to the fall of kindergarten, it would be the fall of 2021, okay? This was in a post-panty world. We can't say the C word in the chat. They don't like it here. And I'm talking about the name for the pandemic, okay? Don't even get me started on what happened in schools during this time, but she's trying to relate something that happened in a social distancing nightmare where these kids were supposed to stay, like, I don't know, 6 or 10 feet apart, right? That he went up into another student's face and that somehow that made him dangerous because of the whole panty thing. I don't know, but that's where it sounds like it's going. No, panty, like as in pandemic. Because he didn't social distance when he was 5 years old. Okay. Let's hear more.
The scene. So when he is in the face of another student, how is he? Is he sitting, standing, or doing something else?
He's sitting, leaning in toward him, staring him in the eyes.
Okay. And you testified that you pulled him away. Could you describe how you did that?
I slid the chair I was holding the back of the chair and I slid it back. We had no carpets at that time because of COVID. So it was easy enough to do.
Yeah.
And so he hopped off and grabbed the front legs of the chair and pulled them forward. But I was able not to fall, but to still hold on. So I could get it a couple feet further and I just sat on it.
So when he pulled the legs, had he stood up out of the chair?
Yeah.
Okay.
Oh, yeah.
So what happens after that point?
I was sitting in the chair and I was talking to the class, and not about behavior, about the instruction we were doing. And he walked up behind me and put both of his arms in front of my throat and locked them together and pulled back and down hard. I couldn't breathe. And he didn't let up on it. The only way I got out of that situation was the assistant, the teacher's assistant that I shared with another teacher, happened to be in there at the time. She was in the back of the room. So she came up and pulled him off with me.
Hold on. I got to hear this again. He put her in some kind of a chokehold. Hold on. The chat was distracting me for a moment. He stood up out of the chair. Okay. At this point, he's 5, maybe 4. I'm not sure. This is in kindergarten. Okay. Okay. There we go.
Because of COVID. So it was easy enough to do.
Yeah.
And so he hopped off and grabbed the front legs of the chair and pulled them forward. But I was able not to fall, but to still hold on. So I could get it a couple feet further and I just sat on it.
So when he pulled the legs, had he stood up out of the chair?
Yeah.
Okay.
Oh, yeah.
So what happens after that point?
I was sitting in the chair and I was talking to the class, and not about behavior, about the instruction we were doing. And he walked up behind me and put both of his arms in front of my throat and locked them together and pulled back and down hard. I couldn't breathe. And he didn't let up on it. The only way I got out of that situation.
So he tried to choke her. He tried to choke her. How did he not get expelled? This happened in kindergarten? Tammy says, former kindergarten teacher here, some of the disturbed children are extremely strong. We've had children in kindergarten attack police officers, among other things. I mean, he physically assaulted a teacher and tried to choke her out, and he's still in school. I don't know.
Was the assistant, the teacher's assistant that I shared with another teacher, happened to be in there at the time. She was in the back of the room. So she came up and pulled him off with me and took him out of the room. But until she pulled his arms off, I couldn't breathe.
What, if anything, happened with JT immediately after that? Does he remain in your room?
No, I wouldn't have had it. I would have left if he did. No, Mrs. Parker, my assistant, took him out of the room. But then sometime later in the day, and it got very blurry after that for me, so I can't tell you how long. One of our counselors and our security officer came and brought him back to my room.
So when you say, hold on, when you say brought him back, do you mean JT?
Yes.
Okay.
Yes.
So when
they
you
each had him, I'm sorry.
when you see him come back to your room with the counselor and school security guard, what happens?
They each had him by one hand, and they were trying to get him to move into the room. And he was yelling, no, I don't want to go back in the classroom. And I looked at them, and I had his back to the doorway so I could talk to them without everyone in the classroom hearing. And I said, well, he's right. He does not belong back in the classroom. What he did was severe enough for me to contact the police and to press charges. And the security officer agreed with me.
Okay, so what happens with JT next?
Well, they told me they were bringing him back to me because no administrator was available to handle the situation.
Okay.
So I said that if he was...
Okay. All right. I'm starting to think maybe the prosecution is throwing their case on purpose because this witness is very good for the defense. The defense is going to be, there were a million failures along the way. Everyone failed this child. We suspended him after the phone smashing incident. There are a lot of people to blame for what happened with this child. Why is my client on trial here? This was a year before. No administrator was available. Nobody would have this child, so I had to take him back. A lot of things should have been done. I don't know. This is making my my quandary harder in my brain.
Going to stay in there, I was going to need to leave the room.
Did you in fact leave the room?
I did, but not because of that. I believe they took him back out again, but it's very fuzzy.
Okay.
What I know is by that point I was so shaky that Mrs. Carter, my assistant, said, go ahead and take a break. And I took my laptop and went to the lounge and got the incident referral form because I wasn't going to leave school without reporting that.
Okay, so hold on just a minute. You've mentioned an incident referral form. Can you just kind of explain to the jury what that is?
That's if you think the discipline problem is dangerous enough or bad enough that you need to refer them officially, formally to the administrators.
And when you say the administrators, what titles do you mean?
Assistant principal and principal.
Okay. And who was?
No, I agree. The teachers were failed too. The teachers were failed too. Let's find out if it was Dr. Parker.
Was the assistant principal at Richneck Elementary School at the time that this happened?
Dr. Parker.
And is Dr. Parker in the courtroom right now?
Yes.
Could you just point her out, please?
She's right there.
Okay. Will the record reflect that she's indicated defendant?
I was not, can you point her out again? I didn't see your name. So no.
Thank you, Jim. So you've told us that you got an incident referral form, okay? And what did you do with it?
I filled it out and I typed up a whole description of everything that had happened that day because I had had some positive moments with it earlier. So I wanted those included too. So typed up the day and then I attached it to the referral form as the attachment and the explanation of the behavior. And then I went to the office and I saw that Dr. Goodman, the principal at the time, and Dr. Parker, they were in her office at the time.
And did you go into the office?
I went into the office. I told them everything that had happened.
Let me ask you this question. Did you have the incident referral form with you?
I had it in my hand.
Do you know who you handed it to or what you did with it?
I handed it to Dr. Goodman after I explained everything on it to both of them.
I understand. So after you explained everything that was on it, if you remember, did Dr. Parker or Principal Goodman react to that in any way? And if so, how?
Dr. Goodman did. When I was talking about the fact that if an attack is occurring, it should never be that no administrator is available to help with it unless there's a worse attack going somewhere at the same time.
Okay. Did Dr. Parker say anything or
No,
have
she was making eye contact. She was looking at me. She didn't say anything.
Okay.
Dr. Goodman said, sort of under his breath, prioritize. And I thought, well, yeah, that's what I wanted him to get from that. And then he told me to go to the nurse and have my neck checked out afterwards.
Okay. That year, did JT ultimately return to your classroom or not?
He did.
Okay.
He returned the very next day. He walked in with his breakfast.
Okay.
And I immediately went to the teacher across from me and said, I need to go to the office so that she would watch both of the classes. And she saw who I had with me, and so she understood. And I just told him, he had his breakfast with him. I said, just bring it, come with me. And so we went to the office and I had him sit down in the waiting area for parents there. And I went into Dr. Parker's office. And I knew at that time that my assistant had to stay in the first grade class all day because the sub hadn't showed up. So I would not have another adult in the room. So what I told her is, I cannot be the only adult in the classroom if he's in that room. And so either he needs to be somewhere else or I'm gonna have to take a sick day and go home.
And was he relocated or what happened?
He must have been, because I went directly back to the classroom and continued teaching for the day. I didn't see him the rest of the day.
Okay. At some point later in the year, does he come back to your classroom?
No.
If there were, and if you remember, any other discipline incidents you saw yourself and you reported to Dr. Parker yourself, are there any such incidents?
With him?
With JT, that's right.
No, I don't believe so.
Thank you so much. I don't have any further questions for you. Please answer any questions of the defense counsel.
I'm sorry.
Okay. Are you all right?
Yeah, I'm okay. I thought he was asking me. I'm
Oh, no, I
sorry.
just need a moment to confirm.
I'm going to scooch through their conversation with the defendant and with each other, the defense attorneys.
Ms. White?
This will be cross.
You just testified that you reported JT's behavior or his presence in your classroom to Dr. Parker directly when he came back the next day, correct?
Mm-hmm.
Okay. And then when you told her that, after that, he never appeared in your classroom again, correct?
Right. And I had heard. But
No, you don't have to tell me what you heard.
Okay.
So when you told her that action was taken and justice was JT was removed from your classroom.
He went to another school.
Okay. All right. Regarding the incident referral that you mentioned, do you know whether Newport News Public Schools retained a copy of it?
I was told they didn't.
Okay. And did you have to then supply it to someone else, your own copy that you maintained?
Yes.
No further questions.
And read the record.
Yes, Your Honor.
You went to another school?
Ms. White, I want to just direct your attention to the incident referral form. You've indicated there was a form. Was that the only piece of paper you submitted?
I submitted the referral form with the attached description of the day.
Okay.
So that I could get the full explanation of what happened, because this little place is not going to be enough.
Understood. And the a description of the day that you attached to the referral form, was it typewritten, handwritten, or something else?
Typewritten.
All right. If I showed it to you, would you recognize it?
Definitely.
May I approach the witness, Your Honor?
You may.
May I see the exhibit?
You may.
Sure. May I approach the witness, Your Honor?
You may.
What is it that I handed you?
You handed me the detailed description that I attached to the incident referral form. And
Oh, okay, and is what you're looking at now a true and accurate copy of the incident report as you wrote it?
yes,
Has anything been redacted from it?
well, yeah, but I did that myself for some that I gave to other people.
What was redacted? Is it a category? I don't know, I sort of words. Is it names?
Names.
Hold on 1 second, ma'am. What? Yes, sir.
Before she can answer that, objection, that document is hearsay, it's an out-of-court statement written, being offered for its truth of what happened on that day. She's testified as to what occurred. She's testified that she produced this incident report, but as far as the contents of that incident report, I'm objecting to it as hearsay.
The objection is premature. I haven't offered any evidence.
Agreed, premature, not yet right. You may proceed.
The redactions that appear are the redactions that you did.
The names, yes. I don't know what I had at the top.
Okay. Are you sure that that is the incident referral that you submitted attached to the form?
It looks like it.
Okay, it either is or it isn't. Take your time to read it.
Yeah. I was gonna say I write a lot, but yeah.
So is it the incident referral?
Mm-hmm.
Is that yes?
Yes, it's the attachment that I attached to.
Thank you. Judge, I am moving that now into evidence as Commonwealth 6 as a past recollection recorded for one thing, and also as a prior consistent statement, because the defense was alleging that or suggesting that it didn't exist, essentially, in cross-exam.
Your Honor, there was no such insinuation that it didn't exist. So that's number one. It's still hearsay. Is duplicative of her testimony in all the previous objections that Mr. Rogers lodged. And it goes beyond, I'm sorry, Your Honor, it goes beyond my redirect as well. I mean, my cross-examination.
And also, how is this not bolstering? How is this permissible bolstering? She testified to what she recalled happened, I think it was a year before.
Yes.
So, I'm talking to the attorney.
I'm sorry.
She testified to what she believed happened to a year before. Why are we allowing in her written statement, her redacted written statements about that?
Because defense counsel asked whether she gave it to the schools and whether it still exists. And I'm establishing that it does.
Okay, so I guess you're interpreting that as an attempt to impeach. And so you're trying to rehabilitate?
If the objection is hearsay, there's an exception to that. If we want to talk about why it's relevant at this stage, yes, we can go to the relevance rules and find that a prior consistent statement does become relevant when on cross-examination, or does become admissible when on cross-examination the witness has been challenged as to having a memory or forgetting something. I can find her rule.
And again, I understand that's where the impeachment comes in, but that's the missing link for me. So the saying it does not come in, and you may approach to retrieve the document.
Thank you, Judge.
Thank you.
So I thank you. I don't have any further questions for you.
Anything further? Okay, and the status for this witness? May she be excused?
I'd ask that she be released unless I'd ask to be released.
Oh, and no objection from defense. Okay, so that means thank you for your testimony today. You are released as a witness. You don't have to go back to that room. You do not have to stay in the courthouse. You are welcome to remain in the courtroom if you'd like. Okay, so watch your step in. Thank you very much. Next witness.
Commonwealth calls ROLONZO RAWLES.
This is another teacher in the building. One of the teachers who they're saying told Dr. Parker that JT had a gun. We'll see what he testifies to. Wait for him to scooch.
Raise your right hand, sir. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Please take a witness stand, sir. Watch your step, and you can adjust the chair and microphone as you need. You may proceed.
Good afternoon. Would you please tell us your name? Mr. Rawls, just a quick reminder that we're not using the names of any children today in court. We'll use initials in place of that. Mr. Rawls, in January of 2023, how were you employed?
I was a school counselor.
Where?
At Newport School at Richneck Elementary.
Can you hear him? He's a school counselor. He's not a teacher, but he is one of the other school personnel who allegedly told Dr. Parker the child had a firearm. He's a low talker as well. Tell me if you think he needs a boost.
All right. And how long had you, as of the January 2022 or 2023, I'm sorry, how long had you been at Richneck?
It probably would have been between that time, it would have been like a year and a half.
Okay.
Not quite 2 years.
And during the course of your time at Richneck, did you come to know a student who we'll refer to as JT?
Yes.
And in the course of your duties, did you receive an assignment related to JT?
Yes. In his second year at Richneck, I was assigned to kind of be like his one-to-one within a set schedule.
How did that assignment come about, if you know?
I don't recall in its entirety. I do believe that originally, because he was having some issues, they were trying to put a plan in place to help him to adjust into the school and be more productive. So I believe the administration came with a plan up, and they administration need to help him out with that plan.
Tell us how, if you could just describe for the jury how the one-on-one assignment worked. What did you do?
Well, in the morning when he got off the bus or was dropped off, I would proceed to have a morning session with him, kind of set goals and plans for him in the morning. He would then go to one of the, I believe it was one of the SPED teachers to kind of reiterate those plans. After that, he was working with Mrs. Kovac on some things like reading assignments. She was a reading specialist at that time. And then when after her time was up, I would come back, retrieve him, and I would take him to the classroom. I would be with him in the classroom.
Okay. And Did you ever speak to Dr. Ebony Parker regarding this assignment with JT?
My recollection, I don't recall. I just remember this has been a request to have me.
Okay. Do you know of any behavior issues that JT exhibited?
Yeah, his first year there, he exhibited a variety of different behavioral issues where he was out of the classroom or taken out of the classroom for whatever case may be, but it varied from time to time.
Okay. Mr. Rawls, do you know what an SST is?
Yes.
Okay, what is that? Can you tell us?
Student support team. It was basically a process or a program to put in place to help to assist them in trying to once again be more productive in the school system.
And did the SST plan involve regular meetings?
Yes.
Did JT have an SST plan?
They were in the process of moving forward with SST because I believe they were trying to transition that SST into more like an IEP, which is like a more specialized support system for students and what's called the spaces.
Okay. And who all was involved in the SST process for JT?
I was currently at that time under Newport Public Schools, the policies, counselors were one of the main people that ran the SST process. Administration would be involved when available and things of that nature, but it was more so put on responsibility of the counselors.
Okay. And so at those SST meetings, who would typically attend JT's SST meetings?
It would be either the principal, the AP, myself, or another counselor, a parent, and if they had any advocates that were willing to be part of the meeting. That's how kind of group of people would be.
Were parents and guardians of children invited to attend those as well?
Yes, of course, yes.
You've mentioned principal and AP. What's AP?
Oh,
thank you. And as of JT's SST, who was the principal at the time?
During the time, the principal.
I'm sorry, I put you on the spot.
I can't remember.
Okay, do you remember who the assistant principal was at that time?
Dr. Parker was doing the SST process in that second year, yes.
Okay. Did Dr. Parker sometimes attend the SST meetings, if you know?
I believe she may have attended some, yes.
Okay. Did there come a time when you decided you no longer wanted to, or maybe that you no longer thought it was useful to have that one-on-one assignment?
Yes, because.
Hold on just a moment.
What happened? I heard something. Object leading. Okay, response.
I'll rephrase the question.
Thank you.
Did you ever decide that you did not want to continue the one-on-one relationship with JT?
As a school counselor.
Okay, same objection?
Yes.
Response?
I asked, did you ever decide that you didn't want to continue the one-on-one relationship with JT? He's already established the foundation that he had the one-on-one assignment. And did you decide is a question he can answer yes or no? He did decide it or he didn't. I'm not suggesting which of those answers is the right one, so it's not leading.
Okay, I think the leading part is to just continue the relationship with JT. So I think the proper phrasing would be, did you decide whether or not to continue or discontinue a relationship with JT?
Thanks, Judge.
So if you could ask that, or do you want me to just?
Go ahead, Judge, if you would like to ask the question.
Did you get the question?
Yes.
Okay, can you answer? Thank you, sir.
It wasn't really a decision of sorts. It was a request. As a school counselor at that time, I had many students that I had to serve, and I felt like it took away my opportunity to service a lot of the other students within the building. So I had a request that if I could be relieved of that duty, so I could also service the other students. Besides, I could still assist. I heard it needed to be done with JT, but I also wanted to be able to service the other students within the building as well.
Thank you. During the time that you were working one-on-one with JT, did you experience behavior issues or witness behavior issues?
Can you repeat the question?
During the time you were working with JT, did you experience or witness behavior issues?
When we were more one-to-one, it tapered off more. He still had concerns here and there, but he knew the relationship we had, me being his one-to-one, that I would be there to help to correct or redirect a lot of his behaviors.
And what were the behaviors that you observed of JT at any point that year?
Non-compliant, defiant behavior, refusal to do work, yes, acting out of sorts where he wasn't following directions, things of that nature.
Would those issues ever be discussed at the SST meetings?
At times, yes.
Okay. I'd like to take you to January 6th of 2023. You remember that day?
Yes.
What is the first moment that you realize something might be up with JT?
Objection, leading, assumes, fact, finding evidence.
I'll rephrase. On that day, did you ever notice anything unusual about JT?
On that day, I didn't even really witness him that day until later. That was in that evening of the afternoon of that day.
Okay. Did you eventually become aware of a crisis that occurred that day?
It was brought to my attention that after dealing with another student, that something had took place at recess where JT apparently told another student something.
So I understand it's hearsay. Let me walk through that with him. During the day on that day, did you have occasion to speak with any students?
Yes.
And were there any students who shared a concern related to JT?
Yes.
Now, without telling me what the student said, did you describe the student's demeanor, how they appeared at the moment they were telling you the information?
They were very emotional, very sad.
Okay. Again, without telling us what was said, were they referring to something they had just experienced or seen?
I wouldn't say they just experienced it, but they experienced it in an earlier time where they still holding on to that it was taken.
Okay. And with that information, without telling me what was said, with that information, where did you go?
With that information, where I went is I went to Dr. Parker to address the allegations that I heard.
Okay. Did you ask Dr. Parker to take any action?
I didn't ask her to take any action. It was presented to me that some action was taken at a particular time with something else. And then I requested her if I could take some action.
Okay. And what action did you ask Dr. Parker to take?
I asked her if I could take action of trying to search or to check the person of JT.
And what did Dr. Parker say anything?
She responded by saying that at the time, because of the scheduling he had, his parent or parental guides would be coming to get him so that we could hold off at that time.
Okay.
So we're clear. His testimony is these children told him something. The prosecutor tried to get that in under an excited utterance, but the witness said, well, it wasn't close in time. It was earlier in the day. So it didn't come in what the children told him. We're going to assume the children told him that they thought JT had a weapon, but that's not allowed in right now. He says he went to Dr. Parker and he asked Dr. Parker if he could search the person, the body, not the backpack, if he could search the body of JT. And she said, no, his mother's coming soon. Let her do it. That is big. You can't get it in, what the kids told him. Congratulations, blessed mom from Texas, on your daughter, Reagan, graduating from 5th grade. And you've been here for 2 years. And thank you so much for your loyalty. I love you so much. And we've already learned they're not allowed to search the children, correct? Not allowed to search their bodies.
The concern and the desire to search JT, did you share your concern without telling us what was said? Did you share your concern with anyone else?
The only person as I shared my concern with is when I went back to speak to Mrs. Zwerner after I spoke to Dr. Parker.
Okay. Mr. Rawls, at the time that you asked Dr. Parker for permission to search the person of JT, did you believe that you had the authority to do that without an administrator's approval?
You know, in my previous experiences, you just can't, in my position, you just can't search a student without some type of permission.
Okay.
He's saying, according to his experience, you have to have permission to search the kid. Only an administrator can search the child, not just the child's possessions, principal and assistant principal. Well, the policy and procedures
And
manual.
finally, Mr. Rawls, as you sit here today, do you wish you had done differently that day?
Shut up. Objection.
Okay. Thank you. I don't have anything further.
I mean, shut up to the witness. I meant to the prosecutor. Do you wish you had done anything differently that day? How does that? Okay, whatever. I'm just gonna let it go. Here comes Cross. And it is freezing. Hold, please.
Good afternoon, Mr. Wells. How are you? Good. Hopefully I won't keep it too long. So on January 6th of 2023, you were the school counselor at Richneck, is that correct? Okay. And so at some point, was it at the very beginning of the year, did you assume the responsibility of having the one-on-one contact with JT?
Not necessarily at the beginning of the year, no, sir.
Okay, but at some point you began one-on-one contact with JT, is that correct? Okay, and how were your initial interactions with JT? Were they positive, or was it a challenge?
At times it could have been a challenge, but we built it before, a year before, where it wasn't as difficult for myself.
Okay, and so over a period of time, his behaviors began to get better, is that correct?
I would say yes.
Okay, and you were part of the SST team, is that correct?
Yes.
Okay, and you function as a counselor as a part of that team?
Yes, counselor coordinator.
Okay. Would you say that you were in a pretty good position to assess how JT was doing on a given day?
I would say yes.
Okay. And would you say that you had more contact or less contact with JT than Mrs. Kovac, the reading specialist?
I would say we probably had about
About the same amount of time? Okay. And at some point, you indicated that you requested less one-on-one time with JT?
Yes.
But it didn't sound like it was because he was doing better, but it's because you wanted to be able to help more students at the time. Is that correct?
Yeah, from my standpoint, point of view, is to be able to be more accessible to students.
Okay.
I just get a pop-up. Here's just one example of misreporting. I just get a pop-up from Court TV. They must have clipped a little piece of the kindergarten teacher's testimony, but the headline says, it's Court TV video on YouTube. It says, teacher claims first grader choked her before shooting. Can anybody in the chat point out to me why that's wrong? It was a year or more before, and it was the kindergarten teacher. Teacher claims first grader choked her before shooting. Is it just me, or is that a little bit misleading, to say the least?
Okay, if you could speak up and tap that microphone, let me see if it's on. Okay, talk into it so that the reporter can get your words down. Thank you. So if you repeat your answer.
Oh. Can you repeat the question?
So it got to a point where you were spending less time with JT. The motivation for that was to be able to spend more time helping, I guess, more students and more people than just JT. Is that correct?
Yes.
Okay. All right.
Go ahead, and I know we're hearing that mechanical squeaking now.
So-
We think it's a chair, so just,
Oh.
well, you know where it came
No,
from?
it wasn't a chair. It was a voice or something like that.
Well, do you know where it's coming from or feedback?
It seemed to be from my right.
Oh, okay. So again, there are other courtrooms and other lockups. We can't do anything about this noises. I'm sorry. Just ignore them. These things on the wall, these are sound panels. So we have as many as we can have, as you see, to absorb all the sound. So we'll just have to do our best to move forward.
Thank you, ma'am.
Okay,
I
repeat your
understand.
question, please.
So my next question is, do you when you began to have less contact with JT based on your request, did you think that was a good move for JT? Do you think that may have been detrimental to his progress?
I can't really answer that.
Okay. But based on your position, you thought as far as resources, you needed to have contact with more students. Is that correct?
Yes.
Okay. Maybe it's the. That's what it is.
It's squeaky something. Maybe it's the door. We have a WD-40 emoji for that, believe it or not. When you hear the squeaky door, the squeaky chair, we've got one. Don't worry, I got you.
That's what it is. So I'm. Maybe it's the.
Squeaky, squeaky.
That's what it is. So I'm the source of distraction. So after you decided to have less time with JT, did you notice any kind of degrade or in his behavior?
Not necessarily, because another plan was put in place to kind of, I won't say replace me, but to try to subside my
Describe that go around or that next plan.
For the next plan, from my understanding, was that authoritative figure within this family would be able to come in to assist and support him in his times process.
Okay, and so you actually observed that next phase of the plan with JT. Okay, and did that next phase seem to cause improvement with JT's behavior?
As far as I know, once again, once I was alleviated from that, I wasn't so hands-on, but I would say it seemed like he was kind of improving, yes.
Okay, so were there less calls from a teacher or from an administrator for you to respond to JT due to bad behavior?
I said, yes. It was less calls to me, yes.
Okay, all right. Now let's talk about January 6th. Did you have contact with JT on January 6th of 2023?
Later in the afternoon, yes.
Okay.
After the shooting?
I observed him.
Okay. You said not direct contact, but you actually observed him. So as a result of hearing information, you decided to go and place your eyes on him, is that correct?
Yes.
Okay. And when you placed your eyes on him, was he in the classroom or was that on the playground? Where was he at? In the hallway?
I placed my eyes on him, he was in the classroom.
Okay. And when you placed your eyes on him, did his behavior that you observed, did it cause you concern?
No.
Okay. Did he seem like it was JT, his normal behavior? Is that
Actually, it seemed abnormal behavior. He was way calmer than he normally was.
Oh, okay. So
He was way calmer than he normally was when he laid eyes on him in the classroom.
So he appeared calm. How long did you observe him?
It was a few minutes. It was long.
Okay. And during that few minutes, JT was doing okay. Is that correct?
Yeah.
Okay. And so is it safe to say that you may have had some concerns for JT's safety or anybody else's safety, and that's why you you wanted to put your eyes on him. Is that correct?
Well, not at that time. At that time, like I said, it was that normal for the behavior of being that calm in that setting.
Okay.
But I didn't have any concerns of him.
Okay. So you put eyes on him, and you were satisfied that JT was doing well that day. Is that correct?
What time was this?
Do you did you have contact with him directly or indirectly after that?
No, I did not.
Okay. So you did not observe any behavior of JT on that day that made you believe that JT presented a threat of danger or harm to any of the students. Is that correct?
That's correct.
Okay. And I believe through.
Well, it felt leading because it's cross-examination and he's allowed to lead on cross. I know, we're all confused because we don't know who's who. We don't know the prosecutor, the defense. This is the defense cross-examining this witness. He's allowed to lead.
The questioning, it seemed like there may have been an indication that there was some additional feedback that you received. Is that correct?
Yes.
Okay. Did that cause you to need to put your eyes on JT again?
The initial feedback that I received had me concerned about what was being said, and that's when I wanted to address it with Dr. Parker and things of that nature. The only other time that I saw JT, and I don't even recall really seeing him, particularly when I went back in that classroom. I don't remember actually seeing him at that time.
Okay. Okay. And do you remember the timing of that when you went back into the classroom?
Once again, it had to be between the hours of 12:45 to 1 something.
Okay.
But I don't recall the exact time.
Wait, so that would have been after recess, I think, right? Well, hopefully he'll clarify it because we're all confused.
At any time, did you feel like that you needed to step in and pull JT out of the classroom?
Only time that I felt after hearing the feedback that I would receive, and then once again I was, told to hold off on that.
Okay. Did you agree with that decision?
At the time, I felt like it was the decision that was made, and whether I agree with it or not, I was just there to be a support. When I came back to the classroom, I spoke to Ms. Zwerner, I told her what was said, I just told her that I would be there if she needed me.
Okay. When you left Ms. Zwerner, did you feel like you were leaving her in extreme danger, or the students in extreme danger?
No.
Okay. When you walked away from that class, you were at peace with JT's behavior, what was going on in the classroom. Is that correct?
Yeah.
Okay. Now, so when the actual incident occurred, did you immediately think that, oh no, JT has shot somebody?
No, when they went into lockdown, I thought it was a drill originally.
So you were shocked.
Okay, Law and Disorder 101 says, again, is Parker being held without bail? I don't know. I guess you're addressing me because I didn't stop the feed to address your question. I never saw it because I'm not watching the chat when I'm trying to maintain volume and everything else we've got going on here. I think she's on bail. I don't really know. We fell into this trial. If anybody knows for sure, I don't think that she's being held without bail. Dr. Parker, that is. I also don't know when exactly she was charged. Two things I would like to know. So if you know for sure, without guessing or going to Reddit, whether Dr. Parker has been held without bail, I don't think so. I think she's been out. I'd also like to know when she was charged. Was she charged before or after the verdict in the criminal case? I mean, the civil case.
Did the incident actually occur? Is that correct? That's correct. Even with the earlier feedback that you received, is that correct?
That's correct.
Okay. You did not think that you needed to take any action to prior to the incident to separate JT from the classroom. Is that correct?
That's correct.
Separate his classmates from him. Is that correct?
That's correct.
You didn't feel like you needed to call the police? Okay. All right. If you believe that there was a gun, do you understand that it was your responsibility to separate JT from the classroom?
Yeah, I mean, that would be my responsibility.
Okay.
Definitely it was.
Okay, and it would also have been your responsibility to contact authorities, is that correct?
Correct.
Okay.
All right. So he's saying that it would have been his responsibility to separate him from the class if he thought he had a gun, and it would have been his responsibility to call police. He says both of those things. And he's the counselor. He's not the classroom teacher who's with him all day long. He's only with him for certain periods of the day. See what the defense is trying to do? They're trying to say Abby Zwerner, his classroom teacher, was just as liable because she could have separated him from the classroom. And maybe then she wouldn't have been shot. And then maybe all those other children in the classroom wouldn't have been endangered, because that's what this case is about. It's not about the child shooting Abby Zwerner. It's about the endangerment of the children in the classroom. And she also could have called the police. And so could have 4 or 5 other teachers that thought he might have a weapon. I mean, that's his theory. Let's hear that again. So you were shocked that the incident actually happened here.
The incident actually occurred, is that correct?
That's correct. When they went.
Has shot somebody. Oh no, JT has shot somebody.
No, when they went into lockdown, I thought it was a drill initially.
So you were shocked that the incident actually occurred, is that correct?
That's correct.
Even with the earlier feedback that you received, is that correct?
That's correct.
He was shocked. He thought it was a drill. He didn't think it was foreseeable either. That's what I'm getting from this witness. He seems like he's telling the truth. I like him as a witness. I think he's making a great appearance. I think he seems credible. $4,000 secured bail, says Tiff. Thank you, my dear. Isn't Abby being just as liable irrelevant? The question is if Dr. Parker did enough, not anyone else. Well, no, the question is, is Dr. Parker criminally liable, criminally responsible, criminally? And a jury may say amongst themselves, listen, there's a lot of things a lot of people should have done. Why is this person sitting in the defendant's chair? Or they may have the opposite reaction. Well, it wasn't anybody else's responsibility to do anything about this child. The entire criminal liability falls on Dr. Parker. But again, there was a civil trial and there was a civil verdict of $10 million against Dr. Parker on behalf of Abby Zwerner. The question is, does this rise to criminal liability? First time ever, a school administrator is being charged with the actions of a school shooter. Slippery slope, or it's about time? You tell me your thoughts.
You did not think that you needed to take any action prior to the incident to separate JT from the classroom. Is that correct?
That's correct.
Separate his classmates from him. Is that correct?
That's correct.
You didn't feel like you needed to call the police? Okay. All right. If you believe that there was a gun, do you understand that was your responsibility to separate JT from the classroom?
Yeah, I mean, that was your responsibility.
Okay.
Definitely it was.
Okay, and it would also have been your responsibility to contact authorities. Is that correct?
Correct.
Okay. You had been involved in previous incidents when JT was removed from the classroom. Isn't that correct?
Yes.
Okay, just a couple days before that. Okay, you were involved in that incident.
Yes.
Okay. You removed him from the classroom.
Yes.
The incident wasn't something that caused danger or harm to his classmates. It was, a cell phone was broken. Is that correct? And that resulted in him being taken to the office. Is that correct?
Yes. Yeah, it was just
Okay.
struck up a little bit. Nothing major.
Okay. So, as a staff member, even on that day, you understood it was your responsibility, if you thought that there was a threat to the students, to remove the threat or the students from that danger. Is that correct?
Objection asked and answered.
Yeah, that's fine. Ronna, can I have a moment?
Yes.
Okay, semantics, but I'll address this. 10 Curio 6679 says she's not being charged for school shooter's actions, Melanie. She's being charged for failing to act. It's the first time a school administrator is being charged in connection with a school shooting. Better? In connection with. That is a more correct statement, but I see what you're saying semantically. He didn't, I think he just said, yeah, that's fine, because he already got the question that he already got the answer that he wanted.
Judge.
Yes, sir.
Just so that I understand the timeline of events, you testified on cross that you went and put your eyes on JT. Do you know if that was before or after you spoke with the student and it caused you to go to the assistant principal?
No, before.
It's before, okay. Do you know roughly how long before you spoke with that student?
I do not recall.
Okay. Would it have been more than 2 hours?
It was earlier that day.
Okay. And what were the initials of the student that you spoke to?
I don't remember the first initials are.
Okay, thank you. I don't have any further questions, Judge.
So what caused him to go lay eyes on JT? Just keeping an eye on him?
Hello, Mr. Rawls. You just mentioned speaking with a student with the first initial of R. Did you ever tell Dr. Parker what R had said to you?
I believe I mentioned what he had mentioned to me, yes.
You believe you did. Do you know for certain whether you did? Okay.
He doesn't know for certain whether or not he told Dr. Parker that the kid told him that he may have a gun. Do you hear that? He doesn't know for certain if he said that to Dr. Parker. Prosecutor's case is falling apart before your eyes, in my opinion, maybe. Listen to that again.
I believe I mentioned what he had mentioned to me, yes.
You believe you did. Do you know for certain whether you did?
No, I don't know for certain, no.
Okay. Would you be surprised if you did not do that?
I wouldn't be surprised.
Okay. No further questions.
I wouldn't be surprised. So there's one down. He can't say for sure that he told Dr. Parker that some kids told him that the 6-year-old had a gun. All right, cross him off the list. He can't say it for sure. The only person who says that for sure right now is Miss Kovac, right? And maybe Miss West. We didn't watch her testimony yesterday. That was one of the things we did not get to yesterday.
Further from the Commonwealth.
Judge, based on that, I'm going to need a couple of minutes
Okay.
before redirect, I guess.
All right. So we'll take this is a good time for stretch break and after lunch restroom break.
Never know what a jury's going to do.
Let's come back at 3:35. Sir, so you're still in oath, but you can step down and retire to the witness room, and we'll bring you back out, and we'll have the jurors go back to the jury room. Thank you.
All right. Hopefully we have some time to FF through this entire break, as we should be getting toward the end of the day soon in this Virginia courtroom. This trial is supposed to wrap by Friday. We'll see how it goes.
You all may have a seat. Thank you. All right. You may resume your redirect. I'm for sure. Redirect or redirect?
This is redirect. Yes.
Quick.
Mr. Rawls, thank you. I believe you indicated to the defense counsel that you didn't remember what you had told or whether you told Dr. Parker about the incident. at the time you asked for permission to search the backpack. Is it true that you don't remember that?
It's been a while, so I don't
Sure.
know.
Understandable. Did you give a statement to police in this case?
Yes.
And if I were able to provide you with a transcript of that, might it refresh your memory about what you said to Dr. Parker? Okay. May I approach, Judge?
Okay, yes, and you responded yes, correct? Okay, and he nodded his head, I just wanted to make sure it was recorded.
Thank
Yes,
you.
you may approach.
Rehab time. It's going to show him his transcript of the statement he gave police.
This document, to take a look and read there where I put a pink post-it note. And after you're done reading, look up and I'll ask you a question.
That's it.
Don't read it. Yeah, sorry. Read it to your. Just read it silently, and then I'll ask you a question about it. Sorry.
I'm going to need a soundboard and a sound mixer.
And does that refresh your memory about what you said to Dr. Parker regarding the incident?
To an extent, yes.
Okay. Would you just tell?
He just said to an extent. Yes. So not really.
And does that refresh your memory about what you said to Dr. Parker regarding the incident?
To an extent, yes.
Okay. Would you just tell us then what it was you said to her?
I'm looking at the witness. At this point, he looks like he's looking at the page, and he's going to be looking at the page and then advising. So his memory has been refreshed.
I'll take it back.
Okay.
I'll go get it. May I approach?
I'll take it
I
back.
want this done properly. Yes, Your Honor.
Yes, may I approach?
You may approach.
Thank you.
Yeah. You're supposed to refresh their recollection with the document and then take it away. And then they testify. This is such a cluster F. It's a cluster duck. I'll take it back. Fine. You want it done correctly? Fine. Fine. I'll do it correctly.
Ultimately, pardon, the legal principle is you can't read from that statement. You can refresh your memory, but you need to testify from your memory. Okay.
Based on now that's refreshed, if he has an independent recollection.
Well, he said to an extent, so we'll flush it out, and we'll give you an opportunity to cross. Go proceed, Mr. Jenkins.
Having refreshed your recollection, do you remember what you said to Dr. Parker prior to asking to search the backpack?
When I spoke to Dr. Parker, it was already relayed to me that a book bag was searched from JT and that nothing was found within the book bag.
Do you remember?
Okay. He's saying it was relayed to me that a book bag was searched and there was nothing in the book bag. That's what he's remembering. That's what his recollection was refreshed about. Well, no one's asked for permission, but I'm going to grant permission for you guys to use the boss baby emoji for Prosecutor Jenkins. Motion granted. I feel like we're being punked too, but listen to what he said. Did it refresh your recollection as to what you told or what you said to Dr. Parker? Here's what he says.
From JT and nothing.
What you said to Dr. Parker prior to asking to search the backpack?
Listen.
When I spoke to Dr. Parker, it was already relayed to me that a book bag was searched from JT and nothing was found within the book bag.
Do you remember if you confirmed with Dr. Parker that you and she knew what you were talking about? Or who?
I know enough that we confirmed that we thought something may have been in the backpack, yes.
Okay, thank you. I don't have anything further.
Again, the backpack was empty.
And Mr. Rawls, and from what you just recounted, nothing was in the backpack, correct? It had been searched and nothing was there, correct?
That was told to me, yes.
Okay. And at that point, you did not believe there was any credible threat, correct?
Objection asked and answered on recross.
Oh, I'm going to try the question, Your Honor.
All right, thank you. All right, anything further for this witness?
No, Your Honor.
All right, and the status for Mr. Rawls. May he be excused or does he need to remain?
I'd ask, oh, I'm sorry.
No,
I'll follow you.
I'd ask that he be released.
Oh, no, we're gonna ask that he be released.
So we're going to ask that he be constructed. I agree to that. We'll ask that he be constructively sequestered, remain available for recall.
Are you, is that suitable to the defense?
Yes, sure.
Okay, and do you all have his phone number?
No, Commonwealth happened.
Absolutely, I do be happy to.
Don't publish his phone number in open court.
Okay, so Mr. Rawls, what that means is you are still a witness. You still have the ability to be recalled. So do not discuss this case, do not discuss your testimony, but you do not have to stay in the courthouse, you do not have to stay in the witness room. You can leave and go about your daily business. You will either get a phone call, 1, to come back to the courtroom, or 2, that the trial is over and that you are no longer a sequestered witness. All right, any questions, sir? All right, thank you, you may step down. Next witness.
Thank you. I'm learning that Dr. Parker was charged in April 2024, about a little over a year after the incident. It took that long for them to charge her. And that was before the verdict in the civil case of $10 million, which I think the verdict came down in November 2025. Many of you are telling me, Peter Tragos, at Lawyer You Know, covered the civil trial. I did not watch it.
Megan DeLeon.
All right, Mr. Rawls, nice job.
All right, you may proceed.
Good afternoon. Would you please tell us your name?
Megan DeLeon.
Ms. DeLeon, do you have a daughter?
I do.
I want to just caution you, and I know we've discussed this, but during the course of this trial, we're not using any children's names, only using initials or referring to your daughter if you prefer. Back in January of 2023, was your daughter attending school?
Yes.
Where?
Richneck Elementary.
Is that here in Newport News?
Yes.
And what are your daughter's initials?
Asst.
On January 6th of 2023, did you become aware of an incident that caused you to go to the school early?
Yes.
And when you got to the school, did you immediately see Asst, your daughter? Do you eventually see her that day?
Yes, when they bring her out to me.
Okay. When you first see her, describe, without telling me anything she said, just describe her demeanor, how she appeared to you and how she interacted with you.
Initially, she just seemed happy to see me and her dad. It was later on in the evening when she kind of showed different behaviors.
By different behaviors, you mean different than prior to the events of January 3rd? Describe what behaviors you observed.
Just that evening, it was a very hectic day, so we just ordered a pizza in and just tried to put some show on to kind of, but the doorbell rang just with pizza and she just got very scared, jumped from her seat, the sound of the doorbell and other sounds like that for many months to come just scared her.
What kinds of sounds would scare her?
Slamming of the door, I know, just loud bangs. She described the sound as a ladder falling when the gun went off. So loud sounds have startled her.
No, I'm going to object to her statement. Sounded like a ladder when the gun went off. Sounds like she's just finding some sickness that, as she may have stated, if that's what she has done, I'm objecting to the hearsay.
If the request is to strike sounds like a ladder when the gun went off, I agree to that.
Okay, so substruct, don't consider that, please. Next question.
So what other behavioral changes, if any, related to SD did you notice in the immediate days and weeks?
Not understanding why this happened. She loved her teacher. The teacher was kind, and she just understand why anyone wanted her.
And who was her teacher, if you know? Okay. So
her daughter was in the class where the shooting happened. And again, because these criminal felony charges are against Dr. Parker for child endangerment, they have to show that the children, at least 8 of them, suffered some sort of injury as a result of her alleged, we're going to go through the statute again, but they read it once in court, her alleged, failure to act, putting them, recklessly endangering them. And so her daughter doesn't like loud noises, and she's having trouble understanding what happened.
Ms. Zwerner, was Ms. Zwerner's classroom her homeroom?
Yes.
Okay. As a result of what you observed with SD, did you seek help for her of some kind?
Yes. We went to just regular counseling through our insurance, and then also spiritual counseling through my church.
And how long did that go on for?
6 months.
Strong objection, relevance.
Agreed.
These are the injuries that the neglect caused, the trauma to the children.
She's not a
I believe
doctor.
that is-
She's not a doctor. She cannot testify as to any diagnosis that she received through a regular counselor, through the insurance, or a spiritual counselor. She's the parent. This is wild.
It's relevant.
So I'll allow it, but do you have additional questions down this line, or do you have additional questions in this line of questioning?
Only to elicit any additional different things that she noticed in her daughter. That's it.
I'll allow it. You may proceed.
Okay. We're from January 3rd to present. Any additional
January
things
3rd?
you've noticed in your daughter that
Wasn't it on January 6th?
were not present prior to the January 3rd incident?
She's very, she doesn't want to talk about it. She keeps everything close hold. She holds in a lot of feelings and emotions. Recently, she went back to counseling because it's the time they said to start doing. They get to give her some time and re-engage with the counselor, and they said that she has depression, anxiety, and one other thing where she's always on alert.
All right. Thank you. I don't have any more questions for you, but thank you.
This is Cross. Do you two have a civil suit against the district? That's what he's going to ask.
Good afternoon, Ms. DeLeon. You were never inside of Richneck Elementary School on January 6, 2023, correct?
Building? No.
Okay. And you did not encounter your daughter in the building, correct?
Right out front. No, they brought out to me.
Okay. You filed a civil lawsuit arising from the events of January 6, 2023, correct?
Yes.
In this courthouse, correct?
In this courthouse, well, through Newport News, yes.
Okay. That's a pending lawsuit in Newport News Circuit Court, correct?
Yes.
Okay. And you've named Dr. Parker as a defendant in that case?
Well, I prefer not to talk about my opinions of the case.
Well,
it's more
I'm
personal.
going to object, Judge, and ask that we not talk about a child's civil matter on TV, that we have not continue the broadcast while she's speaking about the civil suit that is her child's, really, not hers.
Mr. Prosecutor, Mr. Boss Baby, you brought out on direct examination all of the injuries that this child has sustained. Her counseling, her spiritual counseling, the fact that loud noises bother her, that she won't talk about it. You brought out all of those things about this child on direct examination. But now that the defense is trying to point out that this witness probably has a vested interest in convicting the defendant because it will make her civil case better, you've got a problem with it. This goes to bias. She's got a financial vested interest in having Dr. Parker convicted because it makes the civil case much easier. The only civil case that I know of that has been tried to verdict was Abby Zwerner versus Dr. Parker and the school district. The school district was released from that case because of workers' comp. You can't sue your employer for an on-the-job injury. Abby Zwerner was the teacher, and so the verdict for $10 million is against Dr. Parker. Now it seems that some of the parents of the children who were in the room, and not even in the room, in the safe room, have also sued the district and Dr. Parker, and I don't know who else because I don't have the lawsuit. And they've got a vested interest in finding her guilty or in having her found guilty by a jury. And this is all permissible. We are in the real world. In any other courtroom, this would be permissible. But now, yes, now Boss Baby wants to be hyper vigilant about talking about the children's lawsuits. First of all, children can't sue. The parent sues on behalf of the child. So there's that. Let's see what the judge decides, because you never know what you're going to get.
Ruling will be the same as earlier, so the objection will be overruled. She's been cautioned that we're only using initials, but the question.
January 6, 2023.
Well, law and crime does that sometimes. They just jump forward at a certain part of the day. And this was the part of the day in which they did that.
'23, correct? Good afternoon, Ms. DELEON.
All right, well, a bit after this, hold on. Oh, sorry to blast your ears out. I apologize. Hold on.
On TV, speaking about the civil not continue.
Let's listen to Boss Baby's objection.
That we have, that we.
Well,
I'm going to object, Judge, and ask that we not talk about a child's civil matter on TV. That we have not continued the broadcast while she's speaking about the civil suit that is her child's, really, not hers.
The court's ruling will be the same as earlier, so the objection will be overruled. She's been cautioned that we're only using initials, but the question party has a right to cross-examine about interest in the case. And if you just ask who the named parties, not what your opinion is. And I think you said I prefer not to share my opinion on it. So non-responsive as well. Repeat your question, Mr. T.
thank you, Your Honor. In that civil lawsuit, you have named Dr. Parker as a defendant, correct?
Yes, please.
Okay. And you are seeking money damages from the defendants in that case, correct?
I'm more seeking justice for my daughter and what she went through.
And you are seeking money damages from the defendants in that case, correct?
Yes, there is settlement and discussion with that, yes.
Oh, there's been
Yes, but the loss, I know there are settlement discussions. I'm sure there are.
there have been settlement discussions. Oh, she's telling us everything. Shan Pickle, I know you're not new here, so I don't know why you would be like directing viewers to another channel who's covering the same thing. That's kind of a weird thing to do.
But in terms of what you're asking for in that lawsuit is money, correct?
Yes.
Okay. And you believe that a criminal conviction of Dr. Parker would help in that case, correct?
I don't have any opinion about that or anything to say about that.
Okay. After January 6th, you requested that your daughter be transferred to a different school, correct?
Yes,
And that request was refused by Newport News Public Schools, correct?
it was.
Okay.
She
No
didn't
further
get-
questions.
She couldn't transfer her daughter to another school.
Anything further from the Commonwealth?
No, Your Honor.
And the status of the schools?
We'll ask that she be released. And we're also calling Nicholas DeLeon.
Any objection from defense to this witness being released?
She's gonna call, he's going to call the husband too.
Thank you, ma'am, for your testimony. You are released as a witness. You are welcome to remain in the courtroom, or you may leave the building. Thank you. And the next witness's name again, I'm sorry.
Nicholas DeLeon.
Okay, Mr. DeLeon, please.
Now they're going to call the husband. They're going to do it all over again. Kraft Haskell says, can you explain the discussions you just mentioned? Yes, settlement discussions among the civil attorneys about settling the civil case, which are not supposed to really be talked about, but I guess that's what she was referring to when he said, you're trying to get money, right? And she's like, well, there's been some discussions. So I think I don't know if there's been like an offer in the civil case or not. It's something they're not really supposed to talk about. Let's see what's happening here.
Next witness, because I believe it's cumulative. I don't
Cumulative, he's saying.
be able to testify to anything other than his.
I don't know who they are. So, okay, tell me why it's cumulative.
Husband Walker.
Mother and father
Of the same child.
Okay, it's just one witness. I'll allow. I mean, are you bringing out 5 relatives for the same child?
Absolutely not. No, absolutely not.
Why did the mother and father both need to testify for the same child just to show that the child had some issues and went to counseling after being in the class with the shooting? It is cumulative. He's right. It's also prejudicial because now they're going to parade all of these parents up there whose children are having to go to counseling because of what happened here. We're getting a little far afield of the alleged crime here, right? The defendant, whether you think that she's criminally guilty or not, is entitled to a fair trial. And if you start bringing up all of this other stuff to make them feel sympathy for these poor parents, it's prejudicial to the defendant, right? I don't know. Again, same child. Like if they had, okay, if you got to show 8 counts of child endangerment and you got 8 parents that are going to come in and say their kids needed some counseling, okay, maybe we've lost the plot. Thank you. That's what I was looking for. We've lost the plot. Oh, is he going to say that they got divorced as a result of it? Again, this sounds like a them problem. Okay. That's not the defendant's problem, but I don't know. Let's hear. Doesn't matter. It's still the same child victim, right? Even if they're divorced, it doesn't matter. I don't care. If the prosecution is going to say, and they did say this in their opening, the victim here is not Abby Zwerner, the teacher who got shot. The victims here are the children in the classroom. It's still the same child. It doesn't matter if it's a different parent in there. You know what I'm saying? Know what I'm saying?
Mr. DeLeon, please.
She's going to allow it. And now we can fast forward. These smoked out windows here in Newport News, Virginia. I'm imagining this is what I thought it was, like a foggy day outside, and we're waterfront here. I was picturing like a nice ocean view, but I don't think that's what it is. I think they're just, I don't know, maybe cabinetry or smoked out windows. I'm not quite sure.
The testimony you're about to give is the truth, whole truth, and nothing but the truth.
Yes. So please take the witness in, watch your step. Chair and microphone are adjustable. You may proceed.
Good afternoon, sir. Would you please tell us your name?
Nicholas DeLeon.
Mr. DeLeon, just a reminder that we're not using the names of any children at all, including your own. But do you have a daughter?
I do.
And what are her initials?
SD.
And where did SD attend school?
Richneck Elementary.
Okay. And are as of January 3rd, 2023, were you, let me ask the question like this. Who is SD's mom?
Megan DeLeon.
Thank you. Between the time of January 6, 2023, before and after, were there any changes that you noticed in your daughter SD after that hadn't been there before?
Yes.
Could you just describe what you personally noticed or observed, but not anything that she said to you?
I noticed that she was anxious, depressed, very not like herself, as in being quiet, distant, couldn't sleep.
How long did that persist?
quite some time.
Okay.
Months.
Okay. Did you and her mom seek any sort of treatment for her?
Yes, counseling and sort of counseling.
Has it helped?
I think it's hard to say at this point. She's still going through counseling.
Objection. Objection.
It's been up and down, I think, with her.
All right.
And that is terrible. No child should ever have to witness a shooting in their school ever. It is terrible. It is horrible. I can't even imagine. My heart goes out to these families, these parents, and everything. But again, we're losing the plot. He just said it only happened for a couple of months. That's not going to be good for a civil case.
And just to confirm, whose class was SD in? And was that at Richneck Elementary?
It was.
All right. Thank you. I don't have any other questions for you. Please answer any from defense counsel.
Everybody's whispering, I know. Is that Newport News? Does everyone in Newport News speak in a whisper?
Good afternoon, Mr. DeLeon.
Except for him.
All right. You mentioned your daughter, SD. You don't have any knowledge of whether SD was in the classroom when Ms. Zwerner was shot, do you?
I was not there in person, but that is her classroom.
I understand. But you don't have any idea whether she was actually in the classroom, correct?
From what I understand, that she was in the classroom.
And what are you basing your understanding? Is that from somebody told you?
Again, I was not there.
Okay.
I can't verify that. But
So you can't verify that. I'm not asking you to tell me what you were told. That's hearsay. Okay. Now, you are aware that your wife, or I don't know the status of your relationship, but Megan DeLeon has filed a lawsuit on behalf of your daughter in this courtroom, correct? I mean, this courthouse, correct?
Yes.
Okay. And that you're aware that Dr. Parker is a named defendant in that lawsuit, correct?
Correct.
Okay. And you're aware that money damages from Dr. Parker are being sought in that lawsuit, correct?
Correct.
Okay. And so you have a financial interest in a criminal conviction of Dr. Parker, correct?
I don't. This on behalf of my daughter.
Oh, so you believe your daughter has a financial interest in the conviction of Dr. Parker?
Today, that's a separate case.
Just answer my question.
Separate suit.
Answer my question. Do you believe that your daughter has a financial interest in the criminal conviction of Dr. Parker?
Today, I don't believe so, no.
Do you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit?
Objection asked and answered. He said no.
No, it has not been asked and answered, Your Honor. I asked a different question.
All right, I'm gonna take it back because he jumped up like a, what do you call that thing? Oh, like a Jack in the Box. Remember the Jack in the Box? You would turn the and then he would pop up. He was like a little Jack in the Box right there. We need a Jack in the Box emoji. Good grief. And the other thing I was thinking of was the snake in the can. Remember, you just open the can and the big snake would pop out. There's nothing funny about this case at all. But if we don't laugh once in a while, we're going to cry. Yes. All right, Mitchell, you get a highlight. Jack in the Box, Esquire, all in caps. The ESQ, all in caps. If you know, you know. Jack in the Box, Esquire. Okay, here we go.
Question. Oh, so you believe your daughter has a financial interest in the conviction of Dr. Parker?
Today, that's a separate case.
Just answer my question.
Separate suit.
Answer my question. Do you believe that your daughter has a financial interest in the criminal conviction of Dr. Parker?
Today, I don't believe so, no.
Do you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit?
Objection asked and answered. He said no.
No, it has not been asked and answered, Your Honor. I asked a different question.
Well, it's a different question, and I think you already answered it. Are you asking this answer to be struck?
Yes, it's irrelevant and duplicate.
Overruled, and your answer was no, sir. If I heard you correctly.
Correct.
Okay, thank you.
No further.
Questions?
No further questions, Your Honor.
Any redirect
No, Your Honor.
and status of this witness?
I would ask that he be released.
Whack-a-mole.
Any objection? Okay, Thank you, sir. You excuse me, duties as a witness. You may stay in the courtroom or leave as you see fit. Next witness.
Commonwealth will call Tanisha Richardson.
Whack-a-mole. When you bop them. We sometimes have to play Whack-a-Troll in here. The mods are like playing Whack-a-Troll on the daily, but not so much during this trial, right? This is a very very small crowd for us. It's very intimate here. We're not even up to 2,500 viewers on this trial. I guess there's not a lot of public interest in this, but I think it's public. I think it's an interesting case, and I hope you guys do too. And the trolls are really not out so much on this one. But the mods here do the Lord's work. And I couldn't do it without them.
And watch your step and your chair and microphone are adjusted.
Good afternoon. Would you please tell us your name?
Good afternoon. My name is Tanisha Richardson.
Ms. Richardson, do you have a child?
I do.
And in January of 2023, was your child in school?
Yes.
What are your child's initials?
KS.
All right. And just as a reminder, we're only using initials, not names today. Where was your KS in school?
He was in his classroom. He was in first grade in Ms. Zwerner's class at Richneck Elementary.
All right. And did there come a time earlier than normal on January 6, 2023, when you had to go to the school, Richneck, to pick up KS?
Yes. I received notice that there was a community post on social media that there was a heavy police presence at the school.
Okay, let me stop you there. Let me, you're okay. Just let me ask you questions and I'll walk you through it, okay? So after you saw what you saw online, did you go to the school?
I did.
Were you eventually reunited with KS?
Yes.
Could you describe, without telling us anything that he said, could you describe his demeanor, how he appeared to you when you first saw him?
He was very tired. He was cold. And he was ready to get home. He was just really exhausted from the day.
Yeah. Did you notice any changes in his behavior after January 6th of 2023 as opposed to before?
Yes.
I want you to just describe what you were able to notice as his parent that changed after January 6th, 2023.
Oh, sorry.
It's okay, I understand.
And the news is directed to they'll believe that, so it's not going to go out to the press. I just wanted to assure you, we will catch it.
Thank you. I'm sorry.
Wait, what just happened? I got distracted by the troll. Hold on.
Yes.
I want you to just describe what you were able to notice as his parent that changed after January 6th, 2023.
Oh, sorry.
It's okay, I understand.
And the news is directed to they'll believe that, so it's not going to go out to the press.
I think she said his name is what I think happened. Hold on.
Headaches, school avoidance, just a general.
And they did bleep it because they're on a half an hour delay, just in case something like that happened. Just in case.
Anxiousness, just extreme fear, as well as hypervigilance.
When you say school avoidance, can you kind of describe to me what that means?
I can.
He was literally afraid to return to school.
How long was he afraid to go to school?
I would say until at least the end of the school year of that year.
Okay. Did you seek a type of treatment for KS?
I did.
Okay. What did you seek?
He actually had a psychologist initially, and then he also attended CBT therapy with a counselor weekly.
And how long did that go on, and is it still going on?
lasted about 1.5 to 2 years, and we've stopped it since then because his therapist went to a new practice.
Okay. Do you think that it has helped chaos?
It has helped.
Good. Thank you. I don't have anything further for you. Thanks.
Good afternoon, Ms. Richardson.
Good afternoon.
You currently have a civil lawsuit pending in this courthouse, correct? Regarding the incidents of January 6, 2023?
Yes.
Okay. And you've also, in that lawsuit, you've named Dr. Parker as a defendant, correct?
Unfortunately, I'm not. I don't feel comfortable discussing the details of that in this arena.
Your Honor, I'm just going to review my prior objection. I understand the court's rule on the issue.
Wonder if they're all represented by the same civil attorney, and that civil attorney said, if you're asked during the trial any details of your lawsuit, just tell them that you're not comfortable discussing it, because they all have the same answer, right?
So the court will overrule the objection. It's appropriate to be discussed. So if you could please answer the question. Repeat your question, Mr. T.
Thank you, Your Honor. In the lawsuit that you currently have filed in Newport News Circuit Court, you have named Dr. Ebony Parker as a defendant, correct?
Correct.
And in that lawsuit, you are suing Dr. Parker and the other defendants for money, correct?
Yes.
Okay. And you and several other parents share the same attorney, correct?
That's correct.
I was right.
And you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit, don't you?
No.
Okay.
She said no.
Have you made any other demands of Dr. Parker or the other defendants?
No.
Okay.
Demands,
Do
meaning
you know
money
when
demand.
that lawsuit is scheduled to go to trial?
No.
Okay. When was that lawsuit filed?
I believe it was February of 2023.
February 2023?
I don't know.
Okay. Okay. No further questions, Your Honor.
Well, prosecutor's not done.
Just a couple of more questions for you. As a result of the incident on January 6, 2023, and all of the things that your son has done, have you spent money?
Yes.
I'm going to object to go beyond cross-examination.
I think that's right on point with the cross-examination. He asked if she was seeking money in a lawsuit, and I think it's very fair for me to ask if she also spent money as a result of the incident. Did you spend money as a result of what happened to your son?
Yes.
All right, thank you. I don't have anything further.
Anything further for this witness?
No, Your Honor,
I'm sure they're not just suing for the reimbursement of their co-pays. Remember, Abby Zwerner was awarded $10 million by a jury in Newport News against Dr. Parker.
that should be released.
Any objection to her being released?
No, Your Honor.
Thank you, ma'am. You are excused as a witness. You may stay in the courtroom or leave the building. Next witness.
The next witness will be Ramon Gonzalez. Your Honor, I anticipate having this witness plus one more.
I told you they're going to parade 8 parents up there because they got to show 8 counts of child endangerment. Please find the mic, sir. Please, please, please. Or just project. My finger is getting tired on this button.
Good afternoon, sir. Would you please tell us your name?
My name is Ramon Sebastian Gonzalez Hernandez.
Is he good?
Thank you. And I would like to...
Hold on. Hold on. What is wrong with them suing? Nothing. There's nothing wrong with them suing at all. I think they absolutely should sue. I think they should sue, absolutely. But I do not think that these questions have a place in this criminal trial. These questions are better suited for civil court. I'm a plaintiff's lawyer. Don't get me wrong. I think everybody should sue everybody, okay? I think that this guy, he's loud enough that we can hear him, right? It's a choice. You're right. It is a choice. It's a choice, not Jay West. There's nothing wrong with that. What I'm saying is when you start parading parent after parent after parent after parent up here, talking about how their children were harmed, which my heart goes out to them. Is it more prejudicial to the defendant? Because the jury might be like, oh, well, somebody's got to pay. Somebody's going to have to pay for what happened. Somebody has to go to jail for this. Are they going to know that the mother did up to 4 years in jail? Because if they don't, I think that's highly prejudicial because the jury may be back there thinking, listen, somebody's got to go to jail for this. And it must, since this defendant is the only one sitting in the chair, she should go to jail. But the mother did go to jail. So I think they need to know about that. All right, let's go back. I was watching Jeopardy the other night. Quick side note. Remember Adam Lally with his baby shark hairdo? Baby shark, do. Baby shark was an answer to one of the Jeopardy questions the other day. All right, moving on.
We're not speaking to, would you please tell us your name?
My name is Ramon Sebastian Gonzalez Hernandez.
Thank you. And I would like to just a quick reminder that during this trial, we're not speaking the names of any children at all and only using initials. Do you have a child?
Yes, sir.
What are your child's initials?
GG.
And did your child attend school? Did GG attend school in January of 2023?
Yes, he did.
What grade was he in?
First grade.
And where did he attend school?
At Richneck Elementary.
Do you know who his homeroom main teacher was?
Yes, I do.
Who was it?
Abby Zwerner.
All right. Did there come a time on January 6, 2023, when you had to unexpectedly go to Gigi's school, Richneck?
Yes, I did.
And when you arrived at the school, did you immediately see Gigi?
No, I did not.
Okay, stay with me and let me walk you through it. Okay. So eventually, did you see Gigi at the school?
Eventually, yes.
And when you saw him, could you please just describe, without saying anything that he said, describe his demeanor, how he was acting, and how he appeared to you?
He walked out of the school with a look on his face like he had seen a ghost, pretty much. I was crying myself. He wasn't crying, but he was in shock, like complete, utter shock.
Okay. And from that moment forward, did you notice any changes in behavior from Gigi as opposed to before January 6th?
Yes, at home he was a little bit snappier with his brother. Whenever they would argue, he would be a little bit more aggressive. Other things like he had to sleep with him every night because he just felt more comfortable. Bedwetting almost every night. Things like that.
And were all of those things new after January 6th?
Yeah, that was new after that. Okay. He loved to sleep by himself before that.
And did your family seek some help and treatment for Gigi?
Yes, we did. Right after the incident, we went, I want to say 2 or 3 times. Mm-hmm. And he was very adamant that he didn't want to go because we wanted to keep his life as normal as possible after the incident. So wasn't trying to force it down his throat.
You know? Okay. And has he, at any time between then and now, has he sought any treatment beyond that?
Not since then, no.
Okay. And how long did, any concerning behaviors that you've described last?
It still lasts to this day. Getting better gradually, I think. But still, he has a lot of mood swings, and the whole big wedding thing that happens. Yeah, it's very rough.
Did your family incur any expenses as a result of this?
As far as with the
For Gigi, as a result of this, did you have some expenses?
no, not with the therapy that was provided, so we didn't have any expenses as far as that.
Okay, thank you. I don't have anything else for you.
Thanks.
Understandable that he would, that wants the child to live a normal life, only go to therapy 2 or 3 times. He just tanked a civil case. Thanks, prosecutor. But he did say the child has ongoing problems, and it's been a little over 3 years since this happened. I don't know that any child would ever get over the PTSD of seeing in real time a child pull out a weapon and shoot his teacher. It could be lifelong effects. But all of this testimony, if they testify differently in whatever civil case they have, it can be used against them. Very sad. Very, very, very sad.
Good afternoon, Mr. Gonzalez.
Good afternoon.
You weren't at Richneck Elementary School on January 6, 2023, correct?
I picked up my GG that day.
But you were not inside of the building, correct?
No.
You learned about the shooting after the fact,
Mm-hmm.
of course. Did the school contact you at the time of the shooting?
No. I had a friend of mine, a coworker, contacted me and told me about the shooting.
But did the school ever contact you?
Afterwards, yeah.
How long after?
I would say an hour and a half.
Okay. Your child was not in the classroom where the shooting occurred, correct?
Yes, he was.
Okay. And you're saying he was a student in that classroom?
He was a student in Ms. Zwerner's classroom.
Okay. And you filed a civil lawsuit in this case, stemming from the events of January 6, 2023?
I don't feel comfortable talking about that.
Your Honor, I'd like to note my continuing objection.
Okay, so noted. Sir, you need to answer.
Each witness has said the same exact thing. I don't feel comfortable talking about my civil lawsuit. They were totally prepped by their civil attorney.
Question, please.
Yes.
Okay. And you have named Dr. Parker as a defendant, correct?
Yes.
All right. You're seeking money damages from Dr. Parker in that case, correct?
Yes.
Okay. And a criminal conviction of Dr. Parker would be helpful to that lawsuit, wouldn't it?
I'm not sure about that.
Okay. No further questions, Your Honor.
Your Honor, I ask that he be released, please.
Any objection from the sentence?
No objection.
Okay, thank you, sir, for your testimony. You may step down, and by release, you can leave the courtroom or stay in the courtroom, but you're no longer needed as a witness. Thank you.
At Ford Dredd said, this is the worst school incident to try and make an example out of. There's some school incidents where I can understand if they did, but this here is beyond reaching. Let me know what you think about that. This could have been so much worse. And thank God it wasn't. Thank God Abby Zwerner survived. She had 5 surgeries. I don't know the extent of her injuries, but she's alive. So many school shootings that happen, seems to be they happen a couple times a week, where so many more people are killed and injured, and it's horrific. I agree. I happen to agree with you. I just don't think that this was the case to test this new journey of prosecuting criminally school administrators. My personal opinion. I don't know which way this is going to go. I would never, ever, ever bet on a jury, and I'm certainly not going to bet on this one either. But what we're focused on is the prosecution proving its case beyond a reasonable doubt that Dr. Ebony Parker's failure to act rises to the level of 8 counts of felony child endangerment. There we go.
And the Commonwealth will call Sarah Gonzalez.
Also the wife
Your Honor,
also.
Again, we're gonna object. This is a duplicative witness. That adds nothing to the case. This is the last other parent of the child, the second parent of the child.
So noted, overruled. You can bring out the witness. Thank you.
I disagree. Larry says, yeah, but it could
This is the
result
last
in a
witness,
huge
Tom.
wake-up call. Okay, I mean, point taken, but should the Commonwealth of Virginia be spending however much money they're spending on this criminal trial for a wake-up call? I mean, are they here to wake people up, or are they here to, spend the county's money responsibly? I don't know. I don't know. I'm very conflicted.
I'm not going to trying to line up.
I understand. I will take a moment to double check that this is
Understood.
that we're
Understood.
into. Yes,
This is the last witness.
this is the last witness, Your Honor.
I'm not going to trying to line up.
I understand. I will take a moment to double check
Understood.
that we're
Understood.
into.
What now?
Yes.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Thank you, ma'am. Please take the witness stand, watch your step, chair and microphone are adjustable.
Good afternoon. Would you please tell us your name?
Sarah Gonzalez.
Ms. Gonzalez, do you have a child?
Yes.
Remember that we're only using initials or referring to your child as my child. What are the initials of your child?
G.
And who is Gigi's father?
Ramon Gonzalez.
Okay. I want to take you to January 6th of 2023. On that afternoon, where were you when you first see Gigi?
After the incident, when I saw him.
When you first see him on January 6th, 2023.
At our home.
Okay. When you first see him at your home, is it still on January 6th?
Yes.
And do you know roughly what time it would be?
It was in the evening.
Okay. Could you just describe for me, without telling me anything he said, but could you describe his demeanor, how he appeared, and how he was acting toward you?
When my husband came home with him in the car and he came out, he was like he had seen a ghost, kind of. He was white, and his eyes were very big, and he was just kind of, I've never seen that look before, but he was kind of like he was in shock.
Okay. Were ongoing after that day, were there any issues with Gigi that you noticed that were different than prior to the January 6th?
Yes.
Describe those to us.
He couldn't sleep by himself anymore. He had to sleep with someone else, and to this day he still sleeps with his older brother, and he just refuses to sleep by himself. And he frequent bedwetting started occurring after that, and frequent bouts of losing his temper, and just becoming angry, things like that.
Yeah. And for how long did those things last?
For a long time. It's improved, I would say, but it still occurs. It was very frequent after that for quite some time.
Were there any other major life adjustments that your family had to make as a result of what Gigi went through?
Just trying to internalize it and, move forward. And, it's the impact on my husband and myself. It was pretty significant and caused a lot of anxiety and,
Just elements to impact on
I agree, Judge. We won't go down that road.
We won't consider that just to the child. Next question.
I don't have any more questions. Thank you so much. Please answer any questions from defense counsel.
This is Cross.
Good afternoon, Ms. Gonzalez. You have filed a civil lawsuit in this courthouse as well regarding the events of January 6, 2023, correct?
I don't feel comfortable speaking on that as it's relevant to my.
Same answer.
Objection noted, and you do need to answer. Please repeat the question.
You have filed a civil lawsuit related to the events of January 6, 2023 in this circuit court, correct? And you have named Dr. Parker as a defendant in that matter, correct? And you're seeking money damages from Dr. Parker and the other defendants, correct?
Am I still liable to speak on this?
Yes, ma'am, you need to answer the question.
Yes.
Okay. In fact, you and several other parents are represented by the same attorney, right?
Objection, Judge, that is not who they are represented by in the civil suit. It's not in any way relevant.
I think it's relevant. We have a series of witnesses, all filing civil lawsuits, and represented by the same attorney. I think it's totally relevant to these proceedings.
And I object to counsel saying they're all represented by the same attorney. He's not testifying.
Correct, that's not evidence.
Well,
I'm going to sustain the objection. Who their attorneys are, it is not relevant. But, that there's a lawsuit is relevant for cross-examination. Next question.
And a criminal conviction of Dr. Parker would help in that lawsuit, right? What was your answer? I'm sorry?
Yes.
Okay.
Yes.
So you have a financial interest in these proceedings, right? I'm sorry?
I imagine that's part of it, yes.
Okay. No further questions.
She was the only one who answered it honestly.
That's all for this witness, Judge, and I would ask that she be released.
Any objection? Okay, ma'am. So you are excused from being the witness. Thank you for your testimony. That means you can stay in the court or you may leave. And watch your step as you step in.
Judge, may I have just less than 1 minute?
Yes, sir.
To confirm.
You can step down. Thank you, ma'am. And the sheriff will direct you.
Sheriff.
Your Honor, the Commonwealth Rests.
Commonwealth Rests. Wow.
Your Honor, we will have motions to strike, but I do want to take time with my co-counsel and the defendant to make sure that we have every base fully covered. So I'm going to ask the court to consider going in recess for the remainder of the day, and then we'll come back first thing tomorrow and make our motions and present any evidence on behalf of the defense.
Wow.
Commonwealth, in terms of proceeding in that chronological fashion, your position.
I'll submit to the court.
Okay. All right, so to the jury, we take up the motion to strike outside the presence of the jury. It's 4:25 today, and they're asking to do so in the morning. So I will kindly ask you all to report back and would you like the jurors to report? What time is counsel prepared to do motions to strike in the morning? 8:30 or 9? And I'll give that an hour and ask the jurors to report an hour after that.
Any time is fine.
Understood.
Your Honor, if we can be prepared for 9 o'clock tomorrow morning.
Say that starting 9?
Yes, 4 motions to strike. Yes.
4 motions, and ask the jurors to report at 10.
Yes, ma'am.
Okay. All right, so thank you again for day 3. You have the same cautionary instruction. Please do not discuss the case, research the case, allow others to discuss it and or share their discussions, their thoughts, and opinions with you. I know that's hard. I know this is a high-profile case, but that is important to the integrity of the process. And please report at 10 a.m. Are there any issues, anything I can assist you all with? Okay, and last, please, I will not be able to court to provide lunch tomorrow. my assistant's off. And she's the one who, while we're here, actually goes to pick it up. So bring your lunch or be prepared to go out to get food tomorrow. All right, thank you very much.
Please rise for the jury. Thank you.
All right. So coming back in the morning, the Commonwealth has rested. Do you think the defense is going to put on a case? We need to chat. But the one thing we're going to watch, we have to watch Miss West's testimony from yesterday now, because that's one of the teachers whose testimony we did not watch yesterday. And that's it. That's all she wrote as far as the Commonwealth. Did they prove beyond a reasonable doubt? Do you think they did enough to prove that Dr. Parker was informed but did nothing? Those of you who watched the civil trial are going to have a very, very different opinion than those of you who only watched the criminal trial. Let's go through some super chats first. EKG says, in our need to do something, blame someone, right these wrongs. Since our leadership and their lobbyists refuse to do anything, we turn on people who are not at fault. Parents, yes. Random school people, no. Thank you for your 10 and your opinions. EKG also says, I like this judge. Her reading statutes and allowing talking objections is giving us law tube in real time. Yes, except sometimes she's not correct. Not that I'm always correct either. And all law tubers are not always correct either. But this judge has been wrong, in my opinion, on a couple of things. But, you know, that's why we have trials. And that's why if you ask 5 lawyers for 5 opinions, you'll get 5 different opinions 90% of the time. Overruled sit down says, no, I was not reunited with my child. I left him there. Really? Thanks for your 5. Many people think she was reading the statutes out loud because she's been a judge for, I think, less than a year. Julianne said, it sounds like a money grab. I said it and no regrets in saying it. No regrets, not even one letter. Thanks, Julianne, for your 5. Craft Tassical says, Melanie, just wanted to say thanks for showing this case and for your patience with the sound and our complaints. You're a star and we love you. I'll allow it. Thank you. Sometimes I get cranky, but you know I'm not really taking it out on you. Sometimes I just get cranky because I get cranky. Marcy's Lies is here and says, for 20 months. Thank you for being here for 20 months. This prosecutor would never hold it up against AJ. Well, I mean, who can? Not many can. And Monge, call me Murdoch, said, this guy to me sounds like overreaching. In my opinion, I reserve the right to change my mind. As always, listen, I change my mind all the time. I wasn't sure where I stood on this. And I want to listen to Miss West's testimony before I even make that decision because I didn't hear it yet. Thank you for 5. Charlie says, this is X plus Y equals rainbows. Thank you for tuning in from down under. Andrew with an I says, as always, I appreciate the legal commentary. As a layperson, I am admittedly out of my depth with criminal versus civil, and I'm 100% bringing my bias as a mom into this. This one is tough. I know, me too. If my children were one of the children in that classroom, I would be very angry, and I would want someone to have to pay. But like I said, the mom has done 4 years in prison. Is that not enough? Do we now need to go down the chain of everyone who worked at the school who didn't do something? And if we do that, why is it only the assistant principal here? I mean, I think that when they showed the portions of her interviews that they showed from the post-shooting investigation by Human Resources, that watching her and seeing her get very emotional 3 days after the shooting, I think it humanized her. What do you think about that? And I think it helped the defense. Charlie says, how do these people become judges? I don't know, actually, in Virginia, if they're elected or appointed. In New York, we elect our judges, and our judges run for specific court. Criminal attorneys tend to run for judgeships in criminal court. Civil attorneys tend to run for judgeships in civil court. Family attorneys tend to run for family court, to become family court judges, and they don't move around. If you're a civil court judge, that's where you stay. If you're a criminal court judge, that's where you stay. If you're a family court judge, that's where you stay. It's wild to me that in Massachusetts, they're appointed and they move them all around to things that may not be within their expertise. It's crazy. Jordan said, I do think Dr. Parker failed the school that day. Thankfully, the outcome wasn't worse, but I don't think criminal charges are warranted. Thank you. And this is wild to me too. Venus Blue Cupcake is telling us that Judge Lisa Lott was voted back in yesterday. Judge Lisa Lott voted back in. This is why it is so important to vote, especially in off-cycle elections, in elections that are happening in the month of May. In Georgia, the people voted back Judge Lott. She presided over the Edric Foss trial, and she was voted back in. Thank you, Venus Blue Cupcake, because I know you're local to Georgia and new Kelsey Fitzsimmons papers. I have them in my inbox. I haven't read them yet, so I just don't know if I'm going to cover them yet. I'll take a look. Overruled Sit Down says, I'm sorry, but it seems like there was a lot of people that failed this school. Thank you for your 5. If you will indulge me, I would like to watch the teacher's testimony, Miss West, because Miss West had the classroom across the hall from Abby Zwerner's courtroom. Classroom. Oh my God. She testified yesterday on day 1. We didn't get through the entire day 1 yesterday, but Miss West has a lot to say, and I want to know what she has to say, and I think it's important that we listen to it. So if you will indulge me, this video is only about 14 minutes long, and I'll just change the banner, and here we go. Hopefully they've fixed the sound on this, and we'll maybe learn something from Miss West. Let's go.
Good afternoon. Could you please tell us your name?
Jennifer West.
And Ms. West, how are you employed?
I'm a teacher.
Now, I want to take you back to January of 2023. Were you a teacher then as well?
Yes.
What school did you teach at?
Richneck Elementary.
How long have you been a teacher?
23 years.
And what grade did you teach at Richneck back in January 2023?
First grade.
Could you help us understand where, if you know, do you know where Ms. Werner's classroom was?
Across the hall from mine.
Okay. Taking you back to that January 6th date in 2023, on that day, based on, for whatever reason, did you end up observing a student named JT while he was at recess?
Yes.
And where was your class at that time?
Also at recess.
And while you were observing JT, could you describe, just as if it was a movie that we were watching, just the actions that you observed?
He and another.
And I'm sorry for interrupting you, but I need to at this point because I forgot to remind you, we're not using any names of students. You can say a student or you can use initials, but please don't say the names of any students.
He and another student kept going behind the rock wall, and there's a large tree on the playground. They go back there and come back out, and I just was watching their interactions.
Do you know the initials of the other student?
RR.
And do you know the initials of the first? Okay. So describe for us what exactly JT and RR were doing in as much detail as you can remember.
It's hard to remember specific details, but I did write down notes the day of, and I reviewed those before coming.
When you reviewed your notes, did that help you refresh your recollection about what happened?
Yes.
Okay, well, then what happened?
They were staying together, very close together. They kept going behind the rock wall, going behind the tree, kind of being secretive, trying to avoid other people.
Okay. I'll agree that the trying to avoid other people part should be stricken.
So sustain, strike that part, trying to avoid other people. But you can't consider going behind the rock wall. Next question.
Ms. West, when recess ended, did you have a conversation with RR?
After we got back in the building.
Okay. And before I ask you to tell us what RR said, can you just describe his physical demeanor, how he appeared to you?
So I asked him to come speak with me to ask him about what we had observed at recess.
And before you tell us what he said, I just want to know his demeanor, how he appeared.
He was visibly shaken, nervous. I asked him what they had been doing, and he said,
Okay, hold on. Before you tell us what he said, I'll ask judge and counsel if we need to voir dire this witness.
This is all in the presence of the jury.
Just hold on just a moment, okay?
So Ms. West saw at recess the shooter, JT, and his friend, RR. We don't know if RR is a boy or a girl. They kept hiding behind the rock wall and looked a little suspicious. She was just, she's like nosy. She's a curtain twitcher. You can just tell. She's like, I want to know what they were doing behind that rock wall and why they kept hiding back there. And good for her. She's on high alert. She also was a first grade teacher right across the hall from Ms. Werner's classroom.
Your Honor, I think based on previous rulings that the court will allow her to testify, but we're objecting for the record that these statements that she may have heard from RR are hearsay.
Okay, you're continuing your session is noted. Thank you. Our game proceeds, Mr. Jacobs.
Tell us what RR reported to you.
he first said he couldn't tell me, and I reassured him that he could. And he said, I can't. He said that he would hurt us, that he would blow us up. He was referring to JT at the time.
He said that he would hurt us, that he would blow us up if I tell you anything. That's what RR said to Miss West.
And then he said that JT had a gun. And at that time, I asked him what it looked like to kind of confirm whether it was real or not. And he said that he saw the bullets. And I said, well, what color? And he said they were bullet colored. And at that point, he was crying. And I had RR come into my classroom.
And
this was right after recess. Maybe, it seems like, JT showed the gun to RR. She's suspicious. She's questioning RR. She learns that he had a gun and he saw the bullets. This is not the assistant principal. Remember, this is another first grade teacher.
And once RR was in your classroom, did you place a call?
I did. I called the front office
And what was the purpose of that call?
to report what RR had told me.
Okay. And who answered the phone?
Mr. Sims, our music teacher.
Okay. Thank you. If you could give me just a moment.
The music teacher. She called the front office to report it. But again, the teachers have the authority and the ability to remove the child from the classroom. None of them did it. And I'm not saying I think any of them should be criminally charged. The mother was criminally charged. That's who I feel is responsible here. This child should never have had possession of a weapon, ever. It was testing day, right? It was on testing day.
I want to now fast forward a little bit and jump forward. Later in the day, did some students come running into your classroom?
Yes, I think it was just before 2 o'clock.
Hold on. Can you back up from that for a moment and just walk us through what happened that you observed or heard in the moments before students came into your classroom?
I heard a gunshot and I immediately knew what it was. And I went to my classroom door, opened it, and Abby's students came running out.
And she should not have to relive this. My heart breaks for every single person in the school that day, every single one of them, and the parents, everybody. She's the one who was told that the kid had a gun, that this boy told her he saw the bullet. She called the front office and reported it. And then he fast forwards to after the shooting. Okay. Yeah, I guess she had a door. I guess she had a door in her classroom. Take that back a second.
A gunshot. And I
Heard in the moments before students came into your classroom?
I heard a gunshot and I immediately knew what it was. And I went to my classroom door, opened it, and Abby's students came running out, and I ushered them into my classroom. and I could see that Abby was standing. She was just exited her room, and I could tell that her hand was bloody and there was blood on the floor. Once the last student that was on their way out came out, I shut my door and proceeded to lock down, turn off the lights, and settle the students.
In as much detail as you remember, can you describe the behaviors that you observed, the demeanor that you observed of the students as they came in?
They were terrified, many of them crying. RR was situated behind me. I was sitting on the floor with the students around me, and he kept repeating, "I told you. I tried to keep you safe. I told you." And I just kept reassuring. There were a few students who were trying to tell me what happened, but I didn't want my class that didn't witness it to hear all of the details. And I just kept reassuring them that we were okay.
Were some of the children were crying?
Yes.
All right. Ms. West, thank you for your testimony. I don't have any more questions for you right now. Please answer any questions from defense counsel.
Yes, sir.
All right. Good afternoon. How are you?
I'm okay.
I understand that you're upset, and that's reasonable. Whose student was RR? Was that your student?
No, that was Abby's student.
Okay. Did you have a relationship with RR? Or?
I try to have relationships with as many students as I can. So yes.
Okay. And when you had contact with RR after recess, could you tell us again what prompted that?
What I was observing at recess was RR and JT kept going behind the rock wall behind the tree. Okay. And I asked him to come tell me what was going on at recess.
Okay. Did you, during that recess time, did you believe that JT possessed a firearm?
I was not convinced until I spoke with RR.
Okay. So while the children were out on the recess, you did not feel a sense of danger or imminent harm to the children. Is that correct?
I don't really know how to answer that. We were kind of observing. I had been told that Dr. Parker had been made aware.
All right, I'm going to object to that statement.
Objection to that. If this is a question that he asked, and moreover, just a moment ago, he asked the question, what prompted her to talk to RR? And she's entitled to answer the questions that he asks.
And so, again, we don't know what the answer is going to be, and it doesn't make it necessarily admissible. But that is hearsay that she was told. So at this point, we cannot consider that unless it comes in under another exception.
Thank you, Ron.
Next question.
Okay. So based on your observations of RR, you weren't convinced that he possessed a firearm. Is that correct?
I was convinced they were hiding something.
Okay. Had you believed that he possessed a firearm, would you have taken steps to exclude him from the presence of the other students?
I'm not sure how to answer that.
All right, well, I'll ask it a different way. If a student possesses a firearm, should you take steps to exclude them from the presence of other students?
That's the administrator or security's job.
So as a teacher, you don't feel like if a child possesses a gun, you should take steps to ensure the safety of those classrooms?
If a child possesses a gun, I rely on the people whose job is to check the child. And
I'm not talking about checking. I'm talking about protecting the other students.
I understand that, but it's also to be protection of the other students by not exacerbating the situation.
Okay, so you're saying if a student possesses a firearm, it's better to leave that student in the presence of other students so the students won't become exasperated? Is that what you're saying?
No, I'm saying I would contact security and administration, and they will handle the student.
Okay, so you're essentially saying it's not your responsibility to protect the students.
That's not what I'm saying.
What you're saying is you're going to rely on somebody else to protect the students. Is that correct?
Sure.
Okay. All right. Did you have any conversations with Dr. Parker prior to the shooting?
Yes.
Okay.
It was, I don't know that I would call it a conversation. It was an interaction that lasted about 5 seconds.
Okay. Did you tell her that you believe that JT possessed a firearm?
No, that was prior to my conversation with RR.
Okay. Did you?
So she did not tell Dr. Parker that she thought the child had a gun. She called it into the office and the music teacher answered the phone. And I don't think we've heard from the music teacher. Have we heard from the music teacher? Because I must have been absent that day.
Possess any means to communicate with the office while you were out on the playground?
Based on my notes, there was a walkie-talkie. I personally don't remember having it in my possession at recess. I even can't remember what the protocol was that year because they changed so much. Sometimes there's one walkie-talkie per grade level. At this time, every teacher has a walkie-talkie, but I do not recall specifics of the walkie-talkie that day.
So you don't remember if you had one or if Ms. Zwerner had one? Or,
I do not know.
Okay. Do you remember if anybody, you or her, tried to make an attempt to contact the office while out on the playground?
No, I did not.
Okay, that's fine. So you didn't observe Dr. Parker's behavior or interactions anytime?
Personally, no.
Can I have a moment, Your Honor?
Yes, sir.
She was just doing what she was supposed to do, I guess, is in her mind. Does that change your opinion from where you were before the Commonwealth Rested, since we did not get to watch that yesterday? Does it change your opinion? Larry says, Mel, thanks for all the insightful comments and helping me get a better understanding of all different aspects of law. I try to get you to look at, well, at least in this trial anyway. Sometimes I have a set opinion because of all of my pretrial research. And so in this case, I don't know where I'm going to land on it. Could you find this defendant guilty of 8 counts of child endangerment? I guess we're going to have to wait for the judge to read the law, but thank you to the virtual juror for sending me this article from CNN, which indicated that, and we like receipts here, so that is why I asked for this, about the mom being released. Let's take a look here at for a moment. This is an article from CNN from 2 days ago, May 18th. Thank you so much, Larry, for your 5. I appreciate you so much. So here's what had happened. Parker was charged in 2024 with 8 counts of felony child abuse and disregard for life, 1 for each bullet in the gun the student used. Prosecutors allege she committed a willful act or omission in the care of such students in a manner so gross, wanton, and culpable as to show a reckless disregard for human life. She has pleaded not guilty to the charges. Each count is considered a Class 6 felony, punishable by up to 5 years in prison. Trial is expected to last about 3 days. Today's day 2. The Commonwealth has rested. Virginia is also a Commonwealth. Here it is. Parker's criminal trial is one of a number of cases in recent years that have tested the limits of who is responsible when a juvenile carries out a school shooting. Parents in Michigan and Georgia have been convicted of serious charges, but Parker appears to be the first educator to face trial in such circumstances. In November, a civil jury awarded Zwerner $10 million in a lawsuit alleging Parker failed to act on concerns that the student had brought a gun to school. Parker has filed an appeal. Notably, Zwerner testified in the trial about the moment of the shooting and its impact on her life. Parker did not testify in her own defense. And so I don't think she should have. Here it is. The boy's mother, Deja Taylor, pleaded guilty to a state charge of felony child neglect and was sentenced to 2 years in prison in 2023, as well as a 21-month sentence on related federal charges. She was released from state custody to community supervision on May 13th, according to the Virginia Department of Corrections. So that's very interesting to me that she was released from custody approximately 1 week ago. Today is May 20th. I wonder, and I'm not an expert on educational law and IEPs and special programs for children in the state of Virginia, but I wonder if the mother's got a potential for a civil lawsuit against the school. I don't know. And that's why they're hell-bent on trying to convict Ebony Parker. Think about that. Kelly says there's a lot of people who had a reasonable belief he had a pew-pew and did nothing but pass it on with no follow-up. To me, all or none should be on trial. And that's what Kelly says from all the way across the pond. I have no idea what this means either, but somebody told me this the other day about a different video that I did. Oh, hey, it's Allie says, hey, Mel, this video is being featured on YouTube. I am not sure what that means, but it sounds cool. She says, I have no idea what that means either. If anybody knows what that means, let me know that this video is being featured on YouTube. Hopefully more people will see it because there has not been a lot of people watching today as many as watch our regular trials. So maybe a lot of people don't know about it. Devin said earlier, all I can say is watch the civil trial first, then you'll have a way better take on this criminal trial and Ebony Parker's non-actions. Well, Devin, the Commonwealth case is over. And I guess the people who watch the civil trial have a much better understanding of what Ebony Parker didn't do. But like I said earlier, I think the portion of the video that they played of her giving her interview 3 days after the shooting humanized her. And I don't know that this jury is going to find, it says featured on the thumbnail. I didn't put it there. All right, rock on. Woohoo, cupcakes. This is a hot button issue. Let's compare this now with other cases that we've been talking about. I just got to pull up my notes. And let's talk about the differences between this case and the Crumbly case in Michigan and the Colt case in Georgia. So Devin, the jury's not going to hear anything about that. The question here is, do you think they proved their criminal case? For example, let's talk about the other cases. Ethan Crumbly. Ethan Crumbly was 15 years old when he shot and killed 4 students and injured 7 other students at Oxford High School in Michigan. Both of his parents were charged with involuntary manslaughter for ignoring their son's deteriorating mental state, neglecting red flags, and purchasing him the semi-automatic handgun used in the shooting. This was the first time parents have ever been charged for a minor school shooter's actions. Both James and Jennifer Crumbly were convicted, and they are both serving 10 to 15 years in prison after becoming the first parents to ever been convicted of involuntary manslaughter in connection with a mass school shooting on behalf of their child. Brittany's pointing out Ethan Crumbly literally told his parents that he needed help like 10 times. Correct. And also, they gave him this firearm as a present. Remember, this was like a Christmas present. That was very disturbing, but that's different. A lot different than this case. Now, in the Colin Gray case, Colin Gray was the dad. In that case, Colt Gray was 14 years old. That was in Georgia in 2024 at Appalachia High School. Oh, please. Oh, please. The dad in that case, Colin Gray, was charged with second-degree murder, 27 felony counts. He gave his child the AR-15 style rifle also as a Christmas gift. He was convicted in March of 2026, awaiting sentencing in July, facing up to 180 years. Okay, those boys were both, well, Colt Gray was 14, Ethan Crumbley was 15. And then you have a case like the Uvalde case, okay? Uvalde was another school shooting. In that case, the gunman was 18 years old. He legally purchased his own AR-15 style rifles, body armor, hundreds of rounds of ammunition. And in that case, there were no charges filed against the parents because the kid was 18. The target of the investigation and the criminal prosecution was law enforcement for failing to act. I mean, it was similar in that it was a failure to act, and there was no conviction in that case. There was an acquittal. This is the first time. This is the seminal case that a school administrator is being charged. I don't know what's going to happen. I don't think I'd want to be on this jury. How about you? Yeah, Newtown, Connecticut, horrific situation too, but the parents weren't charged. We're talking about third-party liability for someone other than the person who actually committed the acts. That Hoot Mama said, I watched the civil trial and I agree with that verdict. I don't blame the civil suits from the parents. However, I don't think she should be sent to prison for 40 years, right? I mean, I think that's where I'm leaning too. I have no idea what his jury's going to do, but I will see you guys tomorrow. I'll see you tomorrow around 9 a.m. We'll see what time Law and Crime is going to start. They have a half an hour delay, so they may start at 9:30, and if they do, we too will start at 9:30. Something in my house smells good, and it smells like dinner, so go. I haven't eaten all day while I've been on here with you, and I'm really, 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 really hungry. All right. Let me see if there's anybody else here that I need to thank. One moment, please. You guys are emailing me all kinds of other things about other cases, which I cannot look at while I'm on stream, but I will look at when I'm done. Other cases to look at. I appreciate that so much because, you know, I can't find everything all the time. And you guys bring a lot of really interesting cases to my attention, and I appreciate it so much. Okay, so we will see. I'll see you tomorrow. Make sure you have your notifications set so you can come back tomorrow. And I really have no idea what a jury is going to do with this. No idea. Have they met their burden of proof? Will the defense even put on a case? I don't know. It's going to remain to be seen, but we will come back tomorrow around 9:30, I think, is where we're going to land on that. Stay cool, stay kind, stay classy. Thank your moderators. Tip your servers. I love you guys so much. I love my moderators so much too. Stay cool, stay kind, stay classy, all the things. This was yesterday's empowerment card, and it's so good that I want you to hear it again. So we're just going to do this one for today. This was yesterday's empowerment card. Bad vibes don't go with my outfit. Bad vibes don't go with my outfit. Woo, woo. Love it. Love it so much. All right, you guys. I'll see you tomorrow. Peace out, my friends. Bye.